Hey everybody, thanks for being here today. We appreciate joining us. We've got an action-packed day ahead of us. Just as a reminder, we are recording the session today, so if you'd like to watch this again later, you can. I'll do a quick run through on the agenda before we jump into it with Nate and Jesse going first. So if you're local in Stillwater, there is breakfast. I'm in my office because I was exposed to COVID recently, as well as our entire back office. So attorneys are running the meeting today. So if anything goes wrong, you can blame attorneys, which everybody should enjoy doing. Breakfast right now, we're going to start in a minute here with session 1, ad promo enforcement update. That'll be Jesse and Nate. I will then take you through some clinical research contracting best practices. We'll have a break from 10:15 to 10:30. We'll come back at 10:30 and get into regulatory submissions with Amanda, tips and tricks. Tim Phillips will then walk us through how to survive an FDA inspection. Tim was at the FDA for 32 years, so it's well suited to give that presentation. We'll then have a lunch buffet, those of you in person, from 11:45 to 12:30, followed by session 5, privacy and cybersecurity, and that will be Bryn and Paul. At session 6, complaint handling with Theo. Session 7, anti-fraud sunshine update with Amanda and I. And then we will wrap up with a panel discussion, and we have some distinguished guests, Mike Setsky, Sarah Karlgaard, and Frank Piskalich. So 3 general counsels at different companies. So very excited to see that, and Jesse will moderate that panel. And then we'll have a reception at the end of the day, so please enjoy that if you're local. A couple other housekeeping items. I mentioned already the session will be recorded. An email on how to access the recording and slides will be sent subsequent to the meeting. Q&A will take place at the end of each session. Feel free, if you have questions, bring them up. If you're local live, just feel free to interrupt. And if you'd like, put questions in the chat box, please do that. We're going to be monitoring the chat all day, and we'd love to get your questions. If you have panel questions, we have enough questions. Actually, Jesse already has some ready to go, but if you have questions for the panel, you can provide us with those as well. Why don't you just go ahead and submit those in the chat. And then the program is approved for 4.75, almost 5 CLE credits. And the course number will be included in the after event email. So that is the housekeeping. I will turn it back over to Chris, and looking forward to hearing from Jesse and Nate.
Thanks everybody for joining us, including online. A couple things. One, Mark had mentioned just a second ago that if you have questions, feel free to interrupt. Nate and I are not easily offended, so please interrupt us. And then online, please submit them. And I think Paul's keeping an eye on those questions that may be coming in. And for anybody that has questions, especially online for the panel this afternoon, just include panel in the question when you send it in. So great. We'll get kicked off. My name's Jesse Atkins. I'm an attorney here with Gardner Law. This is Nathan Downing, my esteemed colleague. Between the two of us, we have 20 years experience in the healthcare industry, regulatory and legal, that spans being in industry for both of us, as well as in-house in other healthcare settings. So today, I want to jump in and we're going to talk about an FDA enforcement update regarding. Nate and I are actually not that interesting, so I'm not going to spend too much time on these. We're mostly good looking, so you can look at our pictures, but I won't make you read about us. So the agenda for the enforcement update, we're going to do a really quick refresher on ad promo rules, kind of the rubric that we're in. I think everybody here has quite a bit of experience in this, but for anybody that doesn't or anybody that needs a refresher, we're going to go through that. And then we're going to talk about a couple of recent FDA notice violation letters that were sent out that highlight a couple of interesting and I think broadly applicable thoughts that we should have in mind when we're marketing, particularly on social media. We'll follow up with just a quick reminder that competitive promotion can come to bite you, even if FDA doesn't come after you. We'll comment on state actions, and then we'll wrap it up. We are going to start with a quick poll, and so for those of you that are online, if you're able to hit on the poll, whether your primary focus is medical device, drug, or an even split. And here on the room, I guess I would just, while people online are answering that, I would ask, quick show of hands, are you primarily focused on medical device? Okay, so the majority of the room. Drug? No one in the room? Oh, one? Great. Or even split. We'll call that an even split. Great. So and Paul, do we have any poll responses coming back?
Yeah, 79% medical device.
Okay, great. So about 80% medical device. So that's great. Like I said, both the NOV letters happen to be drug, but the tenets of it are generally applicable. So really quick refresher, what constitutes drug and device advertising and promotion? So starting with the law, we start with the definition of a label, which is a display of written, printed, or graphic matter upon the immediate container of any article. Goes on to say that labeling critically includes written, printed, or graphic matter accompanying such article. Accompanying is something that has been interpreted very, very liberally, and not just to include physical accompanying. And that is best displayed by one of our favorite Ninth Circuit decisions, which made this kind of the whole reason that we're talking about all of this, which is that most, if not all, advertising, Ninth Circuit said, is labeling. The term labeling is defined in the Act as including all printed matter accompanying any article. Congress didn't, and we, Ninth Circuit, cannot exclude from the definition printed matter, which constitutes advertising. So that's why we pay any attention to this stuff at all. What's really at the heart of it, and I know everybody here is very familiar with and talks with their clients about intended use all the time. And in fact, we recently wrote a regulatory alert on this that FDA had recently promulgated new regulations for intended use, both in medical device and drug. But the key here is that when we are marketing, there is what we say about the product. I'm hesitant to say this, although I hear a lot of people say it, so I'm just going to say it anyways. What you say about your product is almost as important as your product, frankly. And you can inadvertently create a new product. You can inadvertently create a new intended use. And when FDA is evaluating intended use, they can, under the new regulations, consider, quote, any relevant source, which very clearly includes promotional labeling. And to talk more about that, I'll hand it off to Nate.
Thank you, Jesse. So, right, we just saw promotional labeling is quite broad, and so labeling in general. And so what forms can promotional labeling take, right? So when you are with your client, you're trying to make sure that anything that should go through a proper promotional labeling review, that you call that out and you put it through those channels. And so here you can see a list, right? And whether it be a convention booth, right? Sometimes in conventions, we'll want to get splashy, but the same rules apply to a convention booth that apply to other material. Setting matters, obviously, but an audience matters, but you still have those same rules in place. Obviously, TV and print advertisements, which can reach so many people, are really important. Social media, right? That's obviously promotional labeling, and we're going to talk about that later because social media, as you see, is a really hot button area where FDA is involved, mainly because, right, how easy is it for people to hop on Twitter and see that ad, right? Millions of exposures. We'll talk about too, the limited amount of information you can put on a social media post really can have the ability to use those. So really think of it, any communication created, sponsored, distributed by that manufacturer can be considered promotional labeling. And another thing I want to point out too is when you're telling the sales field to do messaging, treat that as promotional labeling as well, because those messages are what's being put out to the audience. So it may not be written on your piece of paper that you're dropping off for a physician, but whatever message that's accompanying that piece of paper is going to be just as important. And so all of this information, all of that messaging needs to be captured within your process and considered promotional labeling. So, right, we're talking about mostly the regulations around promotional labeling, but it's important to realize the statutory fundamental basis for the FDA action, and it's codified here in Section 352 of the 21st section of the U.S. Code. Misbranded drugs and devices. A drug or device shall be deemed to be misbranded if it's false or misleading on its label in any particular, right? So that's really broad. And so, you know, oftentimes in a ad promo, in an MLR meeting, you might discuss what it means to be false or misleading, and that term is used a lot, but because it's so encompassing, right, there's so many different areas that can be impactful, and that those words can make a situation, you know, hairy, so to speak, is because of the breadth of that statute and how FDA has regulated it. And, you know, it's important to think, and these are obviously not all of the examples of false and misleading labeling, but here's some areas where you're going to have it come out. Incorrect, half-true statements, right? So maybe the context of a study, maybe a study of 10 patients was done and 9 patients had success. Right? But this is a study of 10 patients. So if you put out a broad label that says 90% success rate, even though it's technically accurate in that study, you're going to have an issue with misleading because you haven't said this is a 10-patient study, certainly not powered to make outcome-type proven claims. And so, sure, maybe marketing wants to use that 90% number because it does look great, and I understand that. But that's where in the review process we need to come in and say, listen, contextually, this is a half-truth, right? We need to get more context in to make sure it's not misleading. Unsubstantiating claims, you know, if you don't have evidence, it's false. It can't be, well, this is what it would be, right? Our product does X, it was proven to do X, so it must have Y outcome. If you haven't proven that outcome, it's unsubstantiated, and that can be a false claim. Ambiguous claims intended to create an implied claim. Now, I don't know about the majority of you who work in this space, but this is where a lot of my conversation in a meeting comes in, when it's kind of a back and forth of, you know, I've got my logo here and I'm making a claim about something else, right? I'm saying people with this disease have X symptom, and then I have my symbol or something here. I'm not saying my product is doing this, and then I have to come and say, well, right, now you've got to look at where is this label, where is this product logo, you know, what does it look like? Is it clear that this is, you know, meant to be a disease awareness versus a promotional piece? And all these things can play into this implied claim that gets created that can be problematic. And so, you know, that's a way to have a misleading claim unless we can catch those implied claims and really discuss them. And once again, make sure we have the proper guardrails and the proper context in place so we know exactly what message we're trying to send. Subjective statements that cannot be substantiated, right? And you know, this is where sometimes you draw the line of, is it puffery or is it something that really could be substantiated, we just don't have the evidence. You know, this is the best thing ever, my life improved, you know, 100%. Yeah, right, that might just be a patient saying what they think, but also there's that claim there of, you know, I had really turned my life around. Does this match your clinical evidence, or is this a one-off that now we're putting out into the public arena because we know it sounds good? And so that's another area where, you know, if FDA says, well, where's your clinical evidence that substantiates this, that show you can put this message out, and you tell FDA, you know, we don't have it, this is just a patient's experience, right? That's not going to be a great argument, right? Because it's an unsubstantiated claim, even though it's a subjective opinion of that patient. And then, you know, I kind of touched about it a little bit here, but testimonials is another area where, you know, you might hear somebody say, well, that was the physician's opinion, right? That was the physician saying that, but the company's putting it on. So just a reminder that anything the company puts out, they need to be able to stand behind. So if a physician is speaking on behalf of your company and they have their own experience, they've done a 5-patient study and they want to discuss it, if that 5-patient study is way beyond the evidence that you have or not consistent with, right, all these things we've got to consider, that could be false or misleading, and once again, that could create an issue. So there are many other examples, but these are some main ones to hit on, and always be considering, you know, is there an implied claim here? Is this something that really could have substantiation if a study existed, and that means I should have had substantiation to put that claim forth?
We have a question excuse me, can you hear me?
Yes.
We have a question from the chat here.
Okay.
On HAF claims, I've seen testimonials and survey results that are noted properly and not being presented as a clinical trial. Thoughts of best practices here or watch outs?
Yeah, so I think what's important is you don't present it as a clinical trial, right? It's in a survey, or I think modeling also falls in this sometimes of, I don't like to say, hey, a modeling resulted in X, so then the claim is 90% of patients will see Y. It's modeling suggests, or in a model of run, X amount of times, patients were shown to maybe experience this, or patients are, the extrapolation resulted in this. And what it does is it shows, and this would be mostly an HCP claim the way I'm setting it. What it shows is, hey, we've got this evidence, and it's a model, and you can adjudicate it. We've got a survey, 9 out of 10 patients said why, and it's just a survey, right? We don't have collected outcomes. I'm not giving you statistical analyses on that survey because it wasn't powered to do so. So once again, all those guardrails of making sure they know it's a survey, not holding it out as a clinical study, that's the best way to do it. And then what you still want to understand is, do you have clinical evidence in this area? Because you'd still want to lead with your clinical evidence because that's your substantiation, and then that survey can bolster it. So if it's a survey that touches on your primary endpoint in the pivotal, for example, make sure you lay that primary endpoint, that pivotal study up, and then discuss that survey. Hey, afterwards we did some survey of patients, and yeah, people are still happy with our product. And that's a way to make sure as you move forward, you're not misleading the public, misleading the audience into thinking, oh, a clinical study showed 90% efficacy, as an example. So, consequences, right? So there are a long list of consequences, and really all of these have a major impact on your business, right? Small consequences, if you can even consider something where the FDA just calls and says, hey, I don't know where you got this from, right? Maybe someone has a relationship with the FDA where FDA feels comfortable asking. And now you're saying, oh, I don't either. And maybe you don't actually get an impact, but now you have to put a CAPA into your process. You need to say, hey, we need to go back and look at all of our pieces because we had one that got out that we weren't sure how it was substantiated. And so the cost of a CAPA, right, is great. And then you add on all of these different options for government enforcement, and you can see the compounding concern that your company can occur. So the point of this slide, and I think this is something we all know, but the options for consequence are many, and they're all costly. And having a good, robust review and a good partnership in creating these claims is the best way to avoid these consequences. So we all, understand the allure of stars, right? Especially in today's age. And they're very enticing, right? If you have a star that might use your product, might use your drug, your device, you want to be able to use that, right? You're going to reach a large audience. But you can see here, their stardom does not protect them or your company from FDA enforcement. And, we all know who Kim Kardashian is. Haven't seen a lot of her work, but, she has a lot of work out there. And so it's important that we realize, look at the posts. OMG, have you heard about this? This is very germane language, very comfortable language to a lot of the patient population, to someone that they might look up to and trust. And so FDA is looking at this and saying, listen, this is still advertising. This is still on behalf of the company, and you're not giving any warning, right? Where's the warning information here? It's way at the bottom, way at the bottom. And so, right, those consequences we discussed on the previous slide, a warning letter here for something they thought was safe for a spokesperson of the company, got them in a lot of trouble. So, right, so there are times that we're going to find that there's somebody famous who has a condition we work on. It's important to remember that you're going to have the same regulations as anybody else, as a physician who's putting a post or speaking on a podium. And so it's just a good reminder that stardom is not a protection against regulatory oversight. Another always kind of concerning topic that can come up. Oh, question from the audience?
How could we have done that better?
Yeah, so how could you have done this better is the question. And so this is a drug that's being promoted. And so what you need to do is you need to get your important safety information up in here. You need to have it in the area where your benefit information is. And you need to make sure that you're calling yourself out as a spokesperson. So Kim Kardashian should have clarified that so they knew, okay, this is someone paid behalf of the company. Then they need to have their risk information within the post itself that balances this. And so sometimes, you'll get into a conversation with a company and they'll say, well, I can't fit all this. I can't fit that in my risk information. And what does FDA guidance say? Well, then maybe it's not proper for you to promote that message if you can't fit the necessary balance. And so that would have been the best practice would have been to make sure you balance it properly with your risk. What are your big major warnings? What is your ISI statement? Can you link to that PI? And then make sure that it's clear that Kim Kardashian is speaking as a spokesperson on behalf of the company, not as an uninterested user of the drug who just wanted to give a good review. So off-label, right, you think about the categories of where off-label use can come in. Your patient population, your indications for use, how you use the device, how you prescribe the drug. And to promote the use in a manner that is not consistent with your labeling, with your patient population and your condition, is considered off-label promotion. And another thing to think about is this really hits on intended use. And so that objective intent in designing, in promoting, right? And we're talking about promotion and distributing the product, and it could be demonstrated by, once again, promotional materials. So that is an area where, most everyone is going to have a bar in their SOP against promoting off-label. But there's other ramifications besides, FDA may be coming at you is, from the off-label perspective, is also once again, your intent of the device, your intended use is going to be derived from those statements you make. So FDA is going to say, okay, where's your evidence? Now you've updated your intended use, and that could become an issue. So always, every piece you review, you want to have off-label use in your mind, and you want to be having that IFU, that prescribing information at your side, doing kind of a side-by-side comparison, and highlighting any areas of question. And then you can think about using, do I need to go to my consistent with guidance? Can I do that analysis? It's not directly from my labeling, but maybe it's consistent with, and you can still use that claim properly with the right guardrails, but always be having that in your mind. So along with making sure when you promote, you're promoting consistent with your labeling, based on your labeling. Another issue, and you'll see it we saw it in the Kim Kardashian post, we'll see it in the warning letters, the untitled letters, excuse me, is that disclosure of risk information. And now, those of you who practice in this space, you probably have a lot of conversations with marketing about disclosing risk information. What is that right balance, right? What makes it fair and balanced? Because you have to understand it's the net impression of the piece and that FDA is going to look at to determine if it's fair and balanced. So if you have flowery benefits and you just have page after page, and then at the very bottom, this does have risk, please discuss with your doctor, it's pretty hard to say it's fair and balanced, right? You're gonna have a tough time saying that, and most marketing doesn't expect that to be the outcome, right? They understand that they need to put some in. The question really becomes is, when you have really strong clinical claims and it's a one-pager and they want it to stand out, can we really shrink that risk at the end? Can we really kind of make it smaller so my piece still looks good? And that's a discussion that is important to have and say, well, we can maybe work some things around, but then let's put more fair balance up in the wording itself, right? If you've got a paragraph with benefits, in that same paragraph say, here are some benefits, and by the way, here are some risks that you should discuss with your doctor. So you're kind of making it more conversational and then still making sure you have your ISI, your brief statement, whatever it might be that accompanies that piece. But it's important that you're always thinking of fair balance and you're having a good conversation with your partners so they understand, why do you need to put this piece bigger? Why should this, especially when you think about a drug, what's the conversation going to be? Why does this font on this warning need to be the same as this benefit font? And it's because FDA has laid out that that's the expectation. And so I did add a little bit more on drugs, just a few things to think about. That important safety information is really present anytime you have the mention of the drug and some type of indication, right? And that can be pretty broad. If it's a drug for lungs and you have a picture of lungs, that could trigger enough to have ISI. Also make sure that you've got that established name, about half the half font size of the other brand name. And so there's a lot of other regulations around the promotion of drugs that we're not touching on due to time, but just to understand that there are some differences in the presentation of risk between drugs and devices. So a quick poll, kind of get everyone thinking again as we move forward. Do you or your company participate in social media advertising? So you've got yes, yes, we do not make claims, and no, we are not crazy. And right, and why do I say we are not crazy? It's not because nobody does it. I do it with companies all the time. You just know kind of the work that goes into it and the risks you take. So while Paul puts that poll live, we'll kind of ask, so who here uses social media with their company to promote their device, to promote their drug? All right, so like a third of individuals use social media for that. So how many use social media but don't make any claims, like straight reminder ads? Okay, so we've got a reminder ad, that's good. And how many don't use it at all? Just, that's not their policy yet? Okay. We're too small. Yeah. No, that's what you want to think about is what are the risks and what is your size and what is your risk tolerance? Because, right, social media, as we've seen, that's where your risk grows a little bit.
Yeah, online we have about 60% yes,
Okay.
about 25% yes, but no claims, and then the remaining roughly 20% no, we're
Okay.
not crazy. So.
All right, so that's pretty good, and it's nice to see some sane people. I think we can rely on them going forward. So we're going to move forward and start to hit on now the enforcement update. And I'm going to take an untitled letter, and then Jesse's going to work through one. So a little bit on the Trulicity letter. So some background. Trulicity is a drug made by Eli Lilly. And its indication, which is really central to this letter here, is an adjunct to diet and exercise to improve glycemic control in adults with type 2 diabetes mellitus. And then some relevant risks you can see here, and one that's going to really play a big role here is that box warning on thyroid C-cell tumors. So here is, on the screen, is that ad by Trulicity. You know, 1 week is 604,800 seconds. Make every second count. Make every moment precious. They do say see purpose and safety summary, including the warnings. It's a pretty, pretty captive post. It really has great imagery. You know, obviously happy patients, because that's what you're going to put in there. There's 7 total frames. But what do you see missing? You don't see that prominent display of information about the drug's indication, the limitations of use, or the risks, right? And so you might look at this post, and it maybe seems a little benign, but you know, as the OPDP decided, it was not benign. So here's a little bit about the letter, and I'll just kind of read this one area. This post makes false or misleading claims and representations about the benefits and risks of Trulicity. Thus, the post misbrands Trulicity within the meaning of the Federal Food, Drug, and Cosmetic Act, making its distribution violative. So now they've got this letter, and now we're going to use this to educate ourselves moving forward on how to act. So here's the allegation. The post prominently presents benefit claims and representations about Trulicity emphasized by colorful, right, that's important, colorful, compelling, and attention-grabbing, fast-paced visuals that take up the majority of the post, right? The majority of the post is another key word, with frequent scene changes, busy scenes, and large moving superimposed text, along with other competing modalities such as a strong, fast-moving musical beat. In contrast, the risk information is in a small window relegated to the bottom of the post. See that small window relegated to the bottom of the post, presented using fast-paced, scrolling, small font that cannot be comprehended by consumers. So FDA is really laying out some of those regulatory concerns, right? Your benefit and your risk information are not syncing up. You're not giving fair diligence to making sure the audience can understand that risk information. They're going to see those flashy pictures, those fast-moving scenes. They're not going to understand what might occur with the use of this drug, which is really important, right? You want patients to know this is the possible benefits, these are the possible risks. These violations are especially concerning from a public health perspective because the promotional communication creates a misleading impression regarding the safety and efficacy of Trulicity, which is a drug with multiple serious, potentially life-threatening risks, including that thyroid C-cell tumors warning. So what are the key takeaways before I hand it over to Jesse? So you need to balance your benefit and your risk information. And this is not just a drug right, rule. This is a medical device drug rule. This is an ad promotion of these products rule to have fair and balanced information. So it's not just information, it's also the way in which it's communicated, right? FDA had that word majority. The majority of the screen was really focused on good things, which is, what you might, as a marketer, that's what you're going to create. That's where we have to come in and help walk them back, right? Prominently display relevant information. The indication was truncated, right? And in the letter, FDA talks about diabetes generally is not your indication. And that's really something that's important, right? When we have specific indications, I always try to get my clients to, as kind of close to the top, like let's get your full indication out. Maybe it's conversational. Hey, I'm an adult with X, and Y and Z are my categories, and that's what matches your indication statement. And now you can kind of flow through, but you can't just lead, for example, here with I treat diabetes. We treat diabetes when it's specific to type 2. All those individuals with type 1 who might see this are going to be confused and say, hey, I'm going to ask my doctor about Trulicity. I want to lower my A1C, right? So that's FDA's warning there. And then the risks, contraindications, the mere presence was not enough. They need to make them stand out as similar as they did the benefit information so that the audience can understand that important stuff. And then a quick 2 things. The repeat offenders, this was not the first time Eli Lilly had been called out, so that does play into FDA's overall considerations. And this was also the public watchdog and the FDA bad ad program played a role here, and that was submitted to FDA. I'm going to turn it back to Jesse to close out. Thank you.
So either of you could take this question, but in the chat, are a large chunk of complaints generated by competitors versus OPDP seeing them on their own?
Yeah, so in my experience, competitors really drive a large amount of complaints. They'll send things into the FDA. We can't always follow that out. You don't always know the result. But certainly they're policing you a lot because of the implications of competitors being able to take down your messaging.
Yeah, I mean, I would echo that and suggest that, one, you're not always positive where it came from, but commonly when you see, for example, a MedWatch complaint will come through that will be anonymous and will be artfully written and referencing statute and regulation. And my assumption is that somebody was not sitting on their couch watching a Trulicity ad and writing that in. So I think most commonly it's your competitors that are watching on free, but FDA certainly is identifying these things as well. I'm going to talk quickly about Duobri. First of all, I'm going to say it's not every day that you get to have a presentation that includes not just Kim Kardashian, but Montel Williams, but he's included in this, so this is very exciting, I think, for all of us. Some quick background on Duobri. So it's a topical lotion indicated for the treatment of plaque psoriasis in adults. It has several risks that are relevant to our conversation and to the untitled letter. Serious systemic risks and skin reactions, embryo-fetal risk, and photosensitivity and risk of sunburn. So just keep those in the back of your mind as we jump in. So this is a little different type of an advertisement. This is a screenshot from The Balancing Act, a show hosted on Lifetime, 8:30 in the morning on weekdays. I'm sure we've all got our calendars set for that. Olga Villaverde and Montel Williams are the hosts. I think the audience for this is either, it's probably my grandmother, but other people are, you may have fallen asleep watching a Nicholas Sparks film on Lifetime and then turned on the TV in the morning and this was already on. So what we don't have is the video because, as I would have suggested Bosch do, that it has been deleted and left to the annals of time, no longer available to us. So I can't show you a clip, but what FDA did do in its infinite wisdom was provide us with a storyboard, and I am going to use this to just talk through a couple of the items of what happened here. So this is, again, the Balancing Act. It presents itself as if Montel Williams and Olga Villaverde and their team have evaluated these things. They're speaking on behalf of themselves and these patients, and they're really just presenting information to you as a consumer, as somebody that is just interested in this drug, which of course is not the case. This is paid advertising that is done, and all the information is provided directly from Bosch here. And so it opens up with a young woman named Katie, and young, by the way, is relevant to the conversation, and having young children is relevant to the conversation. What she talks about is that she has struggled with plaque psoriasis for her whole life. She has talked about throughout adulthood. She talks about how she would wear clothes that would cover it up because she was embarrassed or because she didn't want it to be seen. And she talks about what life was like with plaque psoriasis prior to Duobri and after, which sounds, the difference for her was remarkable. Then there's her physician speaks about plaque psoriasis, what it is, how it works. A couple of points on this, and these are all, by the way, clips directly from it. One comment that I would note is when Katie is talking before, you see these black and white photos. Life lacked color and vibrance, right? And then it moves into the after photos where everything was much more flowery. Another point that I'm going to make is the one place where you get any risk information is on the lower left of the screen here, and you can see significantly smaller, and it was commented by FDA that was not adequate. And so there's really two things that I want to highlight here. One is risk balance and failure to disclose relevant risk information. So FDA highlighted that. I guess one of their comments that I just kind of want to read to you is that something can be false and misleading not just where there's a misrepresentation, but based on the extent to which a communication fails to reveal material facts in light of the representations made. Now, I said that her age was important. There are two, in the precautions, there are two recommendations, or a requirement and a recommendation. A requirement pre-prescribing that 2 weeks prior to initiating therapy, a woman of childbearing age have a pregnancy test and have a negative pregnancy test. And a recommendation that a woman of childbearing age during therapy have effective contraception. The studies have demonstrated embryo-fetal risk, and so it is contraindicated for pregnant women. So her age and the age of the children was highlighted by FDA. Another thing I talked about Katie commenting on the fact that she would wear long sleeve shirts, and she changed her wardrobe after she began therapy with Duobri. One of the things that FDA highlights is risk of photosensitivity risks and risks of sunburn are not commented on in the ad at all. And so FDA commented that merely by her making that comment, and they also commented on her wearing a shoulder exposing shirt, that those are the types of things and when Nate talked about implied claims earlier, right? These are implied claims that I'm not going to get sunburned, I suppose, or at least that I don't run the risk of sunburn, or that the fact that we're not disclosing that is problematic. So generally throughout, the warning letter kind of hits them over the head with that topic. The other one, though, that I want to highlight is the clinical superiority claims and the comparative claims. So in it, they call themselves the first and only. There are comments that other creams didn't work, comments that within days results were demonstrated, and the clinical trials. What FDA commented in the letter is that the clinical trials were not against competitive products. They were against a lotion, and therefore they don't have the information or the data, or as FDA says, if you do, please provide it to us very kindly. And so, but we all know that they don't. So, and I'm just going to read one more piece for you from the letter, where they say the claims of demonstrated synergy and superior efficacy versus the aggregated results of 2 monotherapies, so this is an item from the webpage, are based on data derived from post-hoc analyses of a single phase 2 trial of limited sample size, which compared Duobri separately to its individual components and vehicle. And so this is a comment from FDA, not just on the the proper type of data, but on the adequacy of the breadth of the data. They say, we acknowledge the statement post-hoc analysis of phase 2 clinical trial is included on the webpage. However, this does not mitigate the misleading impression created by these claims and the presentation because the phase 2 trial was not designed to support conclusions comparing the efficacy of Duobri to its aggregated components. Now, I know everybody in here knows this, but when our marketing teams get frustrated with us, when we tell them we want to read the clinical, we want to read everything, and they say, no, we've got the conclusion, here's the abstract, we're good. Remember, this is where FDA can hit you. Now, Nate also had commented on the fact that repeat offenders can get in trouble. FDA was not shy about reminding Bosch that they had commented on these things previously in less formal channels, and Bosch did not take that as seriously. So just remember, it's a gift if FDA reaches out to you and says there may be something problematic about this, and take them up on it. And so again, we hit on these, but the primary allegations are that it's misleading. And like I said, they go on to talk about the serious skin reactions, the embryo-fetal risk, as well as the competitive claims. So a couple of key takeaways here, very briefly, in our last couple of minutes. Remember, non-traditional promotion is still subject to regulatory action, and I would say we can say that even more staunchly, which is that this is, I talked about my grandma or you waking up because you fell asleep with Lifetime on last night. This is a more vulnerable person that is taking in this information. You're presenting it to them from what may be a trust. These people, I think my grandma trusts Montel Williams quite a bit. So these are people that are trusted, and we're providing the information as if it might not be an advertisement, but it's actually, we're just taking experience from this young woman and her beautiful children and their lives that are magically improved by Duobri. And then that comment, I guess the one thing that I really want to take away is the photosensitivity risk being tied to what she was wearing. Just remember that the photos that are in your social media posts, the videos that are included, we're making implied claims all over the place, and we've got to have our issue spotting hats on for where those implied claims are coming out. I shared with Nate that I had another client who was running a social media post through Ad Promo Committee. And they were using, the person was on the side of the pool with their elbows on the side of the pool with the product. And this is not a waterproof product. And so that is an implied claim that you can just run into the pool and use this product. And those are the types of things that we want to keep an eye on. I know we are at time. And so I'm going to save this. I'm just going to remind that even if FDA doesn't take up a case, your competitors can. Courts are not, I will say this, in this particular case, the court really looked into whether or not this was a misleading claim. And the linkage between, I'll just tell you, the linkage between COPD patients who may have trouble inhaling with greater force, they recognized that as a need. They also recognized that this new inhaler product had I'll call it an accelerant of sorts that they designed to support that lack of inhaling strength. The issue was they never demonstrated a linkage between that need and their product that was designed to do it being effective. And the court found therefore that it was misleading and that they granted a permanent injunction in that case. So last thing, knowing that I'm now 3 minutes over time, I'm just going to remind everybody, DOJ and OIG are continually reminding us, and we say thank you for that reminder, that they're not slowing down on enforcing these types of things. And so we just want to know that they're looking at these things. False Claims Act penalties have been on the rise, and we think that will continue. So the key takeaways, very briefly, remember, just stick with your effectiveness of what it is. Don't overstate it, and always go back to your data and to your clinical studies. The significant risks that you've got, don't just not downplay them. Make sure that you're playing them up to the same extent that you're playing up your benefit if you're going to hit hard on benefit. Substantiation of claims is critical. It's where FDA is always going to go back to. In their letter, they always, at the end of every statement, they give you that opportunity. And if you have evidence for this, please give it to us. Which, of course, FDA, if we had it, we would have given it to you before. But in any event, they will say that. Don't overplay your competitive advantage because, as we talked about, your competitors are the ones that are going to call you out. And then make sure that you're relying on experts effectively. Make sure that the individuals that are making the claims on your behalf in your pieces are the right ones, and make sure that when they rely on data, especially if it's their own data, that you check for alignment between your data that you've got and the data that they're looking to present. So that is it with -4 minutes left for questions, but we still are happy to take a couple. So yeah, go ahead. Oh yeah.
Yeah, we have one on the chat too.
Okay, great.
We'll start here.
So for this space of regulation, does this apply to pre-marketed products, so like startup companies that haven't launched something yet?
Yeah. So technically no, but also yes. So technically, if you've not placed a product into interstate commerce, FDA does not have the authority to bring down any regulatory action. However, claims that are made prior to going to the market you basically can consider that a file that's being created. And the moment that it's placed in interstate commerce, all of those can be considered false or misleading claims that were made about the product, and therefore regulatory action can be taken.
Yeah, that was going to be my second part, because you make this I've seen startups make a website that talks very flowery about their technology.
Right.
Without any support, and then if they do get to market, they have this.
So commonly what you'll see is you'll have startups with brilliant engineers and business people, and they've got a great idea, and they're running strong, and they're like, we're going to hire legal and regulatory and compliance before we really go to market, but like, let's get this thing going. They're very excited, and they don't really give the thought as to what those risks may be. So,
thanks.
We had one question in the chat, and I think it'll be a quick one. But
sure.
Does the FDA watch for advertising and promo issues, or do they have to wait for a complaint?
They can bring it on their own. OPDP gets submitted to them for a drug, so they have all those in front of them, and they can go on the internet and they can find these things, and they'll be at conferences, right? FDA often is at a conference picking up your material, and so yeah, absolutely, they can be the person, the entity that brings the concern forward. So you got to consider both FDA and competitors.
Where do press releases fall in this category of advertising and promotion? Because I see, specifically for PMA devices, I see the general clinical result produced in there, but I don't see is the list of the risks associated with those products routinely. Yeah, so I think that's an excellent point, because it is still advertising, promotional material. Generally, FDA hasn't done a lot in that arena, but they can, right? There is and I can't think off the top of my head to tell you the specific I can look for it, but there's been some actions out of press releases. And I usually advise my clients, like, if you're going to make these claims, let's still balance them. Let's have a link to that risk information, because what you're doing is you're giving yourself a good setup. Now, is it a press release that's truly a press release going after the investor community, right? So you have to look at how you're using the press release, who you're directing it towards, because like a true investor press release can be different. This could be more forward-looking. You're going to have certain statements on that indicate this is what it's for, right? So you can't give a blanket answer on press release, so you do have to look at the content in the audience. But if that's content and that audience are really seeming promotional, it is promotional material and advertising labeling, and I think it's worth considering these regulations. Now, you're going to have a conversation with leaders, and you're going to come out what risk you think is proper, but I think it's best to treat it as labeling, because that's what it is, and just the lack of enforcement doesn't mean it's a free-for-all.
And I would just add to that generally, like Nate said, FDA has kind of taken a bit of a hands-off approach to press releases to financial-related, investment-related type activities. But you do occasionally see manufacturers that will turn their press release function into a marketing arm, and now they're just issuing press releases nonstop. And at some point, that's just a new marketing arm, and they're not really press releases. So keeping an eye out for that and making sure that press releases are in fact press releases is one of the best things you can do.
We have a couple more questions in the chat. First one here is it not okay to have a patient talk about other treatments they tried that were unsuccessful and or treatment was successful? If they use general terms and do not name the specific other therapies, is that okay?
You want to take it?
Yeah. So yeah, absolutely. Like oftentimes a patient needs to be intractable to some type of other therapies they've tried. So sometimes you need them to spell out those therapies so you can show, yes, we've tried X, Y, and Z, more conservative therapies, and now we're on to our therapies. So sometimes it's actually part of the story. But what you want to do is when you're discussing it, if they said, well, I tried X, and I had all these risks, I had these reactions, and now you talk about your product, and you're not talking about the risks, now you're out of balance, and you're misleading, and you're putting forth another product as having more risks than yours. And so you can do it, but it's that fair and balance we talk about over and over, that still applies. And you need to present that product in a fair and balanced manner, consistent with the evidence, consistent with indications, and then do so with yours as well. So you can, but it's important to make sure that you are considering all of those things, as well as the patient, how they describe it, needs to match available evidence.
And when it comes to calling out an individual product, I would just remind that when it comes to comparative claims, both FDA and FTC are on the record as saying that they expect head-to-head clinical in order to be able to make comparative claims. And if you've got a patient that's making the claim on your behalf in something that you're going to be presenting or promoting, you run that risk of FDA suggesting that you're now making comparative claims that you don't have substantiation for. I think, should we take one more and then cede the...
Yeah, we do have one more in the chat here. There is lots of pre-approval marketing enforcement action, or it's not a question. Let me go to this other one. Is it okay for a patient testimonial story to say they tried a lot of other treatments that didn't work, if that is true, and we add results may vary?
Got it, with results may vary. So I don't, results may vary is great, and I recommend adding it to a lot of pieces. Results may vary or not. It's not going to get you out of. It's not a get out of jail free card. And generally speaking, by the way, I would say, I have a couple of marketing people who will come to me often and they'll say, we want to say this, but we'll put a bunch of disclaimers. But you can't lie about something and then disclaim it at the bottom. Disclaimers are not going to get you out of most things. And in fact, FDA is constantly hitting on the fact that the information that you're providing in small font at the bottom is not adequate to balance or to provide more the nuance necessary to understand, or just to give the full story with the large, flowery, everybody is healthy after using our product language at the top of the screen. So I think results may vary in that situation is great. I wouldn't change your threshold for what you're willing to promote from a patient testimonial perspective shouldn't change based on adding results may vary. I'd say add it no matter what, but keep your threshold for whether or not you're going to use those statements the same.
Yeah, all results may vary may do is allows that patient, that physician to know, I may not get that same result, but it doesn't make something true that was untrue to begin with. So, gotta be careful.
All right, thank you very much. Appreciate all the questions, and we'll be around if there are other questions. And apologies to the next presenter that we just took some of your time.
No problem at all. That was fantastic. I'm glad you guys took that extra time. I was texting the team back where you are saying, keep going. So really thought those were great questions from the audience and answers from you guys. So I'm going to jump into clinical research contracting here. We do have a break coming up. I will turn my video back on here. Okay, so let's, Chris, if you're gonna advance my slides for me, I appreciate that. If you can take me up to the presentation. There we are. I think everybody knows who I am. We can go to the next slide. Okay, so here's what we're gonna talk about. Clinical trial agreement review 101. We're going to hit recent OIG advisory opinion 2205, 22-05, research payments, enrollment incentives, and this notice of non-compliance. And I'm in the office, so I'm just going to ask my the back office staff if they can mute their computers because I can hear myself in the background. So let's go to the next slide. So this is what, clinical trial agreements and research may feel like to you sometimes. This is a pretty arcane area of our practice, or food and drug practice, if you will. And it's not just food and drug. You have anti-fraud issues, privacy issues. It checks all the boxes. You also have the potential malpractice issues for the investigators and product liability for the company. So it's very complex. So this image is just to, hopefully it's not this complicated for you, but it may feel like it sometimes. So I'm going to start with a polling question here. If I think Tracy was going to cue that up for me. I just have a couple of questions. One is, are you working at a company that's performing clinical research right now? I suspect a lot of you will answer yes. And maybe Paul, if you can look at the room by show of hands, how many people are working at a company that's performing some research right now?
Yeah, here in the room, it's just about 50%.
Okay, all right. And do we have polling results?
Yeah, so 84% online are saying yes, and obviously 16% no.
Okay, all right. So the next question is, are you involved, like you personally, Tendy, are you involved in CTA negotiation? Yes or no?
So here in the room, we've got 4 people raising their hands that they are yes involved in that.
Okay, great. Online?
And online, it's just about a 50-50 split. 56% say no, 44 yes.
Okay, quite a few. That's actually more than I even expected. Well, that's good to know. Chris, we can go to the next slide. So I'm glad to hear that, because we're going to spend a few minutes just going into the different aspects of clinical trial agreements. And I'm hoping you guys can see this a little bit better than I can read it. It's a little bit hard on the screen here, but I'll have to use black font next time, I think. But when I was preparing these slides, I thought, how can I visually depict what goes into a CTA without having, how many 6 times 5, 30 slides on all of the different terms and conditions that typically you'll find in a clinical trial agreement. So when I say CTA, that's clinical trial agreement. By the way, in your folders, we have an acronym list. So if you hear different acronyms barked out today, hopefully the acronym list in your folder, or if you're online, those materials were sent out to you. So if you are scratching your head on an acronym, chances are you'll find it on that sheet. So I'm just going to run through really quickly. These are some of the different, oh, thank you, Chris. Look at that. Appreciate that. Much easier for me to read now. These are some of the different terms and conditions, reps, warranties you'll see in agreements. So parties, effective date, term and termination, IRB, Investigational Review Board, EC for Europe, Ethics Committee approval. There may be terms on FDA requirements if you're doing an investigational study, whether an IDE or IND, who's responsible for that, whether it's been checked off. If you're doing an investigator-initiated trial, you want to have a term in there that says the investigator is responsible for that, for example. Study product, communication with regulatory authorities, meaning what if FDA comes and knocks on your investigator's door? Do you get to find out about that? Are they obligated to tell you? So you want a term in there that says yes. Informed consent, Part 50, monitoring / clinical events committee. So if something goes wrong, patient gets hurt, who adjudicates that? How is it kept track of? What has to happen in terms of reporting? Record retention and access to records. You're going to want to have something in your CTA that says you have a right to access the data. And that can be sometimes a contentious point at some sites. They'll say, well, we own the data. You have a right to it, blah, blah, blah. You need to parse that out, figure out what's what. So I'll just continue to kind of run through some of these different terms, and then in the following slides, I'll talk about the most contentious ones. Confidentiality and confidential information. How is it treated? Do you want the terms of your CTA to be confidential? Privacy, pretty self-explanatory. Publication rights and use. Who has to do what? How long do you have to review data? IP. What if some's created during the trial? Who owns it? Etc. Is the site obligated to help you with prosecuting patents, for example? Doing certain things could be, critical. Adverse event notification kind of goes along with the monitoring just above it. Indemnification, insurance, subject injury, publicity, governing law, compliance laws. I know I'm rattling through a lot here because I want to talk about what I see as the most important ones. Payment, and FMV stands for fair market value. Good clinical practices are the investigators and the institution agreeing to follow good clinical practices. Exclusion and debarment, not having anyone on the study that's been excluded or debarred, pretty obvious. Study materials, who owns those? That goes back to use as well. Signature block seems kind of like a silly one, but do you need the sub-investigators on the signature block? So that could be very important. Notices, where do they go? Modification, what if you want to change something? How do you do it? Budget, obviously, maybe one of the most critical elements. How are you going to pay the sites? Other covenants and warranties, we could go on and on with other legal terms and conditions that typically go into these. You may also have in the lower right there a facility use agreement, so also known as an FUA. And some sites will say, okay, you're going to negotiate with the institution, the PIs, but you're also going to enter a facility use agreement for use of certain sites. So those are, you're drinking off the fire hose here with me this morning, but those are the terms that if you were tasked with negotiating a CTA tomorrow, a clinical trial agreement, or even a research agreement where you're providing a grant to an investigator to perform some research, these are the different things that I would encourage you to check through and make sure that these are all covered in your agreement. And that's a pretty fundamental point about having an agreement at all. Anytime you're remunerating a physician or an institution, you're going to want that outlined in writing so that you can meet the personal services and management contract safe harbor, or at least attempt to meet it. Let's go to the next slide here, Chris. Okay, that's great. Thank you for updating the fonts on these. So I next said, those are all the things that go into a contract, what we just covered. If I'm in your seat, I'm thinking, well, Mark, which ones do I really need to drill into to make sure I get right? You should get them all right, obviously, but you're going to want to make sure that these are all in line. And these are the ones that when you send your CTA over to an investigational site, that institution is most likely to redline these terms among all the ones that we just talked about. Again, they may redline all of them, but these are the ones that are probably the most impactful to the organization. So publication rights and use. What you don't want to have happen is you negotiate a CTA, your study's complete, and it turns out that you can't do what you want to do with the data. Maybe you don't own it appropriately. You can't publicize it the way you want to. Maybe the review time that you have when a manuscript comes out related to the published data is limited to 15 days or something. That would be atypical and unacceptable. Typically you're going to have 60 to 90 days to review a manuscript, for example, that one of your investigators may be submitting. And what investigator rights exist? Do they have the right to just go publish anything they want without your review, or do you get an opportunity to review what is published before it's published? So that's an important clause that I encourage you to take a close look at. Thank you. Another, the IP aspects. absent, Theo on our team, we're not IP lawyers. Theo has a background in IP and also FDA law, but the rest of us are not IP lawyers, so we're not going to be reviewing your CTAs for IP compliance. And you should think about that, making that point. So you as well should, unless you're an IP lawyer, you really shouldn't be reviewing the red lines that the site just made to the IP clause. You're going to want to have a professional that's an IP attorney look at those changes. But those are very commonly edited clauses. It could involve, again, disclosure of IP reports, results, ownership, also the prosecution aspects, like you may have terms in there that talk to what the site agrees to do in order for the company to get the IP submissions filings made. So, some of the basics with IP, you'll see, like negotiating with the VA, for example, can be quite challenging because they have a template that they use for CTAs, and they'll just say, you need to use ours, and we're going to own all the IP. I did have one occurrence where I was successful in getting the VA to concede some points. I'm not sure how that I did that. That was a long time ago. But generally, they are pretty reluctant to change it, especially the IP clauses in their CRADAs. So, in that case, whenever I'm negotiating one of these, even if I redline it, I know we have a lot of attorneys signed up today. If I see some pretty obvious stuff in the IP clauses, there's tons of red ink splashed all over, and it says we own everything. It doesn't take an IP lawyer to know that that's not going to work for the company, and then you're best suited to get your IP counsel involved for any final changes there. Indemnification, very contentious. It's rare that if you send a CTA over that the other side doesn't try and edit that. The way we work with our CTAs and draft them, we try and make them agreeable to both sides because that speeds the trial along. When you're burning $2 million a month as a startup, for example, and even if you're not, if you're a big company, but still wasting time on forms, and negotiation back and forth, that's very costly. So you want to start with a form, just a practice point outside of indemnification here, that should be agreeable to both sides. So think of whether, are you asking for the moon on everything? If your indemnification clause says, hey, other side, you're totally indemnifying us and we're not doing anything for you, you just have to assume that's not going to fly. So best thing to do with indemnification is make it bilateral. Take the very similar indemnities should be made to the other side as to you. And as an attorney that's negotiated probably over 1,000 CTAs, and I'm not exaggerating, I'm always comfortable with indemnification, especially if both sides are giving each other the same allowances. There are some nuances, but generally speaking, indemnification is pretty easy to overcome if there's objections there. And by the way, pick up the phone if you are working with another side and they start redlining. You'll be surprised if you call them during the process and just say, hey, I saw I got your red lines. Just thought maybe we could jump on the phone and run through them together. And if you talk through them, chances are you are going to have a much better time than if you're just sending emails back and forth in red lines. That personal element can really help smooth things out, which again gets that contract ultimately signed faster so that site can get rolling in the trial. Subject injury, probably number one on here, I'd say next to budget in terms of editing. Ultimately what I think about with subject injury is and what that means, just to back up, if someone gets hurt during the trial, who's going to pay for it? Is the patient on their own? Is the PI investigator somehow assisting, monetarily? Is the sponsor, or, your company, are you basically saying, yeah, we're going to cover all subject injuries? It's pretty common for the sponsor to cover them as long as they're related to the device. So the language around subject injury is critical. What you don't want to have happen is make that unclear and have it open-ended. anything that happens to the subject after they're implanted with a device or take a drug, whatever it may be, then we're going to cover it. Well, what if they trip and fall on ice and has nothing to do with your product? That I've seen that clause actually abused before, where patients that were already sick before the trial came into the site and then got more sick, and my client was on the hook ultimately for additional costs. Those were for clauses obviously I didn't negotiate, but so be really careful around the subject injury clause. And last one I'll cover here is the budget. And that's pretty self-explanatory when you're talking about money. Naturally the site's going to want to get as much as they can, and the sponsor's going to want to pay as little as possible. Let's go to the next slide. These are some honorable mentions that didn't make it to my top 5. Informed consent, usually a pretty easy one to address. And by the way, what I'm talking about here with a lot of these is you've sent your form, your CTA, to the site, and now you've gotten red lines back, and they may have redlined the informed consent clause, and you may go back and say, look, we already negotiated this informed consent with the agency where we can't change it. That usually shuts that down pretty quick, that conversation. That, the informed consent isn't really subject to editing very often. It can be, but can be, challenging. Record retention, access to records. Sometimes you'll have sites get run the axle about who owns what and who can access what, and rightfully so. They're trying to protect their client. But usually once you talk with the site, like, look, we're running an ID or IND trial here, and we're paying for everything, they pretty quickly appreciate why the company needs access to the records and how long they need to be retained and things like that. Confidentiality and confidential information. It will get edited along with the IP clauses. So that it's kind of like a little brother to the IP clause. Insurance will be, edited in terms of amounts and coverage. Publicity, you may be working with Cleveland Clinic, Mayo, Scripps, UCLA, whatever it may be, Penn State, or UPenn rather. They may say, hey, well, you can't use our name, or you can. So this is where you go back to your clinical medical staff. What sort of publicity are we expecting here? Or do we want to do a press release when we have our first in human? And so you want to think of some of those things ahead of time, because you might be asking the PI from Mayo or wherever it is to be part of a press release on your first in human. And if your publicity clause says that you can't talk about Mayo, then that's problematic. Mayo, by the way, has a sort of interesting fast track process, which I won't get into here, but they're actually quite good to work with from my experience. I've worked with pretty much every teaching hospital in the country, and if you catch me offline, I can give you a rundown on all the different, some of the more challenging ones. I'd probably put UPenn in that bucket. Actually, it's a bit more of a handful. UCLA as well. Exclusion and debarment. Occasionally you'll have people redline that clause, and then once they understand that what you're trying to say is we can't have people that have been excluded or debarred by the government in the trial, they quickly understand what that clause is. A lot of times when you're working with attorneys on the other side, they may not have a lot of experience with CTA, so you have to be really patient with them. A lot of the same issues come up over and over. And once you educate them, you just kind of move on. Try not to have an acrimonious exchange with them. Chances are you'll be talking to them again in the future. Compliance with the anti-kickback statute, False Claims Act, HIPAA, all that. Again, sometimes I'll see red lines in there, and I'm like, look, we're just trying to protect our client, protect you. And they'll pretty much concede those points. And then governing law gets edited a lot, not usually a real big concern. Let's go to the next slide. Okay, so I'm going to shift gears a bit. We're going to talk about an OIG advisory opinion, and this is around patient subsidies. So this is an interesting one. I'm just going to do a time check here. Okay, we have a break at 10:30. I may borrow a little bit from that break. if you guys are okay with that. So this is an OIG advisory opinion 2205. That means it is recently issued, 22 marking the year there. Our clinical trial patient care cost subsidies. This is the question. So I did a typical IRAC, what we'll call, and for the lawyers out there, you already know what that means. For the non-lawyers, it's issue, rule, analysis, conclusion. So this is how they teach you how to break down cases in law school. So I'm going to do that with this advisory opinion. So the issue is in the form of a question. And then what we'll do is apply, I'll call it the facts of the case. We'll then call the rules out. I'll provide the OIG's analysis and their conclusion. I'll give you the conclusion first. The OIG blessed this arrangement. And so if you are out there and you're doing a clinical trial and you're thinking, gee, it would be great if we could cover some of the costs associated with the trial for our subjects, then you're going to want to listen closely to this, because ultimately that's what the OIG allowed this requester to do. So the way that OIG process opinion advisory opinion process works, we don't know who submitted this. A lot of times us insiders will know who the company is. It gets out, gets around. In this case, let's just jump into it with the issue first. Our clinical trial patient care cost subsidies, which could induce Medicare beneficiaries to participate in the study and provide prospective payments to providers, unlawful and therefore subject to prosecution under anti-fraud laws. So calling out the anti-kickback statute there and the civil monetary penalties law, which I'll just call CMP law from now on. The answer is it depends. Let's review a recent advisory opinion that considers this question. Let's go to the next slide. Okay, so these are the facts of the case. Tried to break them up and make them easy to digest. Just bear with me. Can be a bit dry, but for a lot of you out there, you're in industry insiders anyway, so dry is what we all do, right? So device manufacturer company, we'll call them, submitted a request for an advisory opinion to receive feedback on an arrangement. By the way, again, if they get positive feedback, they're golden. You know, they might not meet a safe harbor, but the government basically says we won't prosecute you. Company's investigational device is available for clinical use in the U.S. pursuant to an FDA-approved Category B investigational device exemption. Category B means that the government is reimbursing the product and services associated with the investigational study. It is a one-time use device that uses a patient's own cells for the treatment of ischemic systolic heart failure. Company plans to enroll up to 260 patient subjects, and that fact comes in later that the government likes that there's a cap. It's a randomized controlled trial with a blinded control group. There's a 3-to-2 ratio for enrollment, meaning 40% will get the control. So they will not get the device, and that fact comes in to play in a minute here. As I already talked about this, as Category B studied, Medicare pays for the device and the services associated with it. We can go to the next slide. So here's some more facts, kind of a fact or a dense slide here. I'll try and roll through and pull out the highlights. So this is an important point. The company's saying we're going to cover the cost sharing amounts for Medicare beneficiaries. They're actually also going to do it for the commercial payers, but the federal anti-kickback statute and CMP law, you know, they apply to the Medicare beneficiaries, those anti-fraud laws. The company will not advertise this. They're not going to have a brochure that says, hey, free study. We're going to cover all your costs. Information on the subsidies was included in the informed consent documents. The cost sharing amounts that are going to be covered, about $1,300 a patient. As a result of these subsidies, there won't be any out-of-pocket costs for the beneficiaries. So it's great for the beneficiaries. Investigators and sites will also make money because they're going to be able to charge for their services and they're guaranteed to get paid. Let's go to the next slide. So if you're, playing at home, why are we even talking about this? Why is this a potential fraud? Well, because we're paying for these services that otherwise the patients enrolled in the study would have to cover. And so the government's concerned, well, this could impact the beneficiary, i.e. the patient's decision as to whether to enroll or not. And it could also impact the physicians and the institution because they're going to get paid money to do the work. So if the company's paying for all of it, and then the government ultimately is picking up the tab at the end on some of the costs, the government's saying these could be bribes to the patients and the physicians because there's a lot of costs that we're paying for that are not incurred here. Okay, because there's category B reimbursement. Why does the requester want this, the company? This is what they said in the advisory opinion: to reduce financial barriers to enrollment and to reduce attrition. So they're saying if it costs $1,300, a lot of people are going to say, I'm not signing up. And okay, I'm going to have a bunch of tests in the next 2 years. I'm not signing up because I can't afford them. So they're saying, the company's like, in light of that, this will help facilitate socioeconomic diversity among the study subjects. Only the rich people are going to be able to be in it and not the people that can't afford these things. Also preserves blinding of the subjects because the subject gets a bill for these things that are unrelated to the treatment arm, the investigational arm. And they'll say, well, gee, I can tell that I'm in the non-treatment arm, which then unblinds the study, which creates problems with the integrity of it. So there's a lot of good reasons, and you'll see that the government is later compelled by these in their analysis. But these are the reasons the company put forth. The government agreed with them. Although the advisory opinion focused on Medicare beneficiaries, the government said, hey, we're gonna do the same for private insurers. If you have Aetna, Blue Cross, United Health, whatever it may be, we're gonna do the same. Government like that. For Medicare beneficiaries that supplemental insurance such as Medigap or something else, then the company said, we'll just pay anything that's not paid by these supplemental insurers. Let's go to the next slide. These are the laws. I will not cover in depth. I don't want to take all your break time away. But the anti-kickback statute basically says if you give something a value with its remuneration is the term used, and the intent behind it is to induce referrals or purchases of products or services that the government pays for, then you violate the anti-kickback statute. Let's make a simple example. Hey, doctor, if you buy my drug or device, I'll give you $100 just for free for just buying it. Well, that's a kickback. That's exactly what we just described. You're giving something of value to induce a purchase that the government's paying for in that case. Violators face big fines and exclusion. You have to be excluded if you are convicted. That's why you see so many settlements under the anti-kickback statute, because the alternative is getting thrown out of the industry, usually for 5 years, sometimes longer. And that applies to persons and people, individuals, employees, and companies. Civil monetary penalty law basically says that you can't bribe a patient in order to get them to select a provider. So a doctor can't go out and bribe patients to get them to be their patients. Let's go to the next slide. So here's the analysis. This is where, and hang in there with me. Hopefully this is all making sense. It's complex, dense stuff, but it could be very important to you if you're conducting a trial and you want to subsidize subject enrollment costs. So the government starts out in their opinions. You can go online and read this opinion. And they say, hey, this doesn't meet a safe harbor. So now we'll look at whether it's going to drive over utilization, distort competition, distort physician thinking, decision-making, distort patient decision-making, etc. So the government said the subsidies outlined in the proposed arrangement are a reasonable way to promote socioeconomic diverse study subject enrollment and retention. So that's a plus. Okay, second, the company they like that the company's going to offer the same subsidies to subjects with Medicare or commercial insurance. We talked about that earlier. The payments made to the site and the institution, not the beneficiary, not the healthcare professional directly either. We could add that. And the proposed arrangement has a low risk of overutilization and inappropriate billing. They give several reasons for that. Because the company won't advertise it, because there's informed consent with the patients, they know what they're getting into. There's IRB oversight and monitoring, and the enrollment is capped at 260. A lot of times in these types of advisory opinions, the government likes these programs to be limited, something to think about anytime you're worried about violating potentially the AKS. What's the scope of your potential program? And then the last thing, number 5, that it's not a seating arrangement. So seating arrangement means I'm a device maker, a drug maker, I'm going to give free stuff out in order to get people hooked, and then later the government will come in and start paying for it. This is a one-time use device. Let's go to the next slide. Okay, so the conclusion, the OIG says it presents minimal risk, fraud, abuse, and in its discretion, it's not going to impose sanctions. So hopefully that's helpful. You know, there are some more facts in the advisory opinion, but we've had several clients that have looked at, you know, subsidizing some arrangements. It's been kind of tough to analyze because we didn't know what the government thought of that, and now we have this nice advisory opinion. Let's go to the next slide, Chris, and I'm going to try and run through the last of these slides so we can get over to a break and then hear from Amanda. So again, while developing this presentation, I tried to say what are the most important things I want to convey to the audience. What are the most risky things associated with clinical research? Well, bribing people, you know, that's one of the keys. That's why we just hit this advisory opinion, and now I want to talk more about the avoidance of violating the anti-fraud laws. Paying people at fair market value, paying institutions to do the research is critical. You'll want to attempt to meet the personal services and management contract safe harbor. I say attempt because it's going to be difficult, because one of the elements of that safe harbor says that you can't pay based on the value or volume of referrals or purchases. And if you're going to pay more for more enrollees, then I'm not sure that safe harbor element's met. So you'll want to attempt to meet it nevertheless. Obviously, paying for research is very common, and it's not something the government is interested in prosecuting unless it's, you know, bogus research, for example, or it's overpaid, or it doesn't meet other elements of the safe harbor. So pay at fair market value. You can't pay for research because you like a customer. Hey, that's a KOL. Let's sugar them up with a bunch of payments for some research we really don't need. That's inappropriate. So your grant making function, your clinical research function should be divorced from your sales and marketing people and anybody else with a commercial hat on. We audit companies all the time. Sometimes we go into companies and do a healthcare compliance audit, and the clinical VP reports to somebody that's ultimately overseeing commercial. I don't like that. I don't care what you call them, GM, head, whatever. If their job ultimately is to sell product and they're in charge of clinical research, I'm not a fan of that arrangement. I'm going to call that out in my audit. So get the sales and marketing function away from research. You know, there are times that they can help make introductions or go and check in on a site. Maybe there's some information that needs to be, something basic provided to them, but they should not be involved in decision making absolutely when it comes to deciding who's going to research what or make payments. You got to get them out of that equation. Some other tips, go through your budget meticulously. What is every line item on there? A lot of times you see some things buried in there. I'll look at a budget and I'll see, a bonus for getting more subjects. And we're going to talk about that on the next slide. That's not something that should be in there. Something that's often overlooked, how are you basing your budget? What are you using? Medicare rates as a starting point, or have you got Grant Pro, which is like data you can purchase and have access to? How are you basing your payment rates? There should be some sort of benchmark that you're gauging off of. Maybe you can go higher, but how high are you going to go? you might be working with UPenn and they'll say, I don't know exactly what their overhead is today, but I want to say one year I was working with them and it was like 40%, meaning we're charging overhead. You'll see that now at these big teaching hospitals where they know that you want their name on the masthead of the publication that you're going to have out. And so they're going to charge for overhead, which I've debated that with attorneys at different hospitals, and we say, you want 40%, we're not going to do that because I think that this could be a kickback and we're going to have problems and you're going to have problems. It's sort of a ripe issue, frankly, that hasn't really been challenged by the government. But be careful with those overhead payments. I kind of was teasing one attorney once, I remember, and I said, what do you mean overhead? Are we paying to keep your lights on? Like, just, we're paying for research. I'm not responsible for all the services to keep the hospital open. Again, carefully draft your budget, look it over. If you have triggers for payment, you're paying in tranches. Sometimes you'll see that more with like investigative initiative trials. Then, make sure the milestones are met before you release another tranche. With a typical CTA, if you're doing an ID or IND, you're not going to have a tranche arrangement. It's going to be all itemized. Let's go to the next slide. Patient enrollment incentives, bonuses, bounties, spiffs. What do you think of these? I didn't want to out anyone, but this would have been a good question to have to poll the audience. How many of you, because we have a lot of people involved in research, are paying bonuses, or they're called bounties or spiffs? Whenever clients call me and ask me, can we pay more money? Can I send somebody on a trip that works at the investigator site when they get, up to 10 people? Or can I give them just cash, an Amazon card or whatever? My answer is always no, don't do that. That's not, it's something that is out of vogue. I know, and I always hear my someone that worked at another company did this, blah, blah, blah. And it's like, yeah, first of all, it's hearsay. Second of all, name the big company out there, chances are they've been in trouble. So that's not compelling to me. To be clear, the AMA says, quote, offering or accepting payment for referring patients to research studies is finder's fees is unethical. Some states embody the AMA rules into their laws, like Ohio. So just, be mindful of that. And then guess what? Do you think hospitals follow the AMA rules? Yeah, most of them will embody their rules as well. So don't pay bonuses. What can you do? Pay more to get some more people working on the enrollment activities and pay them fair market value at arm's length. That's okay. All right, I'm going to wrap up here pretty quick. Let's go to the next slide. And I'm going to just really summarize this. You all have the slides. FDA requires that you report 801 of the FDA's Food and Drug Administration Amendments Act 2007. You have to report clinical trial results. And the FDA is getting pushed by consumer protection groups to make sure that sponsors are indeed publishing their research, and they're starting to send letters out. So Ocugen got a notice of noncompliance. A lot of other companies have gotten these as well. I'll just read here a little bit so you can appreciate the law a little more. A responsible party for an applicable clinical trial is required to submit to the clinicaltrials.gov database certain results and information for the clinical trial. This must be generally submitted no later than 1 year after the primary completion date. Okay. So you got to get this stuff in. Let's go to the next slide. And this is a pretty contemporary notice of noncompliance. This is just last month. So, this company is facing fines and bad press now. So they've already got the bad press part. Now they're facing fines. They were supposed to post by May 15. I'm not sure if they have yet or not. But yeah, there's 40 other pre-notices of noncompliance that were sent out, and even by the FDA, and some were even sent to the principal investigators trial. So, do you want your PI mad at you? Hey, now I'm getting letters because you guys haven't done your job. So just be mindful of that. And I think that's it for me. I do have one more question maybe before we cut off. Let's go to the next slide, Chris. To poll the audience, after what we talked about with that advisory opinion, is covering certain subject costs something your organization may consider? I should have probably asked that before and after, but maybe Paul, what do you see in the audience there? And if the folks at home online could also respond, that'd be great. So yes or no, is covering certain subject costs something your organization may consider?
So in the audience, there's a couple of hands up. They're kind of back and forth, kind of a maybe. So, certainly something to think about, but not a strong agreement that, yes, that's something they're going to do.
Yeah, you have to go find that money somewhere, right?
And there's a question. I'm going to walk the microphone to you.
Okay, great.
And just real quick, online, let's see, 84% say yes online. So a much different response online than in the room.
Yeah, when we're doing a study on a device and we're providing the device free of charge because it's a non-commercial device, number one. And then number two, we're reimbursing the facility for the lab tests that are dictated in the protocol, even if they're standard of care, because we're dictating at certain specific time points, we're reimbursing for those lab. So with that, is that just kind of okay?
Do you have any, is the product being or service being reimbursed by the government? Like, I think you said it was a device. Do you have category B or A reimbursement?
It will need to be applied for CMS approval, yes.
Okay. So, if you didn't have any reimbursement, then arguably the law doesn't apply, right? Because you wouldn't be asking the government to pay for anything. There could be an argument for pull through for other products and services you offer, but generally, it's not uncommon, as you know, for companies to pay for everything. And you have a lot more discretion then, but you should still follow all the rules we just talked about and good clinical practices, obviously. If you do have category B or A just means the device isn't paid for, but the services are, then you want to basically walk through that analysis that we just went through. That advisory opinion will be very important for you to determine whether or not you can cover. I didn't hear you say any subject costs. You were going to give the device away for free, and then you were going to pay for some diagnostics.
Right. We're not providing any payments to the subjects. In fact, we're applying for CMS approval so that they will go, Medicare will pay for the standard procedure because it's just our device that's used in a regular procedure. So all we're providing is the device. So the patients are not getting charged for the device itself. We're not paying for anything else that happens in the procedure. And then lab tests pre and post procedure that are required by the protocol at certain time points.
Yeah. So it'll become a fact-intensive analysis as to whether or not what sort of reimbursement you get. If you apply for category A, for example, and not B, I think that would help the facts. What you wouldn't want to do is apply for category B, which then says, hey, CMS, pay for this device that we're giving away for free, because then the customer would be the beneficiary of that. And then as far as the diagnostic test goes, I feel like there's probably, I think the prospects are good for that as well, but it comes down to a fact-intensive analysis. And I guess that's just a bit of a disclaimer to give today that I didn't give at the beginning of the program. We're happy to give some feedback to you, but if you're seeking legal advice, so talk to your lawyer or come to us and we can talk about how we can provide legal advice to you. But not trying to escape the question there, but just want to give that disclaimer. Any other questions? All right, good, because
we got another question really quick, and then I'm going to go back to one more question, then we'll do a 10-minute break.
Okay, good. I was getting question envy there because you guys got so many.
Just a quick one. The study product itself, you didn't mention anything about setting up a retrieval program to make sure that you got any leftover parts, or if a device fails, how you get it back, setting up a retrieval kit, and it, for example, so that you're not shipping hazardous materials around. Are there strings that you can attach to your study product so they don't go floating off to your competition?
Absolutely. Yeah, and that's that one category that was under product that was on that chart. Unfortunately, since I only have 30 minutes, I can't really get into all that detail, but you raise an excellent point that you'll want to have some terms and conditions around the study product, what it can be used for, what it can't be used for, what happens to it if they're not used up. You're going to want to get them returned. They can't resell them. Your T's and C's will also want to get into, that there's no warranties with it. If there's a defective product, you're merely going to replace it. You're going to want to have a bunch of clauses like that in the contract. So that's a very good point. And you kind of have all of that negotiated in there. And in fact, you should probably have a clause in there about what you just described. And that would be under the confidentiality aspect too, where your competitors cannot get a hold of these devices. So all really good points.
All right, we're going to take one more question, then we'll break.
In the CTA, you were talking about having the signature block, and you wanted the PI and the sub-I sign the signature block in the CTA. What if, and this is what I have had done in tons of other studies, the PI actually signs the main CTA, but then you have investigator agreements that all the sub-Is have to sign. Is that still okay?
I like that. Yeah, and a lot of times you'll even just have in that block like a read and understood, because you want to think it through with the PI. Are you going to include the sub PI in throughout the entire agreement? It just gets really complicated to have so many parties. So typically what you'll do is either have the sub PI sign off on something like you just described, or you can even have a read and understood at the end, but they may not be, are on the hook for everything within, although I'd argue they would be. If it were ever, if that were ever litigated, I think that the sub PI would have a hard time saying that the agreement didn't apply to them. But the specific elements within the CTA they generally describe the PI, and then they will not also, get to the sub PI level.
Okay, and then just one quick other one. When you were talking about incentives and bonuses, what I'm finding from a lot of clinical sites now is they're requiring payment for screen failures. So does that fall under a bonus or something like that?
I don't think so. I mean, if they're screening people and they're just not candidates for the trial, I think it's okay to pay them for that time.
Okay.
I don't see an issue with that. I mean, you'd want to make sure that they're being truthful and honest, and that they're not just pulling people in that are clearly unqualified for the trial just to try and drive revenue. But I don't, most of these institutions that perform investigation don't have time for that kind of nonsense. So yeah, no, I like what you described, though. I think that would make sense.
So we do have one more question online. So I think these questions are an important part of the program. So we're going to cover this last question. It reads, we cover all costs for our clinical trials and include patient stipend for their time and travel, but the device is available commercially and covered by insurance and Medicare. Do we have to comply with OIG 522 opinion?
It's going to be different. That sounds like an interesting one. Did you say the device is already approved?
Correct. It's available commercially. So I'm assuming, yes, approved, cleared.
Okay. So, yeah, one of my questions would be like, is it being reimbursed? And, if they're paying for everything, that shouldn't be. So that'd be a red flag. If everything's free to the patient and the site's getting paid, and then the site's ultimately billing back to Medicare, Medicaid, or other federal payers, that would concern me. So, I mean, it's a pretty fact-intensive question, so I'm not sure I can provide an answer to it right now, but those are some of my thoughts off the top of my head.
Okay, thank you. That's the questions for now. Let's take a 10-minute break. We'll meet back just a little bit before 11 and resume. Thank you.
Thanks, everybody.
All right, welcome back, everybody. Good morning. My name is Amanda Johnston. I'm a managing attorney at Gardner Law, and I am going to talk about submissions. So everyone's a fun topic, FDA submissions. And I won't bore you with my bio, but I've been doing FDA submissions for 10 years. So I have, over 100. I don't keep count anymore, but lots of different types of submissions, drugs, devices, annual reports, change control, all that fun stuff. So we'll talk about tips and tricks, and we'll get into it. So we're going to talk through kind of steps to a successful submission. And we'll try to throw in some anecdotes about, kind of what works, what doesn't work, what we've seen, what I've seen over the years. We'll talk about enforcement mechanisms. So, after you get a clearance or approval, kind of what things to continue paying attention to. And then we'll also wrap up with just some more tips and best practices. All right, so a lot of the times we'll get clients that will come to us and they'll say, okay, I need to submit a 510K, like here you go, here's our device. And, we'll say, okay, we'll have to make sure that the classification is correct, you're submitting the right type of submission, do you have your design history file done, like all these kind of things wrapped up, and they'll say, huh, what's that? So just wanted to kind of walk through what the steps should look like, or ideally would look like. So really, this should happen early on in the device development process. We should be thinking about, what does the device do? What do we want to say about the device? And then also just things that we don't want to forget kind of in those discussions. So when you're, designing the device, look at the intended use, which Jesse and Nate talked about. Indications for use, as you know, that's critical as you market your device, and that limits kind of what you can say and what you can't say. And that does come into play from an enforcement perspective as well. So what do you want to say about it? So everything that goes in your labeling, you'll submit that to FDA as well, and there may be some back and forth, but just having kind of a clear, agreement amongst the team on what you want in the labeling and what do you want to say about the device, so that what you want to say actually makes it into the labeling. And then, most importantly, marketing claims. So what are your sales reps going to say? What do you want them to say about it? What do you not want them to say about your product? And just some things so you don't forget these considerations, but again, like thinking ahead about desired claims, and then limitations on claims that can be made based on your indications and labeling and what's in your label. Voice of business. So a lot of the times we'll see companies, not have the planning ahead of time when it comes to reimbursement, which can be, a huge challenge once you do all the work, you get clearance, you get approval, you launch your product, and then you realize that there's no reimbursement. So that can be a challenge. And a lot of the times reimbursement will tie back to the intended use or the indications for use. So just making sure that you're kind of thinking about all these things, and you have a team that's at least focused on the different aspects. Legal, IP, marketing, we want clinical involved as well. Business strategies, so thinking of competitors and just the industry, and kind of thinking of all those things as you're defining your device first, before we kind of jump ahead to the submission piece. And then, of course, patients and users, that should be kind of the voice of customer consideration going into your device and submission. All right, so step 2, regulatory classification. So I think step 1 and step 2 are probably done in parallel a lot of the time, but just kind of for sake of steps here, we'll talk about classification next. So you want to make sure you get this right. As a lot of you know, there's 3 classes of devices. They are risk-based, so class 1, class 2, class 3, and what class you fall in dictates the submission type, and then also kind of what controls you need to have in place, from special controls, whether it's special controls or general controls. There's a lot of different device types, and I don't know if you guys have looked through the database, but some of them are very similar, and they just have nuanced differences in the definition. So it's really important to do kind of your homework on that classification database and try to figure out exactly where your device falls. And sometimes it won't fall perfectly in any, and we'll talk about some options when that scenario comes up. So yeah, I just put the FDA product classification database. I use that all the time. I'm a nerd, but I'm on that database probably every day. There is a 513G request for information process, so if you really are not sure how your device should be classified and you want to have that advanced discussion with FDA about it, there is a method for doing that. You submit and then you get feedback in return, and sometimes they'll say, we don't know, you might have to go to OCP, the Office of Combination Products, or they may say you'll have to, submit an RFD to CDER, for example, the drug branch. FDA also has an email address, which I don't think a lot of people know about, but it's DICE at FDA, and I think it's Division, Tim probably knows, Division of Industry Consumer Education, I think. You can email them, and they will write back. And I've actually had them call me back the same day. But it's intended to be a forum for just industry consumer questions. And so I have actually sent, I don't know, maybe 3 or 4 times in the last year, sent kind of informal emails about classification. And they've gotten back to me, and I think one time they called me back within an hour or 2. So they may not be able to give you firm, like, yes, you're good to go, but it is another avenue that I feel like not a lot of people know about. All right, so step 3. So let's say we've defined our device, we have determined our classification, and now we are writing the submission. So just a lot of this, maybe common sense, but I just want to highlight some reminders. So make sure you're using all the tools and resources that are available to you. There is a ton of guidance, and I still find guidance every day that I didn't know existed. There's just a lot out there. So make sure you're doing your homework, even it's Google or looking on the FDA website for guidance. Always follow the guidance if it's available, and if you're not going to, if you're choosing or electing to do something different, make sure you're putting that justification in the submission. Look at consensus standards. FDA has a lot of checklists for submissions that are very helpful because that should literally be your kind of guide as you're submitting or filling out your submission or completing it. Look at all the other device, so 510K summaries are a good example of, where you can kind of do your homework on competitors. And again, that's not the full 510K submission. I think that's a misconception is what's on the website. A 510K summary is not the entire submission of what they submitted to FDA. It's a summary. So, but that's also important to look at. You can usually get some good information about, what testing they did or kind of what strategies or what standards, that kind of thing. So that's really helpful as well. FDA has a ton of webinars, modules, kind of just go out there and see what you can find related to if you have specific questions. And that DICE email address would be a good resource as well if you have specific questions. We'll talk a little bit about pre-sub. So I feel like they get a bad rap. Everyone's always like, oh, we don't have time for a pre-sub. We just got to submit. We have to get it in, next month. But we'll talk a little bit about the pros and cons of doing a pre-sub, but that's an option as well. And then there are I just wanted to mention that, of course, FDA has the Breakthrough Device Program and then the STEP program, which is similar. So just consider those. That would be done before you, submit your pre-market application. But it does give you kind of a little gold star from FDA's perspective. So theoretically, you should get some priority, a little bit more hand-holding in the process. And they do have a little bit more flexibility around having sprint discussions and pre-sub meetings. So that it is helpful. When you're, compiling the submission, there's different strategies that people take. Sometimes one person will write the whole submission and then, have people provide input. Other times, they'll break it up into different, like, quality takes this piece, software takes that piece, and then kind of compiling it together. There's not really a right way to do it. I would just caution that somebody reads through the entire submission and is able to kind of point out where there's gaps or questions and kind of make the story flow. And I do think of it like a story. When you're submitting and you have you're going through the device description, it should really flow like a story so that the audience, which is FDA, is able to kind of understand all the pieces, and they should be able to pick up sections, and it should make sense even if they haven't read the entire submission. Remember spelling, grammar, formatting, all those things, that all counts. We want it to look professional. We want to make it look like we are, competent and know what we're talking about. I've seen a lot of sloppy submissions. And I mean, I don't know. If I was FDA and I received, a submission with spelling errors and spacing is all wonky, it's an impression, and so we want to convey professionalism and expertise and competence. So just reminder. Use their checklist. So like, for example, the 510K refuse to accept checklist. Use that, have it literally next to you as you're writing the submission and then as you're, creating the e-copies. All right. And then just kind of a quick overview, and this is a kind of in order of, fastest to longest in terms of device pathways to market. But yeah, exempt devices, so those that would not require a 510K. We have the EUA, which has kind of been hot the last couple of years, but it's been around for a long time. The 510K, and then the de novo and the PMA, so you can kind of see how the days get longer and longer as we get more complicated, and so does the user fee. So I just updated those, and I can't believe, what is the PMA at? 374. That's crazy. But yeah, this just gives you an idea of kind of what it looks like. All right, so I'll touch quickly on just a couple of the submission types. Many of you are probably familiar with them, but we'll chat about them quick. So a 510K, it's also called a pre-market notification. So it's mainly for Class 2 devices, some Class 1 devices, just a few that we've run into. But essentially, you're demonstrating that your device is as safe and effective as a predicate device that is already on the market. And it could have been cleared on its own 510K, or it could be a de novo device. But you're essentially demonstrating substantial equivalence. That's kind of the key term, and we'll talk about that a little bit more. 510Ks have a 90-day review period, so they're usually, typically when companies, have a device, they want a 510K because it's quicker. But there are, some advantages and disadvantages with having a 510K versus a PMA or doing a de novo, and we can talk about that as well. So it's 90 days, but the FDA review clock will stop if there are issues. So if there's deficiencies, we'll talk a little bit about some of the acronyms that come up with deficiencies, but the clock stops and you want to respond quickly so that you can get the clock started again. All right, and then there are special controls guidance documents that cover certain device types. So again, just make sure you're considering those and reviewing them as you're putting your submission together. All right, so what is substantial equivalence? So I pasted the actual text here, but we won't read it all. But essentially, we want to prove that our device, if we're trying to prove substantial equivalence in a 510K, that it either has the same, so we want to either prove that it has the same intended use and has the same technological characteristics, or it has different technological characteristics, but the data submitted demonstrates that your device is as safe and effective as the predicate device and does not raise different questions of safety and effectiveness. It's a mouthful, but essentially it's an either or, and honestly, it's usually the two on here where there's a little bit of a difference, but we're trying to demonstrate through submission of data and testing that there is no new question of safety or effectiveness. So just a refresher. All right, and then I had mentioned, sometimes you'll look in the product classification database and you won't find a good match for your device. And this is especially true for novel devices or devices that, there may be a predicate that kind of fits, but it's, we can't overcome that no question of safety or effectiveness threshold. And so then the de novo classification process is one of the options that's available to us. So in the absence of having a device classified, FDA automatically classifies it as a Class 3 device. So if you have a brand new product type that FDA has never considered, they're going to say it's a Class 3 and you'll have to submit, you can't market it. So the de novo classification process is actually the manufacturer submitting a request to FDA asking them to reclassify your device as a Class 1 or 2. And so as part of that process, there's some negotiations in creating the special controls because they would actually create a new regulatory classification for you. So it would be specific to the product type or your device type. And so if they do grant it, you can market the device, and then it actually does create a new classification type for that product. One thing to note, and there is some kind of strategy that you can use in de novos. It's kind of nice because you are setting the stage for future competitors that come along. Future competitors can use your device as a predicate, so that's, it kind of reduces the barrier to entry from that perspective for competitors, but they would have to meet all the special controls that you helped establish. So, yeah. Let's see, is there anything else? Yeah, so if they decline and if they say, no, we're not going to accept your de novo classification request, it remains class 3 and you'll have to probably seek out either a 513G or have, pre-subs with FDA to try to figure out how to submit it if it's a PMA. All right. Okay, we'll talk about pre-subs. And again, I think I mentioned a lot of people are like, nope, don't have time for that. It's a waste of time. I have to submit tomorrow or yesterday. But I just wanted to kind of talk through some of the advantages and disadvantages with doing a pre-sub. So you'll want to make sure that you have specific actionable questions for FDA. So, asking open-ended questions is probably not a good tactic to throw to FDA. If you do that, they'll probably send you back a ton of information or feedback, but it may not be helpful and it may not be what you're looking for. And then also you're stuck with having to address all of these questions that they raise, and you feel like you're obligated to close out some of those. So make sure, if you do a pre-sub, and there are certain questions that are, really helpful for pre-subs that are focused, specific, actionable. I like to think of like the SMART goals type of things. So just making sure that you're thinking about what types of questions would be good and what probably would not be as beneficial. It's a good opportunity, it can be a good opportunity to get some, informal buy-in from FDA. It creates a record with FDA so that you have, an official, you have meeting minutes, you have a submission and a feedback that you can, use as you proceed down the path to pre-market submission. It's a good chance to interact with, usually it's typically the reviewer that you'll probably work with in the future, or at least they'll be involved, or that branch. So it is a good opportunity to just, get on the phone with them, get some feedback. A lot of the times you can sneak in questions or little things that you may want to get across, but didn't want to specifically include a full question on it. It depends on the reviewer. I was just part of a pre-sub a couple weeks ago, and it was incredibly helpful. Like, we wrapped up our questions, and she was willing to entertain, multiple off-topic questions, and she was just kind of like, yeah, you can't quote me on this, but I'll give you my feedback. So it is just that part of it is really helpful. There's no user fees, so that's nice. You don't have to pay for it in terms of submitting money to FDA for that. And then if you use it properly and you're scoping your questions properly, it probably will save time and money in the future. If you're going down one path and then you change decisions based on the feedback from FDA. But again, you want to make sure your questions are scoped such that you're getting feedback from them that will help you make decisions on paths forward. If you just ask open-ended questions and they give you a bunch of other questions back, that really doesn't help you, and so that probably won't save time and money in the future. I really like that you get written feedback and you can have the teleconference rather than one or the other. I've never opted to forego a teleconference. I would always encourage to take them up on that. Even if it's one question and they answered it, I would still try to get that time with them. All right, disadvantages. I mean, people always say, I don't have time, we want to submit yesterday. It's going to take 60 days to get a meeting scheduled, that kind of thing. But it is something that I would encourage teams to think about early on in the process so that they can budget time for it. Because FDA, they do like pre-subs if they have time for them. With COVID, We've seen, sometimes they've been denying them or just saying like, sorry, we don't have time, but I still would encourage companies to try to get in front of FDA for a pre-sub, even just doing that and showing them, then they'll have the submission, so that's helpful. Some other disadvantages, it doesn't always resolve all your questions. It doesn't always, answer everything you're looking for. And a lot of the times with their feedback will be qualified, as in like, hey, this looks good, but we'll have to see the data first. Or, this is not binding, but here's our feedback, or here are things to consider. So it's not always like yes or no. Actually, it's never yes or no. They usually say that looks reasonable, or that appears to be reasonable testing strategy or something like that. So yeah, along the lines, feedback is not binding. It's not. They can change their mind. It's tougher for them to change their mind, because then we can bring up, hey, look at these meeting minutes. You said X, Y, Z, and now you're changing your mind. Like, why is that? But again, it is not binding, so it's just something to consider. Teleconferences are typically limited to 1 hour. I don't know if I've had any recently that have been more than an hour. We've tried, and they just say, nope, sorry. But I might as well give it a shot and ask for an hour and a half or 2 hours if it's lengthy questions. And then just another disadvantage is it's limited in scope, number of questions and topics. So you can't just put 20 questions down. I think in their guidance they say like 2 or 3 or 1 to 3, which I think is a good amount for an hour teleconference, especially if it's really deep subject matter. Maybe limit it to 1 question. All right, so we've defined our device, we've submitted a pre-sub, had a discussion, we've classified, and now we have put our submission together and we are going to submit. So these are just kind of logistical things, but can't have to mention them. So make sure you remember to pay the user fees. This actually gets forgotten sometimes, and then we're like, oh wait, did you pay? It's kind of an administrative step, but they won't accept it unless you pay the user fee. So it will delay it if you submit it first, and then then the user fee gets submitted. So just a reminder, if you'd like to take advantage of the small business program, which if you aren't familiar with that, FDA has a small business designation program. You submit some tax records. I think it's like 100 million or less in revenue is a small business according to FDA. So you get lower user fees. So it actually does save quite a bit of money. I think I had the small business fees on the chart, so you can go back and take a look too. But yeah, like 510Ks go from 13,000 down to 3,000 for a small business. So it's something to think about if you're eligible. It does take time. It takes about 60 days to get approved. So just make sure if you're going to do that, submit in advance so that you have that. The e-copy process. I don't know how many of you have actually done the e-copy process. It can be challenging. So when I worked in industry, we had a regulatory operations team, and I did not realize how helpful they were for a lot of these like logistical administrative things. It took them for granted, and now I want to go back and thank them for helping with all that, because it can be really tricky. I've had some e-copy holds because my USB had like hidden files on it. Now I have a process down, but it can be tricky. So it's not something you want to start like the day of submission. It's something that you'll want to probably practice and try a couple times. And you do literally still, they call it e-copy, but you have to burn it onto like a disk and then go to the UPS. And so it's not really electronic, I'll say that. But and they will they'll put you on an e-copy hold if it's not done properly. So it is something that you'll want to think about. And then once it's we sent it, we did our e-copy validation tool, so everything looks good. They accepted it at FDA. Submissions will go into an administrative review or an acceptance review. And that's when they're looking to make sure that it is administratively complete. So they have all the elements they need to actually start the substantive review. It's usually 15 calendar days. I think it's 15 for 510Ks. And then, once you pass that, you'll go into the substantive interactive review. And that's where there's some back and forth typically. Sometimes they'll move you from, I'm trying to think of scenarios, but they'll move you into interactive review. And so then theoretically, there's more interaction versus just sending information. Interactive is more kind of like a real-time, trying to resolve questions quicker. I don't know if any of you have used the new submission tracking portal that FDA has. It's pretty cool. I mean, it helps you count days, basically, so you don't have to sit with your calendar anymore. But it is pretty nifty. And just some things to consider, while your submission is under, on FDA's desk and they're reviewing it, try not to take risks in the marketplace. Don't start promoting. FDA will probably Google your company and your product, and so if you have your website, already, published, that could pose problems for the review. And so just, that's a time to kind of stay under the radar still and just kind of stay the course until you hear from FDA. And it's likely that you will get questions, deficiencies. I'm trying to think of if I've had any submissions recently without questions or deficiencies. I mean, it's just almost standard that you'll get at least some questions. May not be deficiencies, but could be, additional information, letters, stuff like that. So don't be surprised. That's very typical. Although I think, Nate, you got one without questions, didn't you, recently? Yes. I know, it's always like, it's fun when that happens, but. Okay, just some alphabet soup on things that we hear back from FDA on 510Ks. So RTA, if you hear that lingo, that has to do with the refuse to accept checklist, which again, I referenced the checklist earlier. So if FDA reviews your submission, and again, this is kind of the acceptance review before they start looking at the content, and they decide it's not complete from an administrative perspective, which means you probably missed something on the checklist, they will send you an RTA letter, which is the checklist with some explanations, telling you what is missing, and you want to respond to that as quickly as possible. Again, you'll have to do an e-copy, so that's timed, so think about that. Again, another reason why the checklists are so important. You want to make sure you have everything covered so that you can avoid that back and forth. AI letter is a request for additional information. So this is while you're in the actual substantive review. So you're in the substantive review. They have questions about really substantial equivalence or any of the data that you submitted. So once they've actually looked at it, they may come back with questions. If you get an AI letter, it's on hold, the submission is, until you respond back to them. And they usually give you 180 days, which it seems like a long time, but sometimes, depending on what they're asking for, they could be asking for new testing. And so then it's kind of trying to figure out if that's possible. And then NSE and SE. So SE is substantial equivalence. So you'll get either an NSE letter or an SE letter. If NSE means basically they did not find your product to be substantially equivalent. That's considered final action, so your submission is closed. So then you're forced to try to figure out, do we submit a de novo? Again, you're kind of going through the pre-sub route. Again, why it's so important to really get that classification and the submission pathway right the first time. All right. So these are just continued compliance, and Nate and Jesse talked about this extensively, so I will not repeat, but just kind of follow the rules, make sure you're staying in the clear once you have clearance and approval. Because if, as Nate and Jesse talked about, if you're not following the rules, FDA will, probably deem your device to be misbranded or adulterated. And then the enforcement mechanisms. So I listed out, everything, but really all of them are business disruptors, and all of them are probably going to disrupt sales and marketing and regulatory. There's a lot of really bad things on here, but even, a 483 or a warning letter, that's a huge deal for a company, and from a PR perspective as well. So just things to think about. All right, so we're down to kind of best practices and tips, and I try to distill it, but I have a ton of information that I was trying to convey here, so if I, feel free to come up to me during lunch or breaks if you want to chat about submissions. I know, nerdy, but so again, get the classification and the submission type right, get a second opinion, if you need to. We have, a lot of clients come to us that, they're pretty sure, but they want us to do a second look, and then we'll, prepare a memo for them so that they can have it. They may use some of that justification for a pre-sub or a 513G. Really study the paths and submissions for similar products. So sometimes you'll have a same kind of type of product, but it will be in different buckets. Like we had a situation where there were like 5 product codes that it could have been, and we're trying to figure out, strategically which one works best, but then also from a business perspective, what do we want if there's some leeway there. So really putting the time into kind of doing your homework on those paths and find the most appropriate predicate. Again, that's a big deal. So we want to get that right. And if we're not sure, we can ask FDA too. Consider using the pre-sub process. It may save time and cost in the end, especially if we're, focusing our questions, being strategic about what we're asking. Read and follow guidance as closely as possible. If you deviate, provide an explanation up front. So that shows both that you have, you read the guidance, you understand FDA told you to do something and you're not doing it, and so you want to explain why, because that will eliminate a question. And hopefully they will agree with your justification, but if not, at least it shows that you proactively thought about it. Don't make FDA ask for something. I feel like this kind of comes up as a submission strategy where you just throw it over the wall and kind of just hope that they don't ask. They usually do. And so just, thinking a comprehensive submission, if you think they're going to ask or if you know it's required, submit it. Don't make them ask. And I know there is some kind of strategy with like testing, for example. Sometimes we'll submit at risk waiting for testing, or they'll be doing testing at the same time, kind of knowing that FDA might ask for it. That's, definitely a discussion that can be had, but if it's something that's plainly required, I would not recommend leaving it out. Again, e-copies, find somebody who knows what they're doing. It's not something you want to do the day of submission. Working collaboratively with your team and FDA. So if you get questions and, if you get questions and you have to go to team members to ask, like say it's a clinical question and you have to go to clinical, don't show, I'm trying to think of a good way to say this. Like sometimes there's like disagreement amongst the team, and we want to be very clear with FDA that, you're on the same team and you're trying to help FDA do their job. So just being collaborative with both your team and whoever's, on the email chain and communications and FDA. Try not to be defensive. They may be asking questions that you think are ridiculous, but, try to just, again, we want professionalism, experts. We want to be viewed as being, obviously competent and calm, rational people. So if issues come up, so this, if there's an impasse or a disagreement, this has come up a lot lately, especially with just timing with COVID, and timing is more of the essence when they're already delayed on things. But work with the reviewer as much as you can. Some are better than others about being flexible and accommodating and kind of going into that interactive review. Escalate to management as needed. So if you're really not getting anywhere with the reviewer or the review team, you kind of escalate. Make sure you're keeping email communications and kind of notes from when you called or tried to call. That's helpful. Using the ombudsman. So we've actually used the ombudsman quite a bit lately, just with timing and helping with that kind of thing. They're helpful in that they go and they talk and then they come back and give us an update, but they're not going to make any decisions for you. They're not going to, magically, solve the problem. And then if you really are at an impasse, and again, there's an appeal process, but it's only on final action. So you can explore requests for supervisory review. There's the CFR. It's a process, but it is if you truly have an issue that you think needs to be appealed, and this would be a final action, so what an NSE letter, an SE letter, a not approved letter, there is a pathway for that. All right, and I'm wrapping up really quickly. Watch-outs. So again, failing to submit or submitting inadequate documentation. So again, if you don't have any design controls, probably don't submit. FDA is going to come back and issue an AI letter. Don't delay in responding to FDA questions. Try to get back to them as quickly as possible. Usually they ask for a quick turnaround, like 1 or 2 days. So just be mindful of that. While it's under review, having a plan for who's out of office and who could respond if needed. Yeah, just watch out. So if there's no suitable predicate, if there's product code issues. Again, e-copy process. Can you tell the e-copy process? I've had some struggles. Planning for ongoing regulatory support. So, once the submission goes in, you get approved, you clear it. Unfortunately, it doesn't end there. There's change control, there's annual reports, there's, MDRs, there's lots of things that you need ongoing regulatory support for. So continue to, plan for that, have somebody available. And you probably will have to submit a new 510K and down the road. Rushing submissions is not a good strategy, and that just goes back to kind of thinking through getting it right the first time and avoiding delays. On the topic of delays, so we're still seeing COVID delays. With pre-subs and MDUFA guidelines, I think it's a lot of, it's still a thing. I'm hopeful that it will, eventually start to get better, but for now, and there's not much you can do, unfortunately. So unless it's, you could use the ombudsman and try to get it hurried up, but they'll just say, sorry, we're short on resources. So and so got reassigned, so it's being prioritized. Is basically how they respond. So, all right, that is all I have. Any questions?
Yeah, so a quick question from online. Are pre-subs or pre-sub requests on the public record? And then if they are, what if they want to stay off the radar of potential competitors?
They are not, am I on? They are not public record. So they could submit a FOIA request, a competitor could, but that takes a long time, and then it potentially would be redacted, or you get a chance to redact it. But no, they're not public record. Yeah. Jump over there. Sorry, he's going to get the mic.
I'm sorry. So, yeah, just a quick one. I'm struggling with something. I'm struggling with something for the client, right?
Okay.
We need a pre-sub. I'm like, you don't need one? I can't see what specific question you want to ask.
Yeah.
There's a predicate I could use and have an additional feature.
Okay.
Right? But there's no great reference device. And so I'm like, but I know what they would ask you to want to see, so I think we'll try the 510K. And how many times have you run into that? Because I don't want to tell them they have to.
I mean, often actually,
or
people
do a de novo. I wouldn't recommend either.
Yeah, I mean, I think some companies, I don't know, which is better, I think they assume you have to do a pre-sub. And no, you don't. Don't do it if you don't have specific questions that you need FDA's feedback in order to make a decision on next steps. So, yeah, there's always that kind of weighing, do we just go for the 510K and take the questions then, or do we have truly actionable questions that we need feedback on before we can move ahead? So I run into the same thing, and it really is kind of a business, how much risk are they willing to tolerate, kind of what their timeline is, that kind of thing. Oh, more.
You had up the timeline for the devices for 510Ks, PMAs. Do you have that data for NDAs and BLAs?
I don't here, but I do at my office. You can email me. We also have a database that is awesome. I don't know if any of you use Basil, but they have real-time review timelines, which is awesome. I'll put in a plug for that system because it's awesome. Yeah.
One thing that happened recently for us is COVID actually had a benefit for us because we didn't know. A reviewer that we were working with hinted just as we were approaching 180 days and the client didn't have everything finished.
Yeah.
And we were facing the grim reaper.
Yes, yes.
So I had called the reviewer to talk about something else. Mm-hmm. And he said, well, contact the 510K program office because I understand they're still giving extensions for COVID.
Oh.
So
okay.
almost at the 180-day
Yep.
mark.
Okay.
They gave us another 180
Wow. Okay.
on a 510K. But I don't know how long that door is going to stay
Sure.
open.
Okay, that's really good to know. I haven't had that situation come up
There's
yet, but
There's a
okay.
guidance about COVID.
Yep.
And when they withdraw that guidance, they are
Got
going
it.
to withdraw the 180-day
Okay.
extension option.
Thank you. That's helpful. Good to know. Yeah, not many benefits, but that's a good one. So you don't have to go start from scratch again. Anything else, or are we good?
Should one follow and apply draft FDA guidances?
Good question. Yes, they should.
If your product is class 1, is the submission process still necessary?
So it would depend again. I mean, we'd have to see how it was classified. Some class 1 devices require a 510K. You'd have to look and see what that product code requires. So there's not a hard and fast rule there. But I'd say the majority of class 1 do not require a 510K. You'd have to look at the classification.
And final one for the session, for a PMA product, what mechanisms are available, level of evidence needed to get approval to make a new efficacy claim? For example, long-term data with on-label patients shows memory improvement.
Oh, that's a specific one.
Yeah.
I don't know if I can weigh in on that specifically. It will probably need to be something that would be submitted and added to the labeling if there's data. So it'd probably be a PMA supplement, whether it's, I don't know, real-time review, what are the other ones, 180. Yeah, I don't know, that's kind of I don't know if you have any thoughts, Steve.
I think that oftentimes that's where a pre-sub is almost most helpful, is because you can go to FDA and say, I want to make this specific claim.
Yep.
And then they can say, okay, like, what's your study? And you can kind of work with FDA.
Yep.
And FDA really likes to help design clinical studies. So the one thing is, if you think you might disagree, once it's in front of FDA,
Yeah.
you're going to be kind of beholden to that. But that is a really good pre-sub mechanism, is to have a good discussion on, I want to make X claim. Will these data get me that claim? So.
Okay.
All right, thank you. So
Great.
up next is Tim, and while he gets set up, I just want to touch a little bit on the agenda. I know, with some of the good questions, we've gone a little bit past. And so what we're going to do is really shorten the lunch period. So you're going to be able to eat, just going to be eat while we're still presenting. So Tim is going to go to approximately 12:15. At that point, here in the room, we're going to be able to grab the food and then come back and sit down, and we're going to resume at about 12:30. All time central, and so this should keep us, close to our original ending schedule, but we're just going to have to eat a little bit into that lunchtime.
Thank you for covering that. That was the first thing I was going to talk about, because, as a quality and regulatory professional, you immediately start to pick up on things like the fact that we've completely blown the agenda here, and as a result, then we've started a process deviation. It's in place right now. It's under review. In order to address the problem, thankfully, they're not looking at me to try to get us back on schedule, because I'm like the wrong guy to try to be brief and get us back on schedule. But I promise I'll do the best I can. It's good to know, though, that we're all still going to get to eat. A quick introduction: who I am, where I come from, and why I'm here. I spent 32 years plus with the Food and Drug Administration. My first 12 years as a field investigator. My educational background is biomedical engineering, so as you might expect, I worked a lot in the medical device area. After 12 years, I moved over into compliance, where I served as a compliance officer for 20 plus years. If you want to know the difference there, our FDA's investigators, inspectors, those are the folks out doing inspections, writing 483s, collecting exhibits, those sorts of things. And then all that material then in the agency then goes over to a person like a compliance officer or a center compliance officer, where they decide whether or not to pursue some sort of enforcement or advisory action, and what that action should be. So I had the pleasure, when I was with FDA, of being able to work on both as an investigator and as a compliance officer. One interesting exercise, you can probably do this as we go along here today. I have retired from the agency, but I still, on occasion, slip up and speak as though I still work there. I don't, okay? I think what happened there, it's like this. Any Star Trek fans out there will understand this. I think if you work for FDA for long enough, I think what happens is you end up kind of being assimilated, as like the Borg, So there are a couple of Star Trek fans out here who understand what I'm talking about. So here's what I do now. I'm living the dream. I'm telling you, I am really living the dream. I got out, I'm 58 years old. I got out of FDA relatively young, and that's allowed me now to do some other stuff that I really wanted to do. What is that other stuff? I work as a consultant in the device industry. Primarily, the work that I do now is for Mark at Gardner Law. The other thing I do, I teach. I'm an adjunct professor at the University of St. Thomas. With two other folks, we teach the Regulatory Submissions course in the School of Engineering over there. The other thing I do, and actually this probably takes more time than anything else that I do right now, I coach running. I coach track and field and cross country at Little Prescott High School, which is a neat little town down, just right down the river here, where the St. Croix and the Mississippi come together. That's Prescott. So I coach track and field and cross country there. I achieve, and I have to share this. This isn't going to help us get back on track, but I still have to share it. And I achieved another lifelong dream here. A few weeks ago, when I purchased with a business partner half a share in a standardbred racehorse, and that standardbred racehorse is, if all goes as planned, scheduled to be entered and race up at Running Aces here next week. The horse's name is Beachy Boy Hill. So if you happen to be up there, if you're a fan of racing, cheer for Beachy Boy. Somebody asked me, they said, Beachy, what kind of horse you got? I said, well, I got a standardbred. They said, oh, those are the kind that pull the chariots, right? I said, right, exactly. I didn't try to correct him. I said, exactly, it's just like Ben-Hur. It's just exactly like Ben-Hur. Okay, so how to survive an FDA inspection. I get a kick out of that term, survive, too. Frankly, if I had made the title, I think I would have changed it a little bit. I mean, this kind of gives the impression that they're unpleasant. Thank you. That engaging with FDA is some sort of survival exercise, like you're with Bear Grylls and you're out and eating bugs and drinking your own urine, trying to get through some terrible experience. So I'm happy to do this kind of talk because I think what it does is it helps dispel some of those perceptions, some of those stereotypes about FDA and in particular FDA investigators. And that's one of the reasons why I take the time to actually give a little bit of personal background, maybe more than you wanted to hear, so that you would come away from here today with the understanding that FDA people are people too. They are. And they, like you, are subject to anxiety and angst and worry and wonder and all the stuff that is associated with working in the industry that we are all working in, the healthcare products industry. And just keep in mind that FDA has an agency, and the people who work in FDA share the same goals that you folks do, that being to have safe and effective medical products on the market. So they empathize with you, and likewise I would hope that you empathize with them. So today now in a Q&A format, we're going to discuss some common characteristics of FDA inspections, including how to prepare, how to communicate effectively with agency representatives, how to avoid some common pitfalls, and how to address compliance issues. You will note, I know most people here, it seems, are from the medical device industry, but a lot, conceptually anyway, a lot of what I'm about to talk about does apply to all FDA commodities, even foods, biologics, veterinary products, and the like. So there's a little bit for everybody here. Poll. How many of you have participated in an FDA inspection? Show of hands. So a significant number here in the audience have. What do we got online?
Online, it's about 65% have.
About 65%. Okay, that was pretty close to what we have here. That's good. I'm glad to hear that. That means that some people haven't. So I hope that some of the material that I covered today will help the people who haven't to be prepared for that. And those who already have, I'll be very curious as we go along here to find out whether or not your experience with the agency and its investigators is consistent with that which I'm about to portray here. And if it's not, if it hasn't been, if If it's not, if you take some issue with anything that I'm about to present, feel free to, ask a question or tell me I'm wrong and explain why. After 32 years with FDA, believe me, I have been told a number of times that I'm wrong or on the wrong side of an issue or, need to do something different. So over the years, I've developed a pretty thick skin and some broad shoulders for dealing with that. So don't be shy here today. Here is the perception that I want to dispel, the stereotype that I'd like to get rid of. This picture here, the snarling guard dog with the FDA collar and that over right there, intimidated by FDA inspections, was real. About 25 years ago, that was in a magazine. And I can't remember whether the ad was by a law firm or a consulting firm or what, but they were obviously kind of trying to drum up business, I thought, in order for folks who worked in industry to hire them to help them through the FDA inspection process. Before we jump into the who's, what's, where's, when, why's, and how's of FDA inspections, let's take a moment here to just talk about some pandemic-related inspection things. During the pandemic, FDA adapted their operations for inspections and investigations to the point that even what they term mission-critical type work was only being conducted on a case-by-case basis. And in some cases, the agency went to kind of new and innovative approaches to get the information that they needed in order to do their jobs. That would include like remote interactive evaluations. Those were done in the drug manufacturing and bioresearch monitoring areas. And I really think that now that the FDA has gone to the trouble of working those out and understanding the benefits to that, that we might continue to see that as time goes on, even when the pandemic finally subsides, if it ever subsides, of course. So a couple other kind of key facts just to give you an idea of what happened in FDA with inspections. In fiscal 19, FDA had planned approximately 18,000 inspections and completed 94% of those. Then comes the pandemic, and in FY 20, the nearly 21,000 planned inspections were accomplished at only a 61% rate. So, kind of goes without saying that in fiscals 21 and 22, FDA has been and is playing catch up. I included there in your materials a link to some very, very good information, some comprehensive information involving kind of the roadmap for FDA inspectional oversight. And you can even go there and see for all the commodities that FDA regulates, their definitions of what constitutes mission critical work, high priority work, and low priority work. And you can kind of see what fits where on the scale. Okay, so who does FDA inspect? Well, they inspect manufacturers of finished devices, including but not limited to contract manufacturers, spec developers, and contract sterilizers. Who conducts inspections? Well, usually you're going to see one or two investigators from a local FDA office, okay? On occasion, though, you might see a representative from the Center for Devices and Radiological Health, or if you're in the drug area, a similar representative from CDER, the Center for Drug Evaluation. You might also see a national expert. FDA has a number of those on staff, or an FDA investigator from a neighboring district, or a state official or a local official who, kind of shares the responsibility with FDA to regulate whatever industry we're talking about here. What types of inspections are conducted by FDA? Well, they conduct a number of routine surveillance inspections. In other words, quality system, GMP type work. Inspections are done in the form of pre-approval work to support the approval of a PMA, or in some cases, a 510K. The agency does post-approval inspections too. After a PMA is approved, the agency routinely sends an investigator out to kind of see how things are going in those first few months following the introduction of a new device. Other types of inspections, the agency goes out routinely to cover complaints. Those complaints can be from a number of different sources. Consumer, industry type complaints are pretty common in the agency, and some of the most interesting ones that I saw when I was working there came from informants. In other words, folks who work right in the companies that we were getting ready to inspect. That situation where, somebody says, you can kind of picture it, they're at their desk and say, I'm fed up, I can't take this anymore, I'm going to call the FDA. And a lot of times that's what they do. And then the agency evaluates the information that's provided and decides whether or not to do a specific follow-up to the issues that have been reported. FDA also does inspections to follow up recalls or field corrective actions, or if you want to go to the 21 CFR 806 definition, corrections and removals, right? Corrections and removals, synonymous with the term recall. FDA does special assignments and investigations, and know too that when they're doing inspections, FDA can collect samples, and those samples can be of the products the FDA regulated products that are produced in the facility, or just documents that demonstrate the production of those FDA regulated products. Now, why does FDA do inspections? Well, they're required by law to do inspections. Some people don't know that about FDA as a government agency. They're subject to rules and regulations and law as well, just like industry is. And there was a time when FDA was required by law to inspect every medical device manufacturer every 2 years. Well, guess what? You laugh. That didn't happen. For pretty obvious reasons. The agency just didn't have the resources to allow them to get around to all of those companies that were making medical devices. So that's changed a little bit, and I think I have a slide coming up here that'll explain how that's changed. Why else does FDA do inspections? Well, they do it to evaluate compliance with the Food, Drug, and Cosmetic Act and any related regulations. And they do it to collect information or evidence for the lawyers out there, evidence that can be used to support regulatory action or enforcement action, if you want to call it that, if that becomes necessary. FDA is an agency that really hopes to achieve as much compliance as possible in a voluntary manner, and generally that happens. I think the industry and the agency are pretty good at that whole idea of voluntary compliance. But when that doesn't happen, then there are a number of different regulatory and enforcement tools that are available, starting with advisory actions like warning letters and untitled letters, moving on then to enforcement actions like seizures and injunctions and civil money penalties, and then in the worst of the worst cases, even some criminal prosecutions. Note that you may say, well, I know how to survive an FDA inspection. I just won't let them in the door. Not a good idea. Okay, really not a good idea, because that act in and of itself, to refuse inspection from FDA, is a prohibited act and would make you subject to civil or criminal action. When are inspections done? Well, now, rather than the old, what I said, the statute required before, the 2-year thing, now inspections are done on a risk-based inspection schedule. And I believe that's even been put into statute, that the agency is required to assess risk in deciding how they use their resources. Much of the work that the agency does, especially right now in the pandemic era, is work that is described as for cause. And the types of for cause work that's done by the agency would include a follow-up to observations from previous inspections. If you have a recall, a correction or removal type action, complaints, adverse event reports, if there are industry-wide issues, that'll cause the agency to go out and inspect not just one company, but perhaps everybody who's involved in an industry. The one that always sticks in my mind is years and years ago, I don't know if you remember this or not, but and it actually led to the development of a standard in this area, but we had a number of cases where lead wires for medical devices were being plugged right into receptacles, plugged right into AC power receptacles, and a number of folks were hurt, and I believe there were even some deaths associated with that. So in that case, I remember the agency going out and inspecting every company that made any sort of product that could potentially be misused. Note that sometimes the agency will reveal some details about why they're there to do these for cause inspections, but in other cases they won't. and you can probably guess, the types what leads to that approach by the agency. Sometimes there's nothing to hide. The issues that are to be covered are very clear, but other times, in order to respect, the confidentiality, for instance, of folks who came to the agency with information, the agency will be a little bit more coy, cryptic, and in some cases not say anything about exactly why they're there. What's going to be covered during a routine quality system inspection? Well, it's like you'd expect. Registration and all the stuff, all the general controls that companies that make medical devices need to comply with. Registration and listing, pre-market, quality system, medical device reporting, device tracking. If you make a product that's subject to device tracking, the agency will cover that. Any corrections and removals, and then kind of other stuff as needed. How are inspections conducted? Well, FDA doesn't do a very good job of keeping secrets in this area, nor do they want to. Okay, they're going to do inspections. They've gone on record. It's their written procedures for doing that are published, and you can find them. You can find the quality system inspection technique, which is the top-down system-oriented way of doing inspections that the agency does right now, as opposed to what was done in what I like to refer to as the good old days, when FDA investigations kind of started with, we'd go to the firm, we'd issue our credentials. Hi, I'm Tim Phillips. I'm with the Food and Drug Administration. I'm here to do an inspection. May I see your complaint file and all the MDRs that you've filed? And oh, by the way, if you've conducted any recalls, I want to know about those too. That's the way FDA did inspections at the time when I joined the agency back in the late 1980s. And even a little bit into the 90s. But at some point in there, the agency evolved and started doing inspections from a more top-down, systems-oriented manner.
I do have a question online.
Sure.
So Theranos, the debunked blood test company, passed an FDA inspection by hiding the existence of a certain room that held their technology. How often do unethical companies get away with this? And do these companies eventually get caught before causing extensive harm?
Wow. I didn't know that about Theranos. That's what they did. They very definitely hid information from the agency that, had the agency been aware of it, that all might have turned out quite differently.
Yep.
How often does that happen? I don't know. I really don't know. But my impression is that it doesn't happen very often. Thank goodness. Right? My impression is that, by and large, up in the high 90%, of the companies that FDA deals with are on the up and up. They're straightforward with the agency. They have noble goals, great intentions. They do everything they can to produce safe and effective medical products. That's my impression. Do I have metrics to support it? No, I don't. Sorry. But that said, in my 32 years, you'd be surprised to know that no less than 5 times I was involved in cases, either as an investigator or as a compliance officer, where companies ended up subject to criminal type action and penalties because they either lied to or withheld information from the agency. And I always kind of felt like, one guy in a 32-year career to see that 5 times, that was too many, I thought. I mean, I was, in a couple of those cases, I was stunned. I was shocked to know that had happened. But it does happen, and when it does happen in those cases, because you're all consumers too, right? I mean, you work in the industry, and I work in the industry as a regulator, but we're all consumers. And so, we all want to see good products out there. We all, when it's necessary, want to see a strong FDA that's good at what they do. So I hope that got to the question. Where will investigators look during inspection? Well, a lot of times inspections start with a kind of a broad-based facility walkthrough, so the investigator can just kind of get the lay of the land and see what's out there. Then, as the inspection proceeds, they may do more detailed inspections of manufacturing and quality control operations that are particularly interesting, or perhaps have been the subject of some issues. But know that it's not uncommon for FDA inspections to be spent. A significant amount of time of the FDA inspection is spent in a boardroom reviewing GMP required records. So don't be surprised by that. What should you do to get ready for an FDA inspection? First and foremost, you know what you got to do? You got to be compliant. Okay, because if you're not compliant, if you got a lot of quality system issues that are either, you know, right out there or percolating right under the surface, no amount of being good at the other things that I'm going to recommend here is going to save you, or I'd be lucky if it saved you. Okay, having a good contact person to coordinate the inspection is a very good communicator, and while they might not know where to find everything in the firm, they know who to find who can find everything in the firm and facilitate a good inspection. You know, having that isn't going to save you if you're not compliant. Planning for the situation when quote everybody who knows anything is gone. In other words, having a plan A and a plan B, and in some cases even a plan C, that's not going to save you either if you're non-compliant. But that quote right there, I'll tell you a little bit more about that. I went out one day to do an inspection, drove all the way out into a small town in Wisconsin, and was ready to do the work. Parking lot's full, inspection. I'm in the facility, it's loud. There's a receptionist behind the counter, and I did my thing. Hi, I'm Tim Phillips with the Food and Drug Administration. I'm here to do an inspection. And she said to me, "Oh, I'm sorry, that won't be possible today. Everybody who knows anything is gone." And I said, "Well, really, because, you know, the parking lot's full and the plant's obviously running, you know." So that wasn't really the case. I mean, what happened there, it was pretty clear that the people who they would have preferred to deal with the FDA, they were gone. They were off-site for some reason. But no, thankfully for all of us, you know, there were folks there who knew enough about the operations that they were able to help me that day. I think I may have already mentioned this. So study and understand, you know, this all goes to the being compliant thing. Registration, listing, product approvals, GMPs, adverse event reporting, all of that. You know, just be ready for that, because I like to tell people it's not really a question of if FDA is going to show up. It's just a question of when. Okay. And think about this. Think about, too, as you put together your planning for FDA work, what are you going to do to provide accommodations for the FDA? You know, what are you going to do about giving them a certain degree of privacy? Should they request it just to review documents? In some cases, you know, our folks, I did it once right there. Our folks, like I still work there. FDA folks will want a little bit of privacy, if no other reason than just to allow them, you know, to review materials without having, you know, 6-8 sets of eyes staring at them while they're doing it. Or the one that gets me, this is a pet peeve of mine. Some companies wouldn't even let you go to the bathroom alone. And I knew they were following me there because he didn't have to go, you know, he just watched. And I mean, that's a little over the top. I think that's a little over the top. But I mean, I understand some companies have that policy and it's strict and, you know, right down to that level. But I don't know what they think is going to happen. I don't think you're going to conduct an interview while you're at the urinal with somebody. I don't know. But anyway, think about how you're going to handle that. If you can only remember one thing from the material that I present today, I'd like for you to remember what's on this slide. And it's the concept of TLAST, which was taught to me by a lawyer who did some of our training in FDA, in Food and Drug Law and evidence development. It's a concept that can be applied to how to testify in a court of law, right? And I understand FDA inspections are not, they're not an equivalent to testifying in a court of law. They're different, but they do have enough parallels that I think this applies. For anybody want to take a crack at this acronym and what the first T is? Truth. Very good. Tell the truth. Absolutely, under every circumstance, tell the truth. No GMP violation, no adverse event report, no recall, no nothing is serious enough, awful enough, that it warrants you telling a lie or withholding information from the government about it. That act in and of itself, again, you start talking, you know, like refusing inspection, that act in and of itself is I believe, it's a felony. I believe under Title 18, lawyers. The L. Listen to questions, and I'll go one step further. Make sure you understand the question before you try to answer it. You know, you hear that old saying, there's no such thing as a dumb question? That's wrong. There are dumb questions, and I know because I asked some of them when I was out doing that work. I mean, we deal in a highly technical environment, right? And sometimes it's hard to even characterize exactly what it is you want to know, you know? So if that comes up, if If the investigator asks a question that's confusing or doesn't make any sense, seek some clarification and try to get to exactly what it is that the investigator wants to know, so that you can answer the question, clearly and concisely. What do you think the S might be here? This is another good one, I think. This trips people up a lot. What's the S? Come on, lawyers who are litigators, you got to know this. Who said stop? Whoever said stop got it right. Stop after you've answered, right? Okay, and I'll just give you an example of kind of what can happen with people who don't stop. You want to do a role play with me? Yeah, you want to do a role play? Sure. Do you have a program in? Do you have a program in house for calibrating your equipment?
Yes.
You do. Is your calibration program, has that been reduced to policy and procedure documents?
Yes.
Okay, great. Can you tell me what those are? And in fact, could I see copies of them?
Absolutely.
Okay, you're good. You're good. You're good. And I'll do the other side. I'll do the one you really want to avoid. If I said, do you have a program in house for calibration? And the answer was, yes, we do. That's the responsibility of Frank over in maintenance. But old Frank, you know what? He's got hemorrhoids like you've never seen before right now. He missed the last month of work. And you know what? While he was gone, we had 3 pieces of equipment fall out of calibration. Don't worry, investigator, we got it under control. Nothing to worry about. Carry on, you know. That's what happens if you don't stop, okay? Oh, shoot. Itchy trigger finger there. That's how important the T is to this, okay? It bookends this. It's the first and the last thing I want you to remember in how to deal with government regulators. Let's see. Now, what if you lie to the FDA during an inspection or in a pre-market submission? Well, guess what? You might have an opportunity to meet one of their criminal investigators. Because FDA has those, okay? FDA has folks who are there, that's their job, is to do investigations in situations where there has been or there's a heavy-duty suspicion that a criminal act has been committed, and know that, you know, that Office of Criminal Investigation works very closely with the Department of Justice, who handles all of FDA's civil and criminal litigation. On a lighter note here, let's talk about some things that kind of the whole idea of bribery, I guess. I mean, and whether or not you can offer these sorts of things to the investigator without being suspected of trying to bribe them or influence their decisions. How about a cup of coffee? Show of hands, do you think that's okay? Yeah. Holy cow, I don't want to inspect some of you people's firms. Not even a cup of coffee? Coffee and a donut? My answer is yes. Coffee and donuts fine. Good donuts, please. Good. Bagels would be good too. Bagel would be all right. How about one of your company pens? They don't have one to use? Yeah, that's the example that I like to give. If the investigator's in your firm, it's a Friday afternoon, it's 4 o'clock, and they're writing away furiously, and all of a sudden their pen runs out, and they don't have another one, right? And everybody's ready to go, right? It's the weekend. You know, we want to get to the cabin, get going on the weekend. And you have a box full of pens. They cost 3.7 cents a piece, right? They have your company's logo on them, right? Flip it to the investigator, let them get the job done and get out of there, right? That's probably okay. Nobody's probably going to get in trouble for that. If on the other hand you hand them an engraved cross pen that has, oh, by the way, you know, we thought you'd like this. We've got your name on it too. You know, we've so enjoyed our interactions with you over the years that you know, we want you to take this just as a memento of your visit here. That certainly is a problem. How about dinner? No, that's right. You're right. Dinners are off limits, and that's actually specified in a regulation. I was going to cite the regulation. I forgot to get it in the materials here. But yeah, dinners are a no-no. FDA representatives will always try to pay their own way on dinners. Ticket to a Timberwolves game. No, yeah, the answer is no. Even like when the Timberwolves were terrible and you couldn't give the tickets away, or they fell under the actual regulatory limit, because there is that regulation that I forgot to cite here actually has a number. It's $25 or something like that, and no more than 3 times over the course of a year. You know, don't quote me on it. Just go look it up. But that's another one that just, you know, any appearance that you're trying to gain an advantage or give somebody something that they're not entitled to should be avoided, both for the sake of industry and for the sake of FDA. So yeah, here's the textbook answers. Yeah, a cup of coffee's fine. Coffee and a donut's fine. That's a modest item of refreshment. You know, a bottle of water or something like that. That's okay. That's not going to get you in any trouble. One of your company pens, that's a maybe. Dinner, no. And let's not go to Timberwolves games. Is it okay to ask the investigator questions during the inspection? My answer there is yes, absolutely. And in fact, I would encourage it. I would encourage you to seek feedback on how the inspection is going if you're not getting that from the investigator. Seek that feedback. I can tell you from having been involved in FDA's internal training programs, both at the local and national level, we teach, is that wrong? That would be wrong too. I used to. When I was with the agency, teach our folks to, at minimum, at the end of each day, give a wrap-up for how the inspection is going, what they found, whether there's anything they're concerned about. Especially things that might end up on a 483 or might end up being discussed at length in a report that could lead to some sort of action. Is it okay to argue? This is a trick question. I'll just tell you right out. It's a trick question. Is it okay to argue? It's not okay to have a knockdown screaming match with the FDA representative. That's not okay. That's not good. But it is okay to have an argument with them if that argument is productive, it's on point, and it's constructive, and it's trying just to establish the matters of fact that you need to establish. You know, if you get the sense that the investigator has completely gotten the wrong impression about something, or they have mischaracterized something, don't be afraid to bring that to their attention and talk about it. Just do it in a polite, courteous, constructive way. What parts of the GMPs do you need to be really good at? Well, all of them, of course. But the ones that were my favorite and continue to be my favorite, because of course I continue to work in this industry, are the ones that relate to quality issues. Okay. You've gone a long ways, and you know the FDA's vision of you, the FDA's the picture that you paint for the FDA will be at its best if you are a company that sincerely goes about looking for quality system issues, detecting that stuff, getting them accurately defined and bracketed, and getting things corrected. What's 483? Well, that's the form that the investigator leaves. That too is required by law. That objectionable conditions, and it's the form used to report objectionable conditions and practices that an investigator observes during an inspection, and that whole thing, issuing a written notice of that, is required by law. What does and doesn't go on the 483? Well, for device inspections, GMPs, adverse event reporting, observations involving recall deviations go on the 483. Stuff that doesn't, registration and listing, pre-market, and labeling. Those things on the right side that don't go on the 483, it's not that they're not important, they are important, but the reason that field investigators have not been given the authorization, so to speak, to write them on a 483 is because those are issues that by and large are handled by the folks in the centers. Okay, so like the Center for Devices and Radiological Health are the ones who ultimately determine whether or not labeling is in compliance or not. Okay. Are you required to respond in writing to a 483? How many people think, yes, you are? You get a 483 from the government, you got to send in a response. Yes. How many? No. One taker? Yeah, you're wrong. Sorry. I know it's weird. It's really weird. You're not required by law to respond at all, but you should. And that response should be prompt. How prompt? Well, within 15 days. And there's the address of where you should send it. What does that get you? What does it get you? Well, the agency has gone on record to say if you promptly respond to a 483, then we assure you that we will review and consider your response before we do anything. That anything, of course, might be an advisory action, or in some cases it might be if the agency is contemplating taking some sort of enforcement action. How does FDA inform of the outcome of inspection? Well, now a copy of the establishment inspection report is sent to the company that was inspected when that investigation or inspection has been determined to be closed. And closed is defined in that regulation that I cited right there. This is a lot better way of dealing with things than the agency used to back in my early days. In my early days, you'd answer that question with, well, you know, no news is good news. You know, and boy, that people didn't like that. They really didn't like that answer. And I didn't like to give it either, really, because I didn't think it was really very fair. Just kind of leaving people hanging as to whether or not you know, things were good, bad, or indifferent. Number two, poll number two. If you've participated in an FDA inspection, was your experience consistent with the material that I just presented? And if not, I'd love to hear more about it. Even though I've contributed to the problem. Add this to the process deviation.
Poll is still running. We'll give it a few moments.
Okay, anybody here? Yeah, go ahead.
So I had, when you were talking about how it's changed in the early days,
Mm-hmm.
my first experience was at the U of M with the ALG program.
Oh, yes.
Yeah, you know that one.
I do.
I do.
Can you guys repeat the question?
Sure.
Yep. So the question was, is the speaker's presentation consistent with your experience with an FDA inspection?
Sure. Sure.
You want to give her a mic?
That'd be great. And just for the room, I moved from California here. I took a job at the ALG as quality assurance manager, and I've been there 2 months when FDA walked in and shut the program down for years and years of non-compliance, which was hysterical. But 5 inspectors coming in for minor, teeny, like this timer's out of calibration. And then 20-something pages of clinical violations that had occurred in the 80s. And it was so adversarial that when John Najarian sat in the room and said, don't you know who I am? I'm the greatest transplant surgeon in the world. And the FDA said, you're done. You're closed. That's it. And that was my first inspection after 2 months just entering this industry, which was very, very funny. And a second one was having FDA show up 97, a component plant, to inspect us. They said, we're not a finished device manufacturer. I was on crutches, had just broken my leg, and everybody who knew anything, senior people, were out of the office. I'm like, well, let's gown up and I'll find a way to hop into but I don't think you're supposed to be here. And thankfully, things had changed, and the inspector was really great about it. But,
Good.
But other ones I've been in have been pretty much like clockwork, which is really good. So there has been a big mind shift.
Good.
Just funny, but yeah, that's introductions to inspection with the ALG one was, whoa, this is fun.
Yeah, that was a real. I wasn't involved in that case, but I'm aware of kind of the history there, and ultimately that ended up in a criminal prosecution, I believe. But when he was found, found innocent, I believe, right?
Yeah, it was very.
I don't know. I shouldn't even talk. I shouldn't even talk about that unless I got the facts in front of me. Go ahead.
Yeah, I just have a question about foreign manufacturers and pre-approval inspections, and if anybody knows anything about how that's changed during COVID, or there's anything going on there.
Yes, the agency is back doing foreign inspections. I don't know that they're doing as many as they were before, but that was one area that they really fell quite far behind in, and so they're playing catch up there. Yep.
We've had several that were in the past, I would say in the past 3 years, even through COVID, where they picked up towards the end, where things got a little bit later. And I would say they're very similar to what you've described. in this experience. And one place we tend to get tripped up is we don't have on-site catering. And so lunch is usually a question. And so when we're doing a front room, back room setup and we have a large catering order for lunch coming in, the challenge is always then if the inspector wants to stay on site and have lunch brought in, we have to add that lunch order usually to the big catering order and breaking out a separate receipt for them. And it's very challenging.
Yeah.
But I will say we've had also a pre-approval inspection for biologic product, and it was a very different experience from what was described. It was 5 inspectors and one that was probably on their first inspection and tossing papers off the table, and
Really?
and then the one tricky auditor, right, that would kind of trail behind the rest on a tour and be looking at very different things. So kind of a mixed bag.
Okay, thank you. No more? We good?
No more questions. And online, just to close out, it was about 73% said yes, they agreed with this.
Okay. All right. Yeah, I'm not going to make excuses for FDA's folks who don't do it the way that I kind of would prefer that they do. I can't do. I can't make. I don't know the stories. I can't. But I can tell you, having been involved with the agency for as long as I was, and being involved in the training programs, kind of the bottom line was we encouraged the investigators to be to always, of course, be courteous, be straightforward, don't be heavy-handed, don't be overbearing, and that kind of the bottom line was I always said, there's no reason why when we do this job, the investigator job, that we should be making enemies when we're out there, because our goals are very, very similar. We just get at those goals from a different angle. So.
I have a couple of questions online
Sure.
too. So one comment is, we always escort investigators. We had an investigator sneak out of a bathroom and go onto the production floor.
Really? Wow. That's not there's no chapter on that in the FDA's training program, I can tell you that.
And then Dr. Najarian was acquitted of all criminal charges.
Acquitted, okay, yeah, that's, okay, good. Whoever provided that, thank you.
Yep, that was Howard Root, thank you, and he wants everyone to remember that for now.
Okay.
And then the last one is, have on-site inspections been reduced for a company with MD-SAP certifications?
I'm sorry, can you do that one again?
Have on-site inspections been reduced for companies with MD-SAP certifications?
Yes, I believe they have. The inspections that are conducted according to MD-SAP would, in essence, cause FDA to take those companies off of their schedule for regular coverage. At least that's the way it was at the time I left. Okay, thanks everybody.
Thank you. So what we're going to do is we're going to take like a 10-15 minute break in here, and we're going to grab lunch. And I believe it's actually like in the back room, so we'll kind of snake to the left, and we can follow Amanda and Bryn, and they'll show us. And those online, we'll be back in about 15 minutes to resume the program. So feel free to get yourself something to eat as well, and we'll talk to you soon.
Hello, everybody. I think I'm on here. Thanks for coming out today and staying through lunch. Normally when I give privacy presentations, it's right after lunch and everyone's, just ready to take a quick nap. Privacy puts some people to sleep and it keeps some people up at night. So we'll see which ones you are today. A little about myself, I work at Gardner Law, obviously, and I lead the privacy practice here. One of the things that I did in the past is work with a HIPAA-covered entity and at the state, and then also worked at Medtronic in the global privacy program. So my experience is broad in terms of global and state and federal privacy laws, especially around healthcare and a medical device. We can jump to the next slide there. So some of the common threads that I have the clicker. and I don't have to ask anyone to move this. Some of the common threads that we'll talk about in privacy to kind of kick this off, just to give some context. I think when we think about privacy law, often we think of HIPAA, we think of some of the recent changes, GDPR, some of these bigger privacy laws, and it can be overwhelming, especially when you see there are 5 state privacy laws now that have passed and been implemented or are being implemented in the US today. But what I would like to do is talk a little bit about how these laws don't have to be reinventing the wheel every time we see them. There is a level of consistency and some common things that we see, and privacy programs can help to affect compliance, reduce risk without necessarily starting from scratch every time you see the law. And I'm sure back in 2003 when HIPAA was being implemented, it probably felt like starting from scratch. And I think today we have enough kind of momentum in privacy to see some common things we can do. We'll talk about updates primarily today, so I'm not going to dig into the details of laws that have been around for a couple of years, but we'll talk about some of the changes to those laws or some things that have happened more recently. We'll talk about some things in the US and then also out of the US. And we'll talk a little bit about cybersecurity in this presentation, but this is not the same topic that Bren will cover shortly after me. This is going to be focused on data security and how that's been changing in a few different areas as well. And then some enforcement activity update too. So some common threads that we see in privacy laws, and these are not always implemented in the same way in various laws, but they do typically look something like this. There's some requirements around these areas in almost every privacy law. Transparency is a big one. When you think about a privacy policy on your website, that's probably the classic example of when you collect data about someone, when they visit your website, informing them of what you're doing with that information. That's part of transparency. HIPAA has the Notice of Privacy Practices. These other sorts of laws all have similar requirements in that area. When you think of lawful basis or the legal basis for using data, many privacy laws, HIPAA included, have a set of enumerated types of uses and disclosures of information that you're allowed to do. And outside of that, you have violations. And that's what lawful basis refers to, so identifying that before you do something with the information you have. Limiting data collection. It's a good idea generally from a privacy standpoint to reduce what you collect to what you need, but there are some laws, GDPR, CCPA in California and others, that require that you limit data collection. Additionally, storing, sharing, transferring data, almost always there's some restrictions around that. A key one is if you promise to do something with data, aka not share it, and then do share it, that's always going to be a problem even in fairly loosely regulated spaces. Many laws require that you have contracts in place for sharing and so on, so we'll talk about that too. And then, of course, retention of information. Usually we think about retention of information outside of the privacy realm as, well, we need to keep this data for a certain amount of time to meet our regulatory requirements, or we need to keep it for business purposes. You know, HIPAA requires 6 years of retention for compliance records related to HIPAA. But what we talk about in privacy from a limited retention standpoint is don't keep information longer than you need it for a legitimate purpose, for regulatory reasons. Once you reach that trigger, many laws, GDPR, state laws require that you then delete and destroy information that's no longer needed. So that's a principle. Individual rights, you know, HIPAA access requests would be a great example of that. GDPR requires companies to respond to data requests from individuals, data subjects. So that would be a common one that you'll see across the board in various laws. The details are always a little bit different in each law, so it might be a right to restrict processing or request to restrict processing in some cases. In other cases, you have the right to just have your information deleted. So there's different variations of those rights. Data security goes without saying, that's an important one. And then vendor management, so the idea of accountability throughout the chain. So once information is collected by your company, how is that then entrusted to you? Do you, hire a vendor that handles that information as well? Or is it, anyway, the idea of having controls over that use of information downstream. So let's dive into some updates on state privacy laws, and I know everyone's really excited about this. I'll touch briefly on each of them. We won't go into super detail on all of them because there's a lot to cover, and we could probably spend a whole seminar on each law. We won't do that. We'll spend a slide. But to start off, let's get a question to the audience. Who here is dealing with a state privacy law, one or more of them, and attempting to comply? Maybe you're not involved in that directly, but is your company working to comply with these? Show of hands here. Any poll results there? We see this quite a bit.
Paul, on the poll, we've got about 78% are dealing with one or more state privacy.
So they are affecting many of our clients. Usually, you'll see as we go through some of the applicability thresholds, but they do affect a lot of clients that we have, and many businesses across the country. So we'll talk about the California Consumer Privacy Act briefly. And this isn't a very new law. It's been around a couple of years. But probably for many of you, you have some unfamiliarity with some of the requirements. It's been said it's similar to GDPR in a lot of respects, and that's true. One of the main kind of observable things that you'll see as you go through your normal life that's related to this is those banners on many websites that say, "Do not sell my personal information." That's a requirement from the CCPA. It's been in effect since 2020, and it's affects businesses primarily that do business in California or have certain revenue thresholds that we'll touch on in a second on the next slide. It offers data subject rights. It requires data security, contract controls, various things that ensure privacy of data for individuals. It requires consent before you can sell data of individuals. So there's a lot of requirements. We'll just touch on some of them on the next slide especially because it's been updated since 2 years ago with the CPRA, the California Privacy Rights Act. Now, what's kind of interesting and I think helpful for context is that the CCPA originally was brought forward as a ballot initiative, so it was going to be voted on at the ballot box as this pretty broad privacy law. But rather than go that direction, the advocacy group that was bringing this ended up pressuring the legislature to pass that law instead through the legislative process. It didn't get much amendment in that process, and ultimately it was passed with some inconsistencies and some things that normally would come out of a law like that in a legislative process. That didn't happen until later, so some amendments happened, some clarifications needed to be made, and now we have the California Privacy Rights Act that passed last year and has a more specific focus on some of these areas that weren't addressed in that original law. Interestingly, this was passed through a ballot initiative. Most of the new provisions in this law are effective 2023. One of the big changes in terms of applicability is that originally it was if you have $25 million in revenue annually, this law applies to you, and you do business in California. If you buy, receive, sell, or share information of 50,000 individuals was the original threshold that the CCPA set, and it's been moved up to 100,000. So there's a narrower applicability that will be coming in 2023 than we've had so far. Or if the business derives 50% of its annual revenue from selling the personal information of individuals in California, then that would also trigger the law. Some of them really important, I think, changes that might affect you or your clients is the exclusion of employee data was extended. So the original law, they amended it to exclude employee information, and then the CPRA has extended that extension even further to the end of this year. We don't know for sure if that will continue to be extended or if we'll end up dealing with employee data under the CCPA as well. And then it also updated some of the sale and sharing information definitions. So rather than do not sell my personal information, those banners will say or share. Do not sell or share my personal information. Clinical trial data is excluded, and that was clarified further in the amendments. And then also, any data processing that's kind of a significant risk needs to be reported and assessed and reported to this California Privacy Protection Agency. And this agency was also a new implementation from this law. So that's now the enforcement agency instead of the California Attorney General's office. Only a few more laws to go on the state side. Virginia passed their law, which is now effective January 2023 as well. And this applies to businesses, as you can see, that either process a fairly large volume of Virginia consumer data, so 100,000, or a much smaller number if they derive most of the revenue from selling that information. Again, provides data subject rights. You can see some of the consistency there with other privacy laws. And one thing to note too is this, again, continues the exclusions for PHI, for employee data, for business-to-business kind of commercial data that you'd collect during sales activity, things like that. And then it was amended slightly in the past few months to delete, basically this deletion right was replaced with an opt-out right within that law.
Hey,
So,
Paul, we
yeah.
do have a question that came in online. How long do we need to keep customer data for general promo and marketing in a CRM system? And is there anything we need to do with FDA in this area?
You know, I think as far as the FDA goes, they don't have any guidance that I'm aware of about deleting that data. So I don't see any reason why you would delete that information. We haven't really, as far as requirements for retaining it for a certain period, is that kind of what they're asking, I'm assuming? It would vary, I guess, depending on what specific regulation you're talking about. So we could certainly look at that. It's probably fact intensive, depending on what the database is for. Very similarly to the Virginia law, Colorado has its own privacy law as well. This applies to businesses that do business in Colorado and, again, collect information, process information about Colorado residents. Really, again, this is so consistent, I think, throughout these laws that they're really concerned with businesses that sell and do business with information as a commodity. So you'll see that that's a focus on all of these. Again, similar requirements in terms of data security, contract provisions, risk assessments. These things are pretty common in these. And then also doesn't apply to PHI, doesn't apply to employee data or to business data. One thing that I would clarify is these exclusions for PHI kind of vary a little bit by state. So for example, in Virginia, the exclusion is for the entity level. So if you're a covered entity, any information that you process is going to be subject to HIPAA rather than this law, whereas California and Colorado have focused on what is the classification of data that you process. Is it actually PHI or is it something else? And that's one of those distinctions. All right, moving right along, we have Utah. They've just passed their privacy law this year. It bears similarities to the prior laws that we've discussed here, but they've made a deliberate effort to narrow the scope. So you'll see that not only is there a threshold in terms of revenue, but also in addition to that, there needs to be a certain level of data processing that goes on of Utah residents. Provides the same kinds of rights, the same kinds of security controls, and really clearly they've made exemptions for PHI, employee data, business-to-business data. And they've added another category that's excluded, and that's aggregated data, so any information that's been pulled into sort of a generalized pool of information that you can draw insights from. Just one more here. These are all very new, hot off the presses. So Connecticut just passed their law this past month, and it was signed about 9 days ago. And 14 months from now, it'll come into effect. Some of the requirements are familiar based on what we've just seen in the last couple of slides. They've made it a threshold of 100,000 Connecticut residents. If you process information on that number of Connecticut residents, it will apply to you, except if all you do is handle payment transactions. So maybe you're a retailer that uses, handles credit card information or something. Or if you do get engaged in selling or commercializing data, then it's a much lower threshold. Similarly, provides rights, requires these assessments, security, all of those things that we're familiar with in most privacy laws. And then it, of course, again, and I think helpfully, this is showing a trend, does not apply to PHI, employee data, and business-to-business data. So here's just a quick comparison chart, which I think highlights some of the trends that we are seeing across these laws. Certainly, this doesn't compare every aspect, and there are more things that we could look at, and there are differences. They each define personal information differently. They each define various terms, sale, and all of them in slightly different ways. But you can see that there's a trend here towards granting certain basic rights to consumers, to generally avoiding these private causes of action, which allows an individual consumer to sue on behalf, against the company if there's a violation. Typically, they've excluded PHI, although, of course, the details vary. For the most part, these laws have required some sort of risk assessment when there's processing that's of a high-risk nature. So that definition, of course, varies what is high risk, but there is some sort of threshold where risk assessments need to be done to evaluate the risk for the data subject.
Hey, Paul, quick online question, just
Yeah.
for a little bit further. Can you go a little bit more into what is considered high-risk processing under these laws?
Yeah, that's a great question. And so this kind of originated, this concept of high-risk processing, with GDPR, so the European General Data Protection Regulation. And for the most part, it's identifying the kind of processing that maybe is more sensitive information, maybe larger volumes of information, or maybe is used for things that might be more impactful to individuals. So if it's, for example, biometric processing, that you use someone's facial scan to maybe do predictions about what they might, like to be marketed with, or maybe you profile based on data about that person, what their credit history might, and credit history, things like that would be more sensitive and affect their ability to exercise their rights. Typically, that would lead to, okay, this is high risk. It's kind of it varies by law, but those are some of the examples we could see. All right, so we're out of the states and into the OUS update.
Real quick, Paul, though,
Yeah.
there is another question on the states.
Yeah.
So California requires specific language in informed consent documents for clinical trials due to their privacy laws. Does Colorado, Virginia, and other states with privacy law have those same requirements as California?
So typically, it would vary based on exactly what you plan to do with the data, what the data consists of, and we could look at that more in detail. But generally speaking, if there's a clinical trial, these laws have some sort of exemption for the data collected within that trial. So rather than have your data set then be subject to data subject requests and have potentially deletion requests, things like that, there's an intention, at least in most of these laws, to carve out clinical trials that are done based on good clinical practice, and there's kind of a variety of different carve-outs for that. So a question here, and I think a big topic in the OUS is international data transfer. How many here, by a show of hands, have dealt with this, maybe through a clinical trial that you're trying to get data from in another country or what have you? We have a few hands here.
Yeah, so we're getting close to like a 50-50 split online, 60-40.
Yeah, and that's consistent, I think, with what we see. Generally it's a challenge. It's a common issue. Even if you're a U.S. company that's trying to maintain mostly business in the U.S., you might be running a clinical trial in Germany or Spain or wherever, and within that context, you need data from the EU, and the EU is right now fairly difficult to get data out of. There are other countries as well with these kinds of restrictions. So with that in mind, if you're familiar at all with the GDPR, it includes restrictions on cross-border data transfers unless you meet certain criteria and address certain risks. And that's been the case for a long time. But over the past couple of years, this has gotten a lot more complex and difficult. The US Privacy Shield, which allowed kind of unhampered data transfers between the US and EU, was struck down in a court ruling that's kind of shorthanded to Schrems II by the European Court of Justice. And that led to a few other domino effects, one of them being that most US companies that do business or handle or interact with the EU are now using standard contractual clauses to transfer data between the countries and the country and the European Union. And that adds another set of complexities, including the standard contractual clauses were changed in the past year. So June 4th in 2021, there was a brand new set of standard contractual clauses that were issued. And there's kind of this sunset period for the legacy contracts, and now everyone is scrambling to replace their old SCCs with the new ones, and that's been going on for the last year and a half or so. But what's sort of driving that now is that by the 27th of December, everyone who has legacy contracts will need to completely move them over to the new versions by the end of the year. And if that weren't enough, there's also this concept from Schrems II that has led to these data transfer impact assessments. So any time there's a transfer of data from the EU to the US, there's this questionnaire, you've probably seen it if you're involved in this at all, or a variation of it that looks into not only what is the transfer made up of, what kind of security controls are in place, but what about the sort of government surveillance in the US, what kind of access might they have to this data, and analyzing that. And that's become a big topic of kind of contention and challenge in the privacy world here. The good news is, though, there is a US-EU data transfer agreement in principle that's been agreed upon between the government of the EU and the US as of March 25th. Of course, Max Schrems let everyone know that he plans to challenge that as soon as it's published and confirmed. So just, we'll stay tuned. Quick note on the GDPR in the UK. So since Brexit, there's obviously the EU no longer has laws that apply to the UK. However, the UK has implemented its own versions of these laws, including most recently some new standard data transfer agreements. So you can see this trend is continuing. There's these new addendums and agreements came into effect the 21st of March. They are a little bit simpler than the EU standard contractual clauses, and they're designed to be able to addend onto the EU SECs so that there's not quite as much effort involved in implementing those. And the ICO, the Information Commissioner's Office in the UK, has offered a lot of guidance and provided some good templates for that too. But again, it's a lot of additional labor. Canada has not wanted to be left behind, so there's been some additional activity there, and there's more than this, but just to highlight one of the areas of change, Bill 64 begins to take effect in September this year, with some of the key provisions taking effect next September. But similar to GDPR, one of the most kind of surprising things is the penalties can be extremely high with this new law. Typically around 4% is the maximum, and then in this case, with repeat offenders, the law would allow up to 8% of global turnover to be issued as a penalty, or $50 million, whichever is the greater of the two. And then it also brings in some unique cybersecurity incident requirements. So if there's a data breach, as we kind of commonly think of it, there's no longer in this law an idea of sort of evaluating the risk before considering it an event that needs to be registered and logged. They will consider a confidentiality incident to be the point where you start to document and treat it as a potential breach. And of course, they also have cross-border data transfer obligations that are being implemented with these impact assessments as well. China, I'll just briefly mention this one, but they've had this law in place since November last year and in effect, and some of the requirements are familiar, similar kind of penalty levels to GDPR, and coming soon, there will be some standard contractual clauses for China as well. So that kind of wraps up the OUS update. Cybersecurity is just, and this is not the FDA cybersecurity discussion. Bryn will handle that. This is data security within the US and abroad, and some of the recent developments on that front. Every federal agency seems to be interested in some respect in regulating or getting involved in cybersecurity. The SEC recently issued a proposed rulemaking on the topic, looking at trying to ensure that boards and really publicly traded companies, of course, are properly reporting and having transparency around their cybersecurity situations, and including the right kind of disclosures at the board level. So that's kind of in process right now with this proposed rulemaking. The FTC has for a long time been kind of a primary regulator for cybersecurity and privacy in the US. That's not changed. They still are in the midst of this, and what sort of the FTC has done is take a bit of a watchdog role in prosecuting companies that under the unfair and deceptive trade practices standard. So if any sort of data security it fails in a sense, it's not reasonable, or some other issues, data breaches, the FTC is interested in identifying those and determining, is this an unfair trade practice because it was the security wasn't reasonable, or was it a deceptive trade practice because the privacy policy said this and they actually did that, or the consent form said this and they actually did that. So that's the basis for a lot of the FTC actions here. One thing to note too that I think is especially relevant for this audience, the FTC has this health breach notification rule, and the focus of that is really these kind of in between applications, mobile applications and so on, that don't have covered entity status, so they're not subject to HIPAA, so no one's necessarily regulating the privacy of that information directly, at least at the federal level, so the FTC has stepped in and made some rules around that, and that's what this is about. All right, one more on this front. The False Claims Act has recently been brought into effect, kind of brought to bear against cybersecurity failures by government contractors. Kind of an interesting case, but there was a first case in this initiative that focused on a company that was providing EHR, an electronic health record, to the department, the State Department, and in the process they assured them contractually this is a secure platform, all the data that we gather is going to be secure, but allegedly not all of the data was secured, and so they were prosecuted based on a claim that they made a submission to the State Department that was allegedly false, and that is based on the False Claims Act, which we all know goes back to kind of Civil War times and has been used in the healthcare industry and so on to prosecute fraud. So question for all of the audience, who here is seeing requests about cybersecurity, whether it's from boards, from diligence, or from customers? Who's seen a lot of that?
Give the poll a few moments online.
Yeah, that's okay. Yes, typically I feel like cybersecurity is almost in some ways just, it's still growing, even though it seems like we've hit critical mass and everyone knows this is a big deal. We keep seeing more and more rigor around the questions that get asked on this.
80% online say yes.
Okay. Yeah, that doesn't surprise me. I'd be shocked if not everyone at some point, every business starts to see something about this that they need to answer to. So let's wrap up with an enforcement update. I'll touch on just a few things. OUS, unlike our favorite Sesame Street character, the French DPA doesn't care for cookies. So we've seen a lot of enforcement on cookie consent types of issues in the EU, and most recently this cookie legislation in France led to about 210 million euros in fines levied just within the 9 months that this law was in effect last year. The Austrian and French DPAs both determined that two website operators, kind of separately, but two different website operators' use of Google Analytics was not compliant because, in their view, Google Analytics collects personal data and then it transfers it to Google's kind of servers in the US, and that is considered a data transfer. So kind of we're right back where we started. This is a data transfer issue, and that's part of the concern here. Yet to see what kind of fines might be issued under that, or if we'll continue to see other regulators hop on board. But I understand Google is trying to fix this issue or find a way to offer their product that won't cause these problems. The CCPA, some enforcement action there. About 2/3 of the enforcement there so far has been on privacy policies, or kind of these public-facing things that the company website might include. So pretty low-hanging fruit, and that's been the focus so far. You can go to the California AG's website and look at some of the examples. HIPAA, not a lot of enforcement on sort of data breaches or these bigger entities, but we've seen this right of access initiative, which is targeting individuals who request access to their PHI, targeting sort of providers that haven't been responsive to those requests and enforcing against that. So we've seen 1.6 million in settlements and fines, penalties, and sometimes these are such small incidents that it's maybe one individual patient who complains that I didn't get access to my information, and that leads to one of these settlements. So key takeaways, privacy is continuing to grow. We see a lot of enforcement and regulation ramping up right now. Privacy programs can help reduce those risks, though. As the law changes, the program can adapt and cover some of these common threads that we see in privacy law. Good news in the US, we have a lot of state privacy law momentum around excluding PHI, so covered entities and BAAs can have a little bit of reprieve from that. And then public-facing activities tend to lead to enforcement. So a lot of the enforcement we see tends to be cookie consent or your privacy policy or responding to data subject requests, these things that are very visible. So those are ways to reduce risk, is to look at what is our more public footprint. No comprehensive federal privacy law yet. We kind of hoped or thought maybe next year. And so far, it doesn't look like there's anything likely to come through. I do think we can see some trends that might inform that future privacy law when it does happen, but it might be a few years down the road yet. And of course, cybersecurity, big emphasis. We see constant activity on that front, both regulatory and in terms of data breaches, ransomware. All of these things continue to be a significant topic. So that about wraps it up. Any questions? Perfect. Brandon, I guess I'll hand it over to you for the FDA cybersecurity update. Oh, we have a question.
Thank you. That was great. When it comes to the California law and the other ones, kind of two questions. One is sometimes health information is run in like an AI machine learning model, and so that becomes the product. And so in these laws, I'm assuming that you'd have to somehow retroactively remove that patient's data, rerun the model. That may potentially affect the end product, depending on how many patients request their data to be removed. Is that what these laws are requiring?
So generally speaking, what sort of is interesting is the law applies to the processing of personal data. So during the phase where you are processing certain data, that's subject to the law. If you get to a point where the data is no longer relevant to what you're doing with that, you probably can move forward and use the product. But we have seen instances where, and I didn't put it in this deck, but there's a recent enforcement case where a company was forced to lose some of their product that they developed through an unlawful, I think they used children's consent in that case, but there was an unlawful use of data that led to kind of an output. and that output was then required to be destroyed as well. So there can be some implications there, but it's the use of the personal information that's regulated by the law.
Okay. Yep. And then the laws, do those, let's see, what's the best way to put it? Like if the customer gives consent to use their data in any way we or the company needs, do these laws overcome that, or is that signed consent agreement the one that's more binding?
Yeah, so I think the key thing is most of these laws, and all of them, to the extent a patient consent is obtained, are going to allow you to do things as long as that consent was obtained properly and has the right kind of elements to meet the standards of the law. For example, a big topic in the EU right now is if I get consent, but I've sort of designed my cookie consent in a way that makes it so easy to say yes that no becomes a really awkward and difficult thing to provide, is that really consent? And that's the kind of question that many of these laws are starting to address. So as long as that consent is collected appropriately, generally that will help. Yep. All right. Do you have one of these?
And I apologize, I did not have instructions on this ahead of time. So just a little bit of my bio. I started my career in design assurance at Boston Scientific. And then from there, I worked in various engineering roles and kind of touched all aspects of quality going forward. I started at Gardner Law about 2 years ago. And that's been really great, kind of working from the other side of things. Kind of once I was on the inside, now I'm on the outside a little bit. So I kind of have both viewpoints covered there. So, what is? Okay, that's the wrong one. Which button? It's giving me a laser pointer. The big giant green button. Got it. So this was actually probably a well-designed device that I maybe, it's a little bit of a user error here, but yes. Okay, so the agenda, and I will try to go quickly through these slides because I know we're a little bit behind on time still. So there's going to be just a quick background on cybersecurity. There was a new draft guidance that came out that I have highlighted there in the next piece. So I have this other in the news segment, which I said, but it's really only one slide. It's very brief. There's a lot you could cover with cybersecurity. This is just skimming the surface. Changes then from the 2018 draft guidance and kind of highlights of that 2022 draft guidance that have just come out from the FDA regarding cybersecurity. And so this is sort of a quote that the FDA had as far as their why they decided that they needed to release another draft guidance beyond what they had in that 2018 draft guidance regarding cybersecurity, which is just that we're seeing more threats, we're seeing bigger threats. It's becoming critical that we address cybersecurity, and like Paul mentioned, it's kind of a big topic around this industry and others as well. So there's been a lot of incidents over the years. And they're getting worse. So this is something that really needs to get driven home as far as something that we need to try to protect ourselves against. So cybersecurity incidents, and this is sort of kind of stating the obvious, but they can render medical devices and hospital networks inoperable. They might disrupt the delivery of patient care. There was an example that I don't have covered in this slide deck recently where a hospital basically was shut down because of a cybersecurity incident. And in that case, there was a lot of patients that weren't able to get the care that they were scheduled for because of that threat. And that kind of goes with that third bullet where it can delay diagnosis, treatment, and it may also lead to patient harm. So there's kind of a couple things, and we'll talk about this a little bit later, but it's not just a patient harm thing, it's also just a data security thing in general. So cybersecurity kind of has two kind of main reasons that we're sort of driving home to get that implemented, at least in the medical device space. So this is the very brief kind of in the news segment. Starting kind of back in 2012, I think I have the date on there, maybe I covered it up, but yeah, August of 2012. That's sort of when the FDA kind of started this process of kind of considering cybersecurity more formally, releasing draft guidances, sort of doing that consideration on what they need to kind of focus on as far as for medical devices and ensuring that those things are secure. There's kind of a famous piece in the news, and there was also apparently, I don't watch the show, but this is everything that I've heard about this incident, where there was also an incident on the show Homeland where they were hacking into medical devices. And then there was the whole Dick Cheney, perhaps his defibrillator was going to get hacked, so that was actually modified. These were all, it kind of came straight from the movies and then became part of real life. And then I just have sort of an example there that's a little bit more recent of the FDA actually sharing a safety communication regarding cybersecurity. There's many, many more headlines I could have included in here. The FDA has issued additional safety communications, not additional ones, but the FDA continues to monitor this and relay safety communications and focuses on cybersecurity as we're going forward. So the draft guidance from 2022, which just sort of very high level here, this one focuses more on the total product life cycle. And there's not really any surprises here, I guess I would say, as far as what they've released in this new guidance. It's kind of continuing along the same path the FDA has gone on with other things such as risk management, product development, where they're focusing very much on the total product life cycle, continuing to monitor things, baking things into your product development cycle. That's sort of, the same sort of key things that they're pointing out in this 2022 draft guidance that came out. And then there are additional recommendations for pre-market submission content, but I just want to emphasize that it's not limited to the pre-market submission content. It's sort of, you kind of need to have that stuff on the as you're doing your product development, so that, like Amanda was mentioning in hers, that you're not getting to the point where you're saying, I'm ready to submit, and it says, and everybody says, well, where's your design controls? This kind of thing needs to get baked in, and that's where the 2022 draft guidance is a little bit more, it emphasizes that point a little bit more. So the major changes from the 2018 draft guidance, the change in title, and this is just, the FDA stated to better capture the scope. Really, though, this is more emphasizing that point that it's not just your pre-market submission. It is additionally stuff that's done on the front end as part of your product development, and stuff also that's done on the back end as part of post-market surveillance. So it needs to get put into your quality system and not necessarily just in your submission. So that's where that change in title comes in. Document structure change. This is, again, there's kind of the same way to say the same thing. They introduced a secure product framework, which is sort of just a different way to kind of consider cybersecurity as part of your product development process. Risk tiers have been removed. However, they did not eliminate the concept of risk from the guidance. They've removed the specific tiers, but they do still say if you're going to be putting in cybersecurity controls, we want you to put them in considering the risk of your device. So that's not, they're just, those specific tiers have been removed, but not the concept. The cybersecurity bill of materials has been replaced with a software bill of materials. So we'll go into that in a little bit more detail. Kind of the main takeaway there is just, it's a little bit easier for industry to meet this standard. But I have another slide that will kind of talk a little bit more about that. And then additional changes from the 2018 guidance. So this is, again, additional clarification regarding the submission document. So it's sort of in this in the 2022 guidance sprinkled throughout on what you should include as far as stuff in your submission, but that kind of falls along the same lines as everything else that I've kind of been repeating here, where it needs to be baked in. So if you kind of implement this kind of correctly, I guess I'll say, in your system, this should automatically happen for you, but that's just another way that the FDA is kind of emphasizing that point. Investigational device exemptions have been added into the scope. So again, going along with design controls in the product development process, those were always required for IDEs. The FDA is just explicitly saying that you also need to consider cybersecurity as part of that. And then again, the total product lifecycle approach. So, once you've done the submission, once your product's on the market, you don't just get to forget about cybersecurity. You need to continually monitor it, and you need to make changes based on kind of the data that you're seeing there. And then also it aligns with a May 2021 executive order on improving the nation's cybersecurity. And we'll touch on that a little bit more. That's mostly just the aligning of the language for the cybersecurity bill of materials versus the software bill of materials. Okay, so the secure product development framework. So this is, as part of the 2022 guidance, this is sort of the high level, top level way that they want you to show that you're meeting those QSR requirements for the quality system regulation. And again, this is a set of processes to kind of help you get there. So this includes more than just product, it includes product development, but kind of all aspects that might touch product development. So kind of your requirements management, risk management, even usability, that kind of thing. So those are all part of this secure product development framework thought process. It's just got an added layer of now you also need to consider cybersecurity as part of this. So risk management, I will try not to go into this in too much detail. There is a kind of focus more in this 2022 guidance versus the 2018 draft guidance that came out on what they call threat modeling for risk management. They do emphasize in this new guidance that you are you're still following some of the concepts that are in 14971 if you're familiar with the risk management standard, but the cybersecurity risk management is specific to what they say is looking for, where was my note here? I guess I didn't write it down, but so the 14971 is looking more at kind of patient safety. There are potential cybersecurity concerns that might be even in conflict with the patient safety. So it's not like you can just take your 14971 risk management process and just say that you're done, you have that done, cybersecurity's completed. There's a whole sort of other risk management process specifically geared towards cybersecurity concerns, which can include things like business risk, which you normally wouldn't include in a normal, I call it a normal, I guess, 14971 risk management process. So that doesn't mean that you can't use both together, but they do have some things where there's going to be some differences that the FDA is going to expect that you've covered as part of your submission and also as part of your product development process. The FDA had provided some funding to come out with this playbook for threat modeling. That came out in November 2021. Now that's like 100-page, I think it's 91 pages, specifically geared towards just threat modeling and things that you can do to make sure that all of your cybersecurity risks are considered and that they're controlled appropriately. So there's a lot more detail than what you would normally include as just part of your risk management process per 14971. So it'll be important kind of going forward to make sure that kind of the concepts in that playbook are incorporated into the products or the company's quality system as well as into their products DHFs. So cybersecurity bill of materials versus the software bill of materials. What's kind of been said about this is it's not letting kind of perfect be the enemy of good here. A cybersecurity bill of materials is certainly more thorough. It includes software and hardware, but the software bill of materials is in alignment with that executive order, and it's a little bit easier for manufacturers to meet. So we'd rather have everybody at least get that far than think that this is such a huge burden that they're not meeting it at all. So that's kind of where that big change in this draft guidance came into play. Oh, I guess I should point out, I have it on the bullet, but most vulnerabilities will be software related anyways, so you are catching most of the things as part of that software bill of materials that you would likely need to see. So. And then, so cybersecurity for pre-market submissions. So the FDA has, like I've mentioned, they have mentioned throughout the 2022 draft guidance that this is not just a pre-market submission, check the box type activity. It's what they've said is it needs to be built in and not bolted on. So this needs to be considered kind of at product conception. These 5 things that I have here in the bullet, those you may even consider kind of including way up front in your product development process as sort of you're collecting voices before you even develop requirements for your product. So that's where the FDA is going to look specifically that those are met. If you have them kind of initially conceived as part of your product development process, it will be a lot easier once you get to your pre-market submission to make sure that you're able to say, yes, we have considered these, and this is where they are. So those specific 5 items will be reviewed by the FDA as part of the product submission. And then kind of the last slide here is just the other pre-market submissions, that stuff that the FDA is going to look for. So I mentioned earlier that those risk tiers were removed, but the FDA is still expecting that you are going to provide information that is with the appropriate level based on the risk of the device. So if you have a really low risk device, not for patient safety necessarily, but a low risk cybersecurity device, that's where you won't have maybe as much cybersecurity information in your design history file. But if you have a really complicated device that has lots of vulnerabilities, that's where you're going to have to make sure that you submit all that to the FDA so that they can do a full review of kind of the entire cybersecurity risk. And then basically just driving the last point home, that they're going to look at your cybersecurity as part of your substantial equivalence. So if you have a device that's similar to another one, that's going to be a big part of the submission too, is just to make that comparison to show that your cybersecurity risk is now not just necessarily a safe and effective kind of comparison that you would normally be doing. So that is all I had. There's probably a lot more we could talk about. Yeah, go ahead.
Is it fair to say that risk from cybersecurity will not always mirror risk of classification of the device? So like a class 3 may be high, but also a class 1 could be high depending on what it does?
Potentially. So the FDA they touch on that. They don't directly talk about that in the draft guidance, but they do touch on that a little bit, saying that kind of how you're supposed to assess that cybersecurity risk level. So it's not necessarily based on patient risk. Like I said, it's going to be if you have like literally a brick that can't touch anything, at all, that's going to be a low risk for cybersecurity type aspect. But that doesn't necessarily mean it's a low risk device, because there's a different set of criteria that they're looking at.
Yeah, thanks.
I haven't had a chance to look into this yet because I don't have a client with a pre-sub for the moment, or not a pre-sub, sub. In the new guidance, are they consistent in saying then if you're making updates to your software as a medical device and you're just updating it to increase cybersecurity, you wouldn't have to resubmit?
They don't touch on that specifically.
In this guidance?
No. Yeah, you would have to kind of go through the normal kind of change
because if
process.
the change is only changes to software, if the change is only to increase cybersecurity, you don't have to submit again.
You may have to.
Okay.
Yeah, and they don't kind of go into that level of detail in the guidance, but it depends, I guess, on what the change would be. There's potential that you may have to resubmit because it is considered as part of that substantial equivalence. So.
Yeah, that's my question. I should have maybe specified that a little bit better because it's not going to necessarily be. It's going to be a judgment call.
Yeah. Yep.
Yeah. Okay.
I'm going to check online one last moment for questions. So next up, we have Theo, and we're going to do a quick computer switch while Theo gets set up. Theo's going to take us through complaint handling and MDR reporting. And so if something happens and you get logged off, just kind of log back on. We will have a computer up and running in about 20 seconds. Hopefully nothing will happen, but I just wanted to give everyone a warning.
We're all good? Okay, so I'm going to get started now. Again, my name is Theo Thompson. Good to be here. Nice to meet you all. Thanks for being here today and for staying with us. As you can see up on the screen is my bio. I'm not going to spend a whole lot of time on that because it's been up there for a while. And I'm going to talk about medical device reporting and complaint handling. Today I'll cover complaint handling, MDR reporting, some investigations, trendings, and then takeaways from an FDA warning letter. So we'll start with a real scenario based on real events. You work at a company named Hearts of Fire Pacemakers, and you're at a wedding reception in Wisconsin. You just finished the chicken dance with a new friend you met at the wedding who goes by the name of Millie. You sit down and Millie complains about some discomfort that she's having with her pacemaker. So based on this information, do you get Millie a spotted cow and explain that it may help with the discomfort she's experiencing? Do you take down Millie's information and let her know that you work at Hearts of Fire and are going to report this via the complaint handling process? Or do you start examining her pacemaker right then and there at the wedding reception? So any show of hands, who thinks it's A? Is A a good response? A? A is a preference. We got one taker for A. How many think it's B? B? Yep, B. And then finally, the last one, C. Would it be proper to start examining her pacemaker? No. Do we have the poll results?
Yeah, 94% said B.
Who? What was the other? One person said?
Yeah, it doesn't, it shows 0 for the other two. So
interesting.
Apparently.
Yes, the correct answer, of course, is B. And as I was reading through these, I was just thinking, too, A has two other issues with it, potential issues. One, it could be the unlicensed practice of medicine because you're getting her a spotted cow for her symptoms. And it also has some a promotion of off-label use of spotted cow. There's some implicit claim there that it could relieve her chest pain. So A, I don't know. It's a risky one. Okay. So this is what we're talking about, complaint handling. A manufacturer becomes aware when any employee has acquired information that reasonably suggests a reportable adverse event has happened. And of course, adverse events may result from a device failure, malfunction, improper or inadequate design of the device, could result in manufacturing errors, an error in labeling, or of course, user error. Everyone's favorite catch-all. Just some sources of complaints. Of course, it could come directly from physicians or the patients themselves who have the devices. It could come from literature, which includes scientific articles or just general mass media, such as newspapers. Social media, you need to track what people are talking about or saying on social media about your devices, because those could be sources of complaints. It could, of course, come from return product that you receive. And another thing to keep in mind is that complaints are international in scope. So the FDA wants you to report or at least consider complaints on devices that happen outside the US if it occurred on a similar device which you have clearance or approval for in the US. It could be the same or a similar device. All right, another scenario for you all. You may remember this fellow. You do your duty and report Millie's complaint to the Hearts of Fire's complaint handling group. The group investigates the complaint by reaching out to Millie's physician, who refers to himself as Dr. Slim Goodbody, FACP. The surgeon remembers this implant well, and he provides some information on it. He says that this was one of his first patients. His technique wasn't up to par at the time, and he wanted to use some crazy glue during the implant to really make sure that the pacemaker stayed in the pocket. He thought that was very important. He knows that it's been causing her problems for years, and he also recognizes the fact that she'll be coming in for a revision soon. So with that information, should Hearts of Fire now report the complaint, because FDA needs to know what is occurring in Dr. Goodbody's surgeries? Would they report the complaint as a user error? Or C, would they keep the complaint record but not report it to FDA as an adverse event? How many think it would be A? Any takers? Perhaps A. How about B? Would you report this as a user error? 1, 2, maybe. Or C, keep the complaint record but not report it to FDA as an adverse event. How many think it's C? Anyone? What did the online viewers say?
We got a few responses, and it looks like everyone there said A.
Everyone would report A. Interesting. A is actually the wrong answer. And it's wrong. Well, we can keep going for the sake of the presentation, but the FDA doesn't regulate the practice of medicine, and that's essentially what A is talking to. So some people might be concerned about that, and they are rightfully concerned, but it's not the FDA. Reporting it as a user error, we can discuss user error more. I wouldn't report this as a user error necessarily. I wouldn't jump there first. User errors, the FDA has a couple regulations one regulation that's specifically on point, and that's 803.20. Manufacturers do not have to report an adverse event if they have information which would lead a person who is qualified to make a decision on the matter that the device did not cause or contribute to the reportable event, or that it was not a malfunction which would cause or contribute to death or serious injury if it would recur. I think in this case, the way I kind of tried to draw the fact pattern, because the doctor admitted that it was due to, or he had used crazy glue, a person that reviews this, a medical person or person with medical knowledge might draw the conclusion that, well, the device isn't the cause of the pain here, it's likely crazy glue. Plus, at the time when he called Dr. Goodbody, he said he was planning a revision. He hadn't done a revision yet, so there hasn't been a serious injury associated with it. That's another thing to consider too. Also, the FDA guidance, 2016 guidance on device reporting speaks specifically to user error. So just the last bullet point is probably the most important. If you determine that an event is solely the result of user error with no other performance issue, and there has been no device-related death or serious injury, you are not required to submit the MDR. Something to keep in mind. And then, of course, I couldn't talk about adverse event reporting without talking about what constitutes a serious injury. Straight from the regulations, these are the elements. So to recap, in this case, I don't think it sounds like a serious injury has occurred. Now, the standard isn't whether or not the pain that she's experiencing is debilitating. I just threw that up there for shorthand, but at this rate, it doesn't look like there was a serious injury. There has been no revision performed yet, which we covered. And if there were a serious injury, there's a strong likelihood that it was due to Dr. Goodbody's practice, and therefore is not a user error, or excuse me, was a user error, but was not device related. All right, one more scenario. So Millie has her replacement procedure done, so now we have a revision surgery. And Dr. Goodbody does his job, and he sends the pacemaker back to HAP. They receive the pacemaker and conduct an investigation. However, they find that the pacemaker actually wasn't manufactured by Hearts of Fire, that it was competitors. So what should HAP's complaint handling group do now? Would you send the adverse event information to FDA with a cover letter stating that HAP did not manufacture the pacemaker? Would you do nothing because HAP didn't manufacture it? It's not their duty to do anything? Send it to Zips Pacemaker, the manufacturer of the device, so that they may investigate the complaint, or both, A and C. Well, what does the online poll say? Okay. How many think it would be A? B? Any takers? C? Or D? D. And online?
Online, we've got 9% for A. No one said B. About 73% for C, and 27% said A and C. So D.
A and C is actually the correct answer in this case. You have what now appears to be a reportable complaint because there's been a revision. The FDA there's a regulation on point in 803, which says that if you receive information, there's a little typo in this, but if you are a manufacturer or importer and you receive a complaint or have adverse event information, and you did not actually manufacture or import the device, but which you have that information, then you must forward this information to the FDA with a cover letter stating that you did not manufacture or import the device in question. So this regulation is somewhat tricky because it says, when am I not required to report? That's actually the heading from the regulation. But within it, it tells you when you need to report. You just don't need to submit a 3500A. You submit a cover letter. And there is no requirement that you return the device to the manufacturer in this case. I don't think that's in the regulations. However, it's very often done. So let's talk briefly about investigations. FDA requires manufacturers to submit information that is reasonably known to them resulting from an investigation. So if you have the device on hand and you investigate it, you've already submitted the report for the adverse event because the reporting timeline is 30 days. That means that you have to submit a follow-up report with the results of that investigation. If the investigation is inconclusive or there's no information, you do not have to send a follow-up report. Just make sure that you're putting that information in the event file so that it's documented. This is the regulation on point speaking to supplementary reports. So if you do have additional information or you've received not just information from the investigation, but through also conducting follow-up, don't forget you have to submit that information to the FDA. No, trending is a requirement of the regulations, but it's mentioned quite a bit in 803, but the requirement comes from 820, and it's written out at the top that you shall establish and maintain procedures for analyzing processes, complaints, return product, and other sources of quality data. So that's where the requirement for trending comes from in the regs. And speaking to malfunctions, of course, the malfunctions are somewhat specific. If you have a device or similar device that you market would cause or contribute to a serious injury, that may necessitate a report. And then, of course, a malfunction is the failure of a device to meet its performance specifications or otherwise perform as intended. The thing I want to highlight from this is that performance specifications include all claims made in the labeling of the device. So, of course, you want to limit your claims, your device advertising, to what's in the device labeling. But don't forget that there can be other claims which, through repetition, are sort of incorporated into the device claims that you need to consider. I don't know if you'd want to admit that you're off-label, but what I mean is if you're making claims in writing about the device, make sure that you're also considering those in your malfunctions and trending and tracking. So let's talk about some FDA warning letters now. There's one in particular from December of 2021. It was citing a manufacturer's trending and tracking of their serious adverse events and the risk severity. There were several takeaways from this. First one, the manufacturer was down classifying the risks that were associated with the device. The FDA saw that, and they didn't like it. The main point from the warning letter is that if you are down classifying, or even any classification that you put when trending device issues, make sure that it's well supported with a rationale and written procedures. Otherwise, the FDA may give you a warning letter. In this warning letter in particular, one of the issues the FDA spotted was that the manufacturer was using the total number of devices shipped as a way to calculate the overall risk posed by the device. They thought that that might downplay the risks, another source of, or another reason why the manufacturer was downplaying the risks, because it overcounted the amount of devices which were out there. So if you are sort of basing your risk calculation on those, the number of devices shipped, make sure you have a rationale for it. Perhaps this wouldn't be as big a deal if the manufacturer could show that there's high turnover of these devices, so they're not sitting. In other words, it's not overcounting the number of devices that are in the field and undercounting the ones that are implanted, that there's a good rationale for using that number in your risk calculation. Another thing that the risk letter stated, or the warning letter, excuse me, that stated, in this case, the company did an investigation, but forgot to put the information from that investigation. The investigation in this case was inconclusive, but they didn't put that information that the investigation was inconclusive back in the complaint file. And the FDA found that and said there's no information to conclude that in the complaint file that justifies the malfunction would not be likely to cause or contribute to death or serious injury in the future. The takeaway there, of course, is close the loop. Make sure that that information goes back into the complaint file. Otherwise, the FDA will conclude that an MDR should have been submitted and find you at fault for it. So thank you. Are there any questions from the floor or online? No online? We have one in person.
For terms of complaints, is a lack of efficacy or lack of function considered one as well?
Yeah, I think it would, because it's not performing as intended.
So then you mentioned publications. So if a competitor published our product worked better than their product and their product failed in these cases, are those all reportables then?
I mean, it would certainly require you to investigate and then determine, I mean, you have to kind of relate the specific device to a specific event. But I wouldn't just take their conclusion as whole and report on that, no.
Yeah, thanks.
Yep, you're welcome. Anything else? All right. Thank you very much.
Are we phoning Mark in?
Yep. Can you
Oh,
hear me?
you're here. Yay. Technology is
All right,
great when it works.
I'm excited to be back. It's been fun all day watching everybody present. I wish I were there in person. But as I talked about earlier, I met with someone on Monday that turned out to be exposed to COVID, and I found that out yesterday, late in the day. So decided it probably not a good look for a healthcare lawyer to be at
Spreading COVID at a CLE. Yeah.
Just got to be careful. So we're going to turn now, Chris, if you could get us on to the agendas. There we go. Some of you, before I get into the agenda, you might be wondering what UFTA means. And I think about, this next part of the presentation as UFTA. And I'll just read from Wikipedia what UFTA means. It's an exclamation or interjection. Well, actually, before I do that, let's poll the audience. What do you think UFTA means? And I think Tracy prepared a
quiz. Good.
Yeah, so I won't give that away.
What's the question?
What does UFTA mean? And the responses are, is it another word for sneezing?
Okay.
Is it a made-up Norwegian term, or I have no idea?
A, B. What do you guys think? I'm guessing most people know this. We're hearing B on the floor. What? C? Okay.
Polls closed at 85% think it's something Midwesterners say.
Yeah, yeah.
19% have no idea. And I don't know
Okay.
where the other, I don't know.
That's funny.
We have an extra 4% in the poll. I don't know where this is coming from, but.
Okay, well, bad math. UFTA means it's an exclamation or interjection used to express dismay, typically upon hearing bad news. Or of Norwegian origin, the phrase was brought by Scandinavian Americans, which we have a lot of in Minnesota, to the upper Midwest, New England, and Pacific Northwest regions of the United States during the 19th century. So UFTA, this next part of our program, you're gonna be saying UFTA. So we'll talk about trends. We'll talk about some AdvaMed updates, transparency reporting updates, recent cases, which will be the big UFTA part. Then Mallory, and then a bonus topic is responding to investigations. We're gonna try and go through this really fast.
Yeah, I was gonna say we can try to go as fast as we can. But yeah, you guys have slides too, so.
And Amanda, I don't know if you can advance the slides there. Or
Yep.
Chris, great. So before we start, Amanda and I were literally called the doom and gloom twins by another attorney on a conference call,
Yep.
I don't know, a month ago or so. It
Yep.
said that we reside in a black hole. And I
Yes.
had to pull that into the deck.
This is
here.
true.
So we are trying to remediate our reputations by balancing the information we share. So let's go to the next slide. Here's a picture of a puppy. How cute is it? It's not scary. So let's go to the next
Yes,
slide.
we want to start with good news. Cute things.
Good news, and then we're going to quickly depress. So these are the trends that we're seeing in the industry. I think everyone knows the off-label cases have been on decline, since Howard kind of rung their bells in his case, and that I feel like I think there has been a declination of cases, although there are still some around. But FDA is continued to lose on FDA First Amendment off-label cases. But we're seeing a definite uptick in the adulteration cases and misbranding cases. So FDA's bringing they're getting DOJ, and DOJ's involving other theories like adulteration, products made wrong, or the labeling's wrong. It's not truthful. It's false and misleading. We continue to see a ton of cases around anti-kickback, False Claims Act. So if you violate the anti-kickback statute, you automatically violate the False Claims Act too. That's written into law now. So free stuff to doctors, watch out for that. I know we have a lot of watchdogs, if you will, as part of the meeting here. A lot of the cases continue to be driven by whistleblowers. I had a friend who's a compliance officer at a very large healthcare company, and he was asking me, "Hey, did you hear about this this hedge fund that was put together to basically be a whistleblower hedge fund?" And so their aim is to just find whistleblowers and then help them bring suits against companies, and with the hope to make lots of money. So I was like, "Are you kidding me?"
Yeah.
And I'm sure he wasn't making it up. So just like one example that's pretty recent from 2020, a little less than 2 years ago, the whistleblower in that case stands to gain $110 million. So, not a bad day's work or year or two work. And then we're starting to see the Sunshine Act cases ramp up as well. So I'm going to hand it over to Amanda to talk a little bit more about this.
Yeah, my professor in law school who taught FDA law, Ralph Hall, I don't know if any of you know him, but he used to always say, like jokingly, that he wanted to retire and be a whistleblower. So I doubt he will, but it's a good payday. All right, so we'll talk quickly about AdvaMed. Some of you may have seen that they issued an updated and revised version that goes into effect on June 1st. They added quite a bit of content, but I'm going to focus on kind of the key updates. Alcohol is always a hot topic. So no, they did not ban alcohol like pharma did, so that's good news, I guess. But they did add an FAQ that more explicitly says that companies should add in controls and processes around alcohol at company events. So things like, 2 drinks maximum, or having like tickets, or restricting just to beer and wine, that kind of thing. So something to think about in your interactions with HCP policies. Virtual interactions was also added, which was good because look at us today. We're a great example of the virtual world that we live in now. So there's they've explicitly allowed for virtual interactions, and they called out some specific rules around meals, like no home delivery, but you can, deliver meals to like a clinic, for example, if you're doing kind of a company program or something like that. So if they're all together and the rep is not there. They also added quite a bit about value-based care arrangements. And so the safe harbor, the anti-kickback statute, safe harbors were added to address value-based arrangements, which really are widely not available to manufacturers. But they did want to kind of, as a nod to those safe harbor updates, they did incorporate some concepts. So these are kind of the three key updates. I would recommend, looking at your policies and seeing what needs to be updated or aligned to accommodate these updates. The Sunshine Act, so this has kind of quietly been in the background. When the proposed rule came out, it was kind of a hot topic because they had added a definition for physician-owned distributors, so PODs. So as many of you know, they kind of have a bad connotation with the DOJ, and they've issued some special fraud alerts about PODs. But they did, all of it passed into the final rule. So these changes are coming into effect. So it'll be calendar year 2023, and then reporting in 2024, March of 2024. So here's kind of the long list of key changes. There's actually more. So I would encourage you guys to go in and check out and make sure that your processes are going to be, set up and ready to comply for 2023 calendar year. Let's see, is there anything else interesting in there? Yeah, a lot of it's administrative, but there are some, like clarifying the exception. There's some clarifications. But yeah, nothing too earth-shattering, except if you are except if your company meets the definition of a pod, then you have to basically say that you're a pod, which it'll be interesting to see how that kind of shakes out with anti-kickback statute. Even though CMS explicitly said that this definition only applies for Sunshine, it's just kind of interesting to see. It'll be interesting to see how that plays out.
I was just going to comment too, Amanda. There's little tweaks in there, other little changes.
Yeah.
Rules around publications and short-term loans and things. I think one of the takeaways is that the Sunshine Act has continued to evolve over the years. So if you haven't, if you haven't looked at your policies and procedures since 2013, it'd be smart to go back and look at your definition of, who's a covered recipient.
Yeah, absolutely.
A few years ago, they pulled in certain types of nurses and whatnot.
Yep. And we, have to mention state transparency reporting as well, so just don't forget about it. Although it's interesting, with the expansion of the definition of covered recipient under the Federal Sunshine Act, we haven't heard a ton about how, a lot of the things that we probably would have previously reported to states are now going to be preempted because we're reporting them to federal. So I haven't seen a ton on that, but I think it'll just be a smaller pool of people you need to report on or entities. Like, for example, Massachusetts has a pretty broad range of covered entities or covered recipients. So just something to think about, and it's reporting season now. So June 1st is Nevada, then we have July coming up with Connecticut and Massachusetts, so.
Yeah, so just another quick comment. You see all the states at the bottom there, they all have rule. We counted them up for you yesterday, there's 26, so. Amanda made the comment, we should start talking about the states that don't have restrictions, but some of them are, obvious. We all know about Vermont, no meals to any HCP anywhere. But New York has the same rule, but it only applies to state employees. So I remember being on the lab 20 years ago and trying to buy a lab director a cup of coffee for 50 cents, and she said, I can't accept it. So knowing those little nuances are important. Tim also commented briefly before about federal gifts, and there's something called the 2050 rule, limits gifts that federal employees can receive to $20 per instance, up to $50 in aggregate per year. So a lot of companies just say no gifts to federal employees just to make it easy. And there's all kinds of other wacky, little nuances in all these other states. So just something to be mindful of. All right, I think I'm going to go, and Chris, if you can make the font black again on these, that would be awesome. I have notes in front of me, so if I look like Walter Cronkite, it's because I'm looking down notes. That joke probably is falls on deaf ears if you're younger than 45 years old. But so the first one is Medicrea. It's a French company, and I'm going to really go rapid fire through these because we want to get onto our panel. But essentially, this was a device company that was inviting consultants over to France, and they're kind of whining and dining them. Thank you, Chris. And bogus consulting arrangements. By the way, all these settlements I'm going to talk about, they're all alleged, right? So these folks all settled out, all these companies. But that was the first one. So the company was kind of taken off guard because they thought, hey, we're in France. Well, you also have the FCPA to worry about. But they ultimately settled under the AKS FCA because these were American physicians. But if they were bribing, foreign officials, it'd be an FCPA issue. So the Sunshine Act also wasn't followed. They didn't report this. They might have thought, hey, we're outside of the US, so it doesn't apply. That's wrong. Again, I'm just going to go rapid fire. The next one, Medical Designs v. Seekage. This is the steakhouse case, in case you heard about it. The physician owned steakhouse, and they just kept doing dinners at his steakhouse, Carnival Brazilian Steak Grill and Brazilian Grill in South Dakota, but it didn't get reported to Sunshine. Remember, that's an indirect payment. So since the physician owned the restaurant and ultimately the payments behoove the physician, those payments are indirect payments that should have been reported. They also settled under AKS, under the AKS, because they said, hey, you're using this restaurant to really drive business. Alliance Family and Companies, they were providing free services. They were interpreting test results for free. So, you're getting physician services ultimately. Government said that's a kickback. They should have been paying for that. This was also uncovered during diligence, and it was not stopped after diligence. So think of that if you, I probably don't have a ton of bankers on the phone, but or on the webinar here, but if you are strategic and you buy a company, you uncover something during diligence, you should stop it if it's violative and then determine whether or not you have to report as well. You might have to report that to the federal government. Lastly, last point on here is just that the White House has a memo on anti-corruption out, and that was put in place shortly after it was in 2021, but the administration, it's on their radar. Turning then to the next, again, continuing the rapid fire. Merit Medical this case was really all about practice building. So that's, helping your customers get more patients. The government views free ads, free marketing, free practice development as a valuable thing that companies are provided for free. If they're doing that for free, then, that's a kickback issue. So they entered an $18 million FCA, False Claims Act settlement, because like I said before, if you violate the anti-kickback statute, you violate the False Claims Act. And they're also in the CIA, that's Corporate Integrity Agreement, extremely disruptive and expensive. They last usually 5 years. And it means that someone's going to come in, an IRO, and audit you every year to assess your compliance for 5 years. Let's see. Oh, they also ostensibly said that the payments were education. So keep an eye on your marketers. They may try and say, hey, this is education. Well, if it's a valuable thing, then the government's going to think otherwise. And I'll pick on marketers because I worked in product management at a couple different companies before starting to practice law many years ago. The next one, Gilead, this is around a copay, so I won't get too much into the facts on this, but $100 million settlement. And the government said, you set up a copay / foundation, or a foundation that covered copays. And you're really, you're ostensibly, again, saying this was to really help the indigent and whatnot who can't afford your drug. But it turns out that everybody that got assistance from the foundation ended up getting on your drug. A lot of times companies like to set these up because they don't want physicians to say, hey, I'd prescribe your drug, but I can't get it covered. And then the patients come back and complain to me. So companies will say, well, we'll just set up a foundation and that'll cover the drug. And then we'll get the insurance companies to cover that to cover the drug as well. And for those that don't, we'll just send them to the foundation. So the government's been all over those types of programs. There is a lawful way to do them, but you need to be careful, and it can't just be designed as a conduit to get your product to people to cover the cost of the product when they can't pay for it. It should include other types of, other options, and you can't tell the foundation what to do. Novartis, this is a pretty famous case. Probably a lot of you are aware of it. And this was really the driver. I think this was kind of the straw that broke the camel's back and wound up creating the special fraud alert from the OIG on speaker programs. And this has, the complaint had all the typical stuff: going to Hooters, fishing trips, top shelf alcohol, no controls. The government loves to find out when somebody buys a bottle of cake bread or whatever it is that, Silver Oak, something real expensive, and just whining and dining doctors. That's what this case was. At $275 million settlement. They also said that you're just paying speakers to come to your social events and drink wine, and there's no legitimate activity at these events. Many times they're saying you're doing them for one person and you're not even talking about the drug. So government clamped down. Think of how disruptive this would be to your business. Under their agreement, their settlement agreement with the government, they can only do virtual meetings, no in person. They can only do them for 18 months after the approval, FDA approval. The maximum amount they can do on a drug is $100,000, which we all know is nothing for promoting a drug. And it's $10,000 for speakers. So they essentially shut down their speaker program. Let's go to the next slide. Okay, I know this is where the doom and gloom comes in, Amanda. This is why we are referred to as doom and gloom. So we'll talk about Pacira, and a few more cases here. I have so many. I'll have to start going even faster.
Yeah.
Pacira involved a pharmacist that blew the whistle, and he said, "Hey, we're being offered these grants, and there's no milestones for the grants. It's bogus. So make sure that if you do have a grant program, that it's legitimate and that it's actually the grants are for a good reason. They're being provided for a real reason." Mallinckrodt, this one's also a similar copay type arrangement where the government took issue. The compliance officer, who got any compliance officers out there? The compliance officer blew the whistle. So they're gonna, if they can extract money from Mallinckrodt, it's now bankrupt, but they'll see a big payday. DUSA, Sun Pharma, this was actually one of the off-label cases recently, and they were promoting allegedly off-label during speaker programs, promoting a contraindication. So paid a $21 million settlement there. A few more, and we will, actually I have so many more. I'll have to keep going. I think the point here, I could summarize this entire slide actually. As I mentioned earlier, the FDA cases are ramping up. So it's no longer just your, sales and marketing people that you have to worry about bribing doctors. It's actually if your QMS is messed up because you're mislabeling products and misbranding them, or you're not making them product properly, or you're not disclosing complaints in a way that the government likes, you may be facing a False Claims Act case. And we are seeing these in the background ramping up. We're involved in one federal case but obviously we can't get any of that, but we are seeing these cases coming up. I'm hearing from people, gee, FDA is just camping out here. What's going on? Are you seeing this? They're asking for a lot of quality information. Well, there's a decent shot that someone's blowing the whistle and saying that the product's being made wrong. So more good news for industry that there's even more scrutiny on it. The last one there is also another off-label case. Let's go to the next slide. Privacy ramping up. Maybe in Paul's next program, they'll call him, we'll have to come up with another name, doom, gloom, and
exactly.
But we're starting to see the privacy cases come up. You're just seeing crazy laws on point where governments are saying we're going to take 8% of your gross revenue if you to fine you. It's just like bizarre. But Europe especially is just, really over the edge with the fining and getting the attention of Silicon Valley especially. And the newest development is the cybersecurity. So the government came out and said, if your cybersecurity is poor and you're involved in the federal supply chain, then we may prosecute you for False Claims Act violations. Let's go to the next slide. I'll take this one, Amanda, and then pass it back to you to wrap up.
Sure.
The Mallory case, I'm not going to read from this slide. I'll just summarize it. If you are a company that has a contract sales force and you have 1099 agents that you are paying commissions to, you need to look at those arrangements, because there was a court case not so long ago, $114 million FCA judgment, where involved a whole bunch of other nasty conduct. But one of the big points coming out of it was the government said, you're basically not meeting any safe harbor. You've got these agents out there that you can't control, and they're not employees. And so we're going to prosecute you for under the kickback statute. So I know one of our polling questions we talked about, we have a polling question, I think, on this. If someone could ask that.
We also have a question in the chat here. Do medical companies involved in FCA cases settle and pay the fine in lieu of the potential of being banned from operating for 5 years? I thought something like this was mentioned earlier, or is that strictly doctors?
Yeah, absolutely. There are exclusion rules underneath under the laws, and there's a special law just for exclusion. So if you commit healthcare fraud, you can be excluded from industry. And so typically that is such a powerful weapon that the government has that they will say, like with Howard, hey, you promoted off-label here, and obviously that Howard won that case, Vascular Solutions won that case. But they say, if you don't settle, then we'll kick you out of the industry, we'll put you in jail, we'll do whatever. And so that's the weapon. So the answer to that question is yes, that companies are forced really with their arm behind their back to go into these settlements. So who knows what would happen if a lot of these cases were really litigated. I suspect there would be some changes.
Yeah, and I'm guessing exclusion is probably part of the negotiation and the settlement as well, because you see sometimes certain people are excluded, or the company, or certain business units within, so I'm sure that's a point of negotiation as well.
So, yeah, Paul, polling question. Do we have a polling question?
I don't think we do.
Okay.
Nope.
All right. Well, I'll make one other point on Mallory. There's ways to actually remunerate contract sales reps. You just need to be smart with it. Ideas on how you could do that. I bolded that. Think about, like, you can't, if you're not paying them a commission based on the value or volume of the referrals or purchases ultimately made, then what other things could you do? Have key performance indicators, MBOs, management by objectives. So map out your territory, and then we'll pay you this much money. Call on this many physicians, and we'll pay you this much money. If you get asked to come back and do a second presentation, this much money. If you ultimately do an in-service, this much money. So, there's ways that you can pay those contractors for legitimate activities that are not based on the value or volume of referrals. So think about that. And that's what a lot of our clients ended up doing. They just restructure those commission arrangements. And there is an advisory opinion out there, 9933, which actually blessed a commission arrangement. But Mallory just had a lot of other facts involved that, the government, just because there's an advisory opinion out there on something doesn't mean it's like a safe harbor. So whenever you're looking at any fraud, you got to really study those safe harbors. Over to you, Amanda.
All right. So on the topic of enforcement trends, we wanted to just have a bonus topic here, just kind of some things to think about when you're faced with responding to an FDA enforcement action, and enforcement action is used very broadly here. But just remember earlier, Tim had talked about TLAST, so just remembering, that applies in a lot of situations. Because lying to a federal agent is prison. It's up to 5 years in prison. So tell the truth, listen, answer the question, stop talking, tell the truth. Appreciate the nature of the inquiry or action, so kind of depending on what type of inquiry it is, acknowledging and appreciating the level of attention needed. Is it an all hands on deck thing? Is it just quality? Is it regulatory? Is it legal? Do you need to call your insurance company? Like just trying to scope out who it is and then, giving the situation the attention that it deserves. Consider whether you're under investigation and by whom. So that's important. Sometimes you'll get a call or a visit from an inspector or an investigator or an auditor, and you just want to make sure that you're clear on who you're working with, who's on the other end of the line. It could be a very different scenario if it's the FDA or if it's the FBI or the DOJ. So just kind of asking questions and really understanding who you're working with and truly whether you are under investigation or if it's just a line of inquiry that they have maybe related to another investigation. Know when to call your lawyer. Will a regulatory attorney help? Do you need to call a white-collar crime defense attorney? It all depends on the scenario and the kind of questions they're asking.
I will say there too, quick, we're not that lawyer.
No, we're not white-collar crime, no.
We have lots of friends in that place, but hopefully we never have to have that conversation with you. But it has happened many times, more than once with clients. But anyways, keep going, Amanda.
Yep, just remember to preserve documents or at least follow your retention periods. Don't go on a shredding rampage. That will not do you any favors. Remain calm, resist the urge to be defensive. The tone is important. You want to have kind of a collaborative, not necessarily friendly, but at least being able to have a cordial conversation and being collaborative. Consider remediation. So if there were, issues or errors or anything uncovered or that you've uncovered through the FDA action, get the fixes in place, show progress, don't overcommit to the agency. I know it's tempting if you get, 483 or a warning letter and you say, yes, we'll have this all done in a month. And then, you go away and you're like, wow, this is going to take like 3 years. So just kind of thinking through those topics is important. Don't get too overexcited. You may detect new issues when you're remediating. That's okay. Address those. And be transparent with FDA if there are ongoing communications, and you can keep them in the loop on what you're finding and what your remediation plans look like. Don't send FDA documents that will create new issues. So again, if you detect an issue, you don't need to kind of send them, a bunch of other documents that they're going to have more questions on. So again, responding to what they're asking, but then stop in the T-last. Consider whether reporting is required. So do you need to report to the FDA, SEC, OIG, calling your insurance carrier? Do you have government contracts you need to look at? Kind of thinking through all the different communications that you may have to make depending on the nature of the inquiry. Do you need to conduct an internal investigation? So, companies should have an internal investigations policy. Do you need to, does the enforcement activity constitute a trigger to initiate an internal investigation? Do you have an internal communication plan? If there's, something comes up, is there a crisis communication plan in place or something along those lines? Making sure that you're following up with FDA on next steps. So again, don't overcommit, but you want to lay out your plans and be transparent with them, and then, they will provide feedback if they disagree. Do not sign anything without legal consult. So yeah, if you get, something that some official is asking you to sign, politely say that you need to have counsel review it before signing.
I'll make one other comment there, man. I know we have FDA there, but we could also insert regulator.
Yeah. Yep.
OIG, DOJ. DOJ is the law enforcement agency. It could be OCR.
Yep.
The other comment is sometimes we'll get pushback from clients, maybe some of the more uninitiated, where they're like, "Well, we don't want to do an investigation because it looks like we did something wrong."
Yeah.
Well, actually, we conduct these all the time for clients. We'll do an investigation under attorney-client privilege. So that means we would work with the general counsel, for example, if there is one at the company, And that report is private. You know, we don't, you have to be really careful with who we share it with, but ultimately that's our business. We don't have to share that. But sometimes we'll write those reports with the anticipation that we're going to need to share it with a regulator, so that if they uncover it later, maybe we get comfortable with this situation, we remediate it, we don't feel like reporting is necessary, but then a whistleblower brings it up later and we say, yeah, I remember that from 7 years ago. By the way, everybody will be gone by 7 years later, but you'll be at the company dealing with it.
Yeah.
And it should have a compliance folder. Then you open it up and it says, yeah, look, we hired, we actually looked at this and we got comfortable with it. And we'll show you a report. Sometimes we'll share it, we'll make a report knowing again that we're going to share it later, and it lays out our position. And that way the company appears responsible. Optics, they are important. Substance is just as important, but that can really help you down the road, because then it shows that you have a properly functioning compliance program.
Yeah, yep, exactly.
I think we have one more slide here, Amanda.
We do, and we just wanted to leave with a happy feeling on everybody so that we can remediate our reputation for being in a black hole. So here's some cute puppies. Two cute puppies.
We have one question from the chat here. Is it acceptable to pay internal sales reps on commission? If so, why?
So,
well, there's an employee safe harbor.
If they're employees,
so under that safe harbor, those you're allowed to pay employees basically commission. There's special rule on the kickback statute. If you meet it, then that's acceptable. So that's a great question.
That it?
Amanda, if you have anything to add there.
Nope, that's what I was going to say. As long as they're employees and they are, bona fide employees and meet that safe harbor, should be good.
All right.
All right.
Any other questions?
Hey, Mark, can you hear me?
Yes, Mike. How's it going?
Good. How are you doing?
Excellent. Great to see your face.
Likewise. So I've got a question on that last point you brought up, a memo from, say, Gardner Law on a compliance topic. And let's say you want to create a memo that does become you're willing or you would want to share with an authority down the road. How do you manage privilege so as to avoid waiving privilege on all other communications relating to the topic?
Great question. I'll respond, then I'll go to Amanda, because she's conducted hundreds of investigations. She was compliance officer of a large multinational medtech company. But a lot of times we'll create two. So we'll have our own, their ACP protected report, attorney-client privilege report, and then the one that's the LTF, the letter to file, that we may produce later. That would be my response on that, Amanda.
Yeah, depending on the issue, sometimes we could, we would choose whether it makes sense to keep the entire investigation privileged, or if we do want the ability to share it. And I think having two can be a good situation, or a good strategy for that. I'm trying to think. I haven't had a situation come up where we later had to share it, but I'm imagining that you'd probably summarize it and share it, or have like a separate thing. Yeah, you wouldn't want to reshare and kind of try to, and potentially destroy privilege of the entire investigation. Does anyone else have ideas? It's a good question.
Sometimes we'll also work with, obviously the corporate counsel outside, or these. I once went to just to make sure that ACP is maintained, and I once went to a CLE. This is years ago, but I mean, I swear, from the podium, the expert on ACP basically spoke for an hour about how ACP gets shot up.
Yeah.
And it was kind of appalling. It's like, unless your email says exactly.
I know, it's,
this, that, and the other thing.
Like at the request of.
Right. Yeah. Use these magic words and maybe ACP will be recognized by the government. But
well, yeah, and it gets, a lot of us may have combined legal and compliance departments, and we do want to generate, the letter to file from within the department, but the same person who may or may not be a lawyer is generating correspondence that you do want to be either work product or, ACP. And so, if it were ultimately questioned, you have the same person on the same topic generating some stuff that is intended to be privileged and other communications that are not. Would that withstand that challenge?
It's a great question. And, not to bore you guys, but here at the firm, I mean, we have our own outside counsel that we go to and receive training on these different topics. And it's a bit of, it's a challenge. I feel like the ACP, you could do a whole CLE just on.
Yeah, no, absolutely.
It seems like, based on case law, it'll be like, well, this happened in Oregon, this was in Florida. It shifts all over the place. So
Yep.
I think some of the old tried and true points are to limit people that need to have the information. Sometimes on these reports, we'll even write, issue 1 of 3, have the person's name on it. Report number 2 of 3 goes to this person, and then right on the report in big block bolded text, it says, you can't forward this report without the GC's permission, and we just plaster it with ACP, work product doctrine, confidential, do not copy, do not distribute, etc. But, so limiting the audience to who needs to know. Sometimes we'll be involved in investigations and outside parties get involved too, or somebody's invited to a meeting that's a contractor. And we're like, well, hang on, do we need to have this person there? So, some of those old fundamentals that we all learned in law school or just on grandpa's knee I think it's wise to follow those. All right. Well, I think our time's up. If
Yes. Yep.
We'll turn it over to Jesse and get our panel going.
I think we are ready to get started. So what we'll do is I'll introduce quick while we've got this screen up our illustrious panel, and then I think we're going to switch a slide and we're going to have Mike Pisetsky join us virtually. So thanks for joining us. This is the last session for the day. It is a panel discussion with 3 general counsels that we are very lucky to have here or virtually here to speak with us. I'm going to introduce you guys very, very briefly. Oh, and there is Mike. Mike's coming from outer space, which is it's a real special treat for us. So thank you for joining us, Mike. So since Mike just popped up, I'll start with Mike. So Mike Pisetsky is an attorney whose background includes advising not only legal, regulatory, and compliance matters, but additionally an impressive background in financing and securities matters in the biotech space. Mike is currently SVP of Operations and Administration and Chief Legal Officer at SI Bone, where he oversees worldwide legal and compliance functions and advises the board of directors on legal and corporate governance matters. Sarah Karlgaard is also joining us. Sarah's an attorney with deep experience in healthcare, legal, regulatory, and compliance issues, technology, and privacy and security. She has experience at a large variety of healthcare companies, including Optum and Allina Health. Today, she holds the position of General Counsel of Canon Medical Systems Corporation, HIT division, where she leads the legal, compliance, and regulatory functions using her extensive experience. And Frank Piskulich, last but not least. Frank's an attorney who additionally has an engineering background, something I can tell you I commonly wish I had when I'm interacting with clients and their manufacturing changes to obscure subassemblies. Frank is a general counsel for Respicardia, Inc., a division of Zoll Medical. At Zoll Respicardia, Frank is responsible for legal, regulatory, and reimbursement issues associated with the distribution of implantable PMA devices. So, thank you all for joining us. We'll dive right in on an issue that we've touched on a little bit today, but I want to dig in on a favorite topic, physician remunerative relationships. So FDA, we've discussed a little bit today that FDA prosecutions and regulatory enforcement have scaled down a fair amount in the off-label space, but there's been a commensurate ramping up of focus on physician remunerative relationships. And that includes several of the high-profile DOJ and OIG cases that Amanda and Mark talked about. Mark referenced the special fraud alert on speaker programs. We've also simultaneously had the pandemic, which eliminated a lot of in-person programs. It may have included food and drink and other opportunities for physician perks. How do you see industry responding to these intertwined shifts? And do you see the decrease in in-person interaction as having, at least momentarily, de-risked industry? Or do you see that new risks are being created as manufacturer sales forces look for new ways to accommodate physicians? And Sarah, I'd love to hand it off to you. Yeah.
So I would say I can't project what industry as a whole is doing, but I am delighted to ride sort of the lower risk wave, right? So I am actively embracing the fact that virtual is so much more prevalent. I just think the risk goes way down. And I think there's been an acknowledgement with my entire organization from a business perspective that those interactions can be really effective virtually. And so I'm watching, but there's just inherently less risk if you're not in person. There's no meals involved. You can control the entire arrangement in the writing, which is beautiful. So that's what I'm seeing right now, and I'm still just watching it.
I would say I've seen a lot of the same as far as in the short term. We've gone to virtual. We do allow virtual meals under the AdvaMed guidance. We did that right away. But again, a virtual meal in a hospital is much different than an evening meal at a steakhouse, much lower risk. So seeing a lot of maybe benefit there. But with any disruption, you sort of see creativity and if you have a good system in place, you get a big disruption, you see a lot of creativity. That's a chance to raise your antenna and sort of look for compliance issues, other accommodations. So I think that's a good question, and we've seen efforts at some of that, not necessarily on meals, but in other ways.
Yeah, in time.
I will say I do watch a little bit for when it does become back to more in person. It feels a little bit like we're going to have to start over. Like it's from a compliance standpoint, just from the training standpoint, I think it's going to have to be a much more meaningful refresh with the sales force, because I think, memories are short and reminders have fallen in some ways because the risk has been so dramatically reduced. So I do think even just with sales team meetings coming back online, you're going to want to be really at the forefront of those and thinking about these things differently, because I do think we might get caught off guard that all of a sudden things are back and people don't realize that, and in fact, some things have changed with some of the guidance, the alcohol, the things like that. So I think there's going to have to be more of a push than you would just see if we would have been just kind of status quo with the last 2 years.
Yes, spring is in the air. I feel it myself when I get out again, right? The risk is there. If you're back again, you have a chance again, you're out in front of people again. I think we need to reinforce the issues, and the rules haven't changed.
Well, and the other thing is, with the so-called great resignation, right? I'm sure there's a fair amount of turnover within your teams that are interacting with physicians, and so it's been a long 2 years, and I think a lot of people either have forgotten or they may have come on to the organizations in a scenario when they didn't have to deal with these types of issues. Mike, it looks like you're back with us. Sorry about those glitches. Just wondering if you had any thoughts on this, the kind of decreased in-person interaction, and whether that's de-risked or whether or not you see new risks arising.
I think for a time it may have, de-risked us. I think we de-risked some of this. I think we fairly quickly figured out how to do the kind of virtual in-services. I think, I talked to counterparts at other organizations and, MDMA and AdvaMed and so forth. And I think the industry is still trying to figure out exactly how to react to the special fraud alert and what the stance on alcohol is. I could certainly see, as things get back in full swing, there's just pent-up demand for events. People want to interact more, and I think the point on turnover and retention is very well heard, right? We have a whole group of reps who have come in, or group of employees who have come into the organization. They've probably gone through at most kind of a virtual compliance training, and they just haven't. There's something about a culture that needs to get perpetuated, a sort of compliance culture that needs to get perpetuated through the sort of in-person interaction and coming to the meetings and interacting with the management team directly and so forth. And that's missing. So we'll have to rebuild that.
Yeah, the one last thing that I would add quick is that I'm hearing from clients is that some of these changes with pharma and with AdvaMed, that you're seeing changes that aren't impacting anybody right now, and so they're slow to update, whether they have SOPs that are on point, whether there are trainings. That is not top of mind. We all have more to do than we have time in the day, obviously, and so those things go to the bottom of the list, and so there may be some catch-up as we emerge from all of this as well. I think that might have to happen. So that segues potentially a little bit into the next question, which, as I have mentioned to all of you in speaking with you, you've certainly got your houses in perfect order, no issues whatsoever, but the same can't be said for all of your competitors. And one of the questions that we all hate to hear is, well, competitor X is doing Y, why can't we? I think that dovetails a little bit off the last question. And that may be in the advertising and promotion space, and maybe in some of the physician interaction items that we talked about. It may be in reimbursement and coding and the recommendations that they're giving to physicians on that. What sort of challenges do you see competitors creating, and how does it have the opportunity to impact your business? And what strategies would you recommend to manufacturers that are facing those same sorts of issues? Frank, would you mind giving us a start?
Yeah, when I get that other people are doing this, what can I do about it? There's sort of two responses. One is are they really doing something wrong, and is there some way I can align with the sales force to help meet their goals and suppress this unfair activity? So whether it's trade complaints, cease and desist letters, going to the compliance officer of the competitor and saying, hey, are you aware your people are doing this? Right. Uncool. That's an opportunity if it's that kind of thing. If it's a race to the bottom kind of issue where, maybe that competitors aren't really doing this, but this is the way they're trying to loosen our controls, I usually just ask, show me what they're doing, let's see it. I think I'm 100%. I've never seen people do things that we're not doing. If people consider me too conservative, that's just a slander. I mean, there's just no basis. That's an unbased slander, right? I mean, but I first try to see it as an opportunity to get on their side, understand, can we do it? Are they really doing it? Can we stop them if they shouldn't be? And then if it's neither of those, then try to understand it better. And it's an opportunity to educate why we aren't doing the thing they want to do.
Sarah?
Yeah, I think one of the things, I would agree, a very, very similar approach, but one of the things that's unique for us, so we develop medical imaging software, that's medical device, but in addition to the diagnostic medical devices, we have a lot of technology that isn't classified as medical devices. And the complexity for us is that in that space, many of the competitors don't then have medical devices. And so you go to these trade shows or you go to these industry shows and you've got the pure sort of non-healthcare technology companies that are completely unimpacted by the compliance regulations that we are. And so that's one of the things I get a lot is, XYZ company is giving away a car. Well, gosh,
you can't give
goodness gracious. So there's some interesting things. I was having a conversation with someone who's on the board of AdvaMed trying to talk about, is there some sort of hybrid model that should exist? Or instead, if technology players are going to play in the healthcare space, and I give this advice too, they might need to be careful because, sort of be careful what you wish for. If you fly too far in the face of medical device, regulations for the true medical device companies, you might find yourself, looped in with that. But it hasn't happened yet, and so that's just one of the things from a competitor standpoint that we run into and have a hard time trying to navigate, right? Because if it's apples to apples, we do exactly what Frank's describing. We can work through, we can, be nice, we can let them know politely, or we can be not so nice because it makes good sense. But when they're not subject to the same rules, it makes it harder, and my teams are more disappointed.
Yeah.
And Mike, I know in your space, competitors are all playing on the up and up, right? 24 hours a day, 7 days a week, right?
Nothing but goodness. Yeah, I mean, to pick up on Sarah's point, we have a slightly different version, but a similar problem. So our product is a medical device. We pioneered the device-based solution in this field, created the coding for the procedure, and then we now have close to 30 competitors who also offer devices, as well as a number of companies that are offering competitive products, but they're actually Section 361 HCTPs, or they consider themselves and treat themselves as HCTPs. And these companies, we've seen them just very aggressive, making sort of wild claims that we think ought to put them squarely within the device regulation. But I think there's some question at FDA as to whether or where these products belong, and I think some of these companies tend to fall through the cracks as well. They're smaller companies. So what I like to focus on with our commercial team is, look, we are the pioneer here. We've set the standard. We've developed all the evidence. We sell, an evidence-based product and solution, and we're going to be the kind of gold standard in the business, and not compare ourselves to those other companies. And I think some of that does resonate with surgeons. They'll tell us, SI-BONE has done things the right way, and there are other competitors that may play sort of fast and loose with the claims they're going to make, or they'll play fast and loose with the coding they recommend for their products. But it's a constant dialogue with the commercial organization, and explain to them that, look, if you're a small company, you may not be here next year. They're willing to take those risks, and they may not have been through some of the same things that a larger company with experienced kind of compliance counsel is aware of.
I think that's a really good point. I'll just add briefly, I mean, one of the things I try to work with our sales teams on is really trying to understand that the healthcare system, the healthcare providers are also subject to these regulations. So in some ways, leading with a compliance-first attitude really does give you competitive advantage, because while maybe in the moment the physician thinks he's being wined and dined, if that gets back to his compliance function, he's in trouble or she's in trouble. And so you really do have this thoughtfulness around, okay, yeah, maybe it might get you in the door for a half a second, but if you get past the door, right, and the behavior gets to the people who understand whether it is appropriate or not appropriate, you've maybe lost credibility where you felt like you were gaining. So I think that can be really beneficial just as you're, starting out with your sales team and trying to kind of build why this is important.
Yeah, and I think both of you highlight something that I would just reiterate, which is the first thing that we think of is how are we going to interact with the competitors, but how we interact with our own internal sales force is often just as important, because either one, you're highlighting for them, hey, you're our ears, let us know when these things are arising, but two, it's also you're marketing compliance to your marketing team very often.
And to Sarah's point, finding the right customers and, so that they reinforce your compliance message to the sales people. If we have customers that are asking to do a lot of, maybe they're not the right customers too.
Yeah.
Right.
Great, thank you. Oh, and in the chat, if anybody's willing to take Frank's slander case, please, please just put your information.
Cases.
In there. All right, so let's jump across the Atlantic here quick. So most of our focus today has been FDA law and regulation. You all work for companies with global distribution. So a particularly clamorous discussion, I spent a lot of time figuring out what word I was going to use to describe this, but clamorous works, is occurring in industry regarding EU transitions from AMDD and MDD to MDR. And so as certification deadlines are hitting for companies, what sorts of challenges have you all run into in the transition? And Sarah, I actually might start with you because I'm particularly interested in being a software company. I know that there are some unique challenges that arise in recertifications.
Yeah, I mean, I don't have any great guidance on how to do it perfectly other than to say early and often. It has been a significant process, and I'm hearing from all of my colleagues that that is the case across the board. This has been an enormous transition. The EU regulators and notified bodies just simply weren't ready for it. They're completely understaffed. There's no amount of gnashing of teeth and slamming on tables that will get them to move any faster. And so as a result, you are hoping for the best. You do everything that you can to plan, but even they're committed to deadlines they miss very frequently. There was a process under which, and our company worked really hard to recertify under the MDD, which is supposed to then allow you more cushion time to transition to MDR. But the complexity with that being a software company, which is I think what we're getting at, is that only allows you to play in the market so long as you don't make any significant change, which is a sort of amorphous definition, and it's very complicated. And in software, you are making changes all the time. And so even if you have a good rationale that it is not significant and it's appropriate, you are going through hoops and you are doing filings and you are documenting. I mean, it is an incredible impact. So I'm just acknowledging that. If you want to trade war stories, find me after for a cocktail, but it's a challenge, that's for darn sure.
And I can just echo the hopelessness, or not hopelessness, but
we thought doom and gloom was the last.
Doom and gloom
session.
Part 2 a little bit. I think back to 10 or 15 years ago, medical devices, the plan was get CE mark, commercialize in Europe, show you got some success, get FDA approval, and go on from. That's what we did with our first generation device. Our second generation device is FDA approved and not CE marked and not available in Europe, and it's because of MDR issues and the things we're talking about right now. Some of it is lack of notified body capacity. Some of it is they're not working as well with their competent authorities. That relationship has deteriorated because of the transition to MDR, so they're not working as well with us. So if you can find a way to help the notified body take some of the heat off of them with their competent authority, that's a strategy, but it's a bottleneck, and yeah, I guess that's it. I'll be there too. I'll be at the bar.
Well, Mike, sorry you can't be at the bar for war stories, but any thoughts on this topic?
Yeah, I mean, I would certainly echo what both Sarah and Frank said. Attack early and often. So that ship may have already sailed for the most part, but get in line with your notified body. I think the other thing is that it seems like the industry is still trying to figure out what is the evidence requirement mean. To get a device into Europe, what's the real level of evidence that's going to be required for different types of devices? And we're on the one hand working through it with, thinking through it with our new products, but then with our legacy products where we do have, we think we have evidence, but other competitors may not. Is there an opportunity to be one of the few that survive?
Yeah, that's great. So I'm going to ask one more question, and I think this one may be of interest to people because I think a lot of, especially general counsels and folks on leadership teams and companies are trying to figure out the answer to this. So we heard from Paul and Bryn earlier about emerging cybersecurity and privacy-related issues. And industry increasingly has alignment on best practices when it comes to cybersecurity, or certainly federal and state regulators and legislators are trying to tell us what the best practices are. But it's not universally agreed upon the ways in which organizations tackle cybersecurity questions or responsibilities. And so in some organizations, it'll fall primarily to IT. In other organizations, it's within legal or compliance. And I guess I just want to know, how have you guys thought through those decisions? And if you'd like to share how you've implemented some of the decisions that have come out of that. Mike, you haven't gotten a chance to go first yet, so I'd love to hear from you on this.
Well, so one, I mean, we don't think so much in terms of the the boundaries between silos. So we're small enough that our legal team works very closely with our IT team. A lot of where we're spending our energy, and there's certainly a lot of it right now in cybersecurity, is thinking about the right governance model. So what's the right cadence to report to the audit committee or to the board? What's the information that they need? Putting metrics beside it and dashboards, and then finally, external audit or assurance, whatever you want to call it. We have external consultants come in regularly and review our cybersecurity program, and it's a constant. I don't think you ever check the box, but it's constant maturing, and that's the trick.
Frank, how about you?
All right. Our legal and IT security work well together. I would say our IT security is maturing. We've put quite a bit of investment in that in the last couple of years, so I'd say that's maturing quickly and taking maybe some of the lead. I would pull in your risk management and your insurance groups as well, because your cybersecurity insurance is becoming ridiculously expensive, and it's amenable to modification. If you have the right certifications in place, you can bring those rates down. So we're able to find some money for IT security by revisiting our cybersecurity representations.
That's great.
Yeah, I think on our end, we have, again, as software as a medical device, there's cybersecurity and privacy within the development of the products, right? Making sure that the products are secure when they're deployed at a healthcare system. But then there's operational privacy and security, right? How do we manage, and again, we're a global company, so how do we manage employee data? How do we manage support case that might have PHI within it? How do we manage data we get through research? So there's that aspect of it, which is kind of day-to-day operation. And then what about the organizational aspects of privacy and security, right? Who sets the policy for incident response, for use and disclosure, for all of those things? So it's sort of this three-legged stool, between kind of operational privacy and security, kind of the traditional security officers, with our security professionals in our technology and engineering function, as well as compliance and legal. And so we, at this point have implemented, more or less a weekly interdisciplinary meeting where we kind of go through the issues, risk rank, try to tackle the ones that are cross-functional, and then disperse throughout the different functions, ones that you can kind of silo at some level. But you get a log4j type incident, and it really is cross-functional in that regard. And so I think, Mike, when you're talking about escalation points and things like that, it really does become more complex than you ever expected, because who's on point, which function is impacted more, and then who ultimately gets to make calls. It is not without its fun.
Well, that's great.
That's right. I would also echo the point about cyber insurance. So we've actually found that very useful. The premiums have gone up astronomically in the last year, but to use us as an example, we were able to get that renewal premium down this year by implementing specific technical safeguards that the carrier required of us. Essentially, they said, we'll write this, but you have 90 days to correct this issue, and we did. And now that carrier, they publish a quarter, or they don't publish it, but they provide us with a quarterly report where they use automated scanning software, and they identify vulnerabilities. And so each quarter we get that report and we go address those issues. So having the right cyber coverage for us has been a real asset.
Well, that's great. Thanks, guys. Well, with that, I know that we're well past time that today's session was supposed to go anyways. So I think we will conclude the CLE now, and with the exception of Mark back in the office and Mike back out west. We apologize to both of you that we can't send you a drink, and we wish you were here. But I think that the bar will, well, I guess I'll hand it over to Amanda.
Okay. Yeah, I was. I just was checking to see if there's questions, but I don't think there are. Any in the room? No? Okay.
Excellent.
Yeah, with that, we will not hold you from the bar any longer. Those of you at home, feel free to get your own cocktail. But thank you so much for joining us today. It was really fun to actually see people in person. And I'm sure hopefully everyone on the phone and online enjoyed the program as well. If you have any questions, we'll be hanging around. Feel free to reach out to us via email or give us a call. But yeah, thank you very much, and enjoy the rest of your afternoon and evening.
And a special thanks to Mike, Sarah, and Frank.
Special
Thank
thanks
you guys.
to our panel.
Appreciate it.
Yes.
Thank you.
Yes, thank you very much.
Take care, Mike.
Bye, Mike.
Thanks. Bye-bye.